Hi everyone. So today in this section we will be discussing about AKN's note on company law. So actually it's just not a discussion. I'm reading out loud his notes for people like me who would prefer reading, who doesn't get time to read it, who can hear it while doing summer or while traveling. You can hear it. So I'm reading out loud AKN's note on company law. So company law is one of the largest statute, and Law-AKN's introduction, most of you will be aware of him and his notes. He's an advocate, a senior advocate in High Court of Kerala. He has prepared study material for most of the law subjects with respect to Kerala University, and it is very useful for all the students. I can say that 80% of the students from my class do prefer AKN's note, and this is also one of that last minute go-to material for exam. So here in this company law, sir has discussed about 51 topics. If there is any interruption in the segment, I am sorry about it. I'm having a mild cold, so if any interruptions there in between, I'm sorry about it. Okay, let's start with it. The Companies Act 2013. So the first topic is introduction. The law relating to companies in India is now contained in the Companies Act 2013. One who traces the history of company law in India can see that the first enactment on the subject of company law was passed in 1850, known as Joint Stock Companies Act of 1850. Thereafter, several amendments were made to the Act of 1850, and after India became independent, the Government of India appointed in 1950 a committee of 12 members to make recommendations for the codification of company law in India. The chairman of the committee was Mr. H.C. Bhabha. The committee submitted a comprehensive report on all aspects of company law, and it resulted in the most comprehensive legislation, the Companies Act 1956. So, initially, there was Joint Stock Companies Act 1850, and later, after independence, there was a 12-member committee assigned for the codification of company laws in India, and the chairman of this committee was Mr. H.C. Bhabha. The committee submitted a comprehensive report on all aspects, and this came into being as Companies Act of 1956. The Companies Act of 1956 was a consolidation of existing laws, statutory rules, and certain principles laid down in decisions of the courts in India and England. The Act of 1956 substantially incorporated provisions of the English Companies Act of 1948. So most of our statutes were largely influenced by the colonial rule. So the Companies Act had provisions of the decisions from courts in India as well as England, and this was substantially incorporate provisions of the English Companies Act of 1948. In England, a new enactment, namely the Companies Act of 1985, came into force on 1/7/1985. So since we already had Companies Act of 1956, why was there necessity of Companies Act 2013? So why the new act? That is discussed, and that is the Companies Act of 1956 had been in force for about 45 years and had undergone several amendments. However, a need was felt to enact a new legislation to meet the changed national and international economic environment and to further accelerate the expansion and growth of Indian economy. So why there was a need for change? That was to meet the changed national and international economic environment and to further accelerate the expansion and growth of Indian economy. In order to achieve the desired object, the Companies Bill 2009 was introduced in the Parliament. Subsequent to its introduction, the central government received several suggestions for amendment in the bill. The Parliament Standing Committee on Finance also made numerous recommendations. In order to incorporate the recommendations of the Parliament Standing Committee, the Bill of 2009 required drastic amendments. Under such circumstances, the central government withdrew the Bill of 2009 and introduced the Companies Bill 2012 in the Parliament. The Companies Bill, having been passed by both the houses of the Parliament, received the assent of the President on 29th August 2013. It came on the statute book as the Companies Act 2013. So it got President assent on 29th August 2013. By Section 465 of the Companies Act 2013, the Companies Act 1956 was repealed. The Companies Act 1956 contained a total of 658 sections and 15 schedules. That is, Company Act 1956 contained a total of 658 sections and 15 schedules. The new Act of 2013 contains only 470 sections and 7 schedules. So, the Companies Act 1956 had 658 sections and 15 schedules, and the new Act, the Act of 2013, had only 470 sections and 7 schedules. Though the Act received the assent of the President of India on 29/8/2013, only Section 1 of the Act of 2013 came into force on 29/8/2013. So, only one section of the Act came into force when the President gave assent, and that is on 29/8/2013. The remaining sections were not brought into force on different dates. Some of the sections were brought into force on 12/9/2013. Some other sections into force on 1/4/2014 and on 6/6/2014. So only one section came into force when the President gave assent on 29/8/2013. The rest of the sections came into force in 3 different dates, that is 12/9/2013, 1/4/2014 and 6/6/2014. When did the President give assent? 29/8/2013. Only one section came into force on that day, and the rest on 12/9/2013, 1/4/2014 and 6/6/2014. The remaining sections were brought into force on 29/5/2015. So, though the Act got its assent on 29/8/2013, it took till May 29th of 2015 for the entire Act to be in force. So, it took 29th of 8 2013 it got assent. One section came into being, and 2 weeks later on 12/9/2013 some of the sections came into being. Then again few months later on April 1st of 2014 some of the sections came into being, and then again with a gap of 2 months in June 6th 2014 some other sections came into being, and with a long gap, that is after June 2014, the rest of the sections came into being on 29th May of 2015. So the dates 29/8/2013, 12/9/2013, 1/4/2014, 6/6/2014 and 29/5/2015. Now all the sections of the Act of 2013 have been brought into force. Now, this Companies Act of 2013 also had amendment. The Companies Amendment Act of 2015. the Indian government is actively working to improve the ease of doing business in India. Key initiatives in this respect can be seen from the amendments made to the Companies Act 2013 by Companies Amendment Act of 2015. The main object of the amendment is to make the company law more business or investor friendly. So, what was the objective of this amendment? Is to make the company law more business or investor friendly. The Companies Amendment Bill 2015 was passed in Lok Sabha on 17/12/2014, and then it was passed in Rajya Sabha on 13/5/2015. The Companies Amendment Bill got President's assent on 25/5/2015 and was published in the Official Gazette of India on 26/5/2015 as Companies Amendment Act 2015. All the sections except sections 13 and 14 of Companies Amendment Act 2015 have come into force with the effect from 29/5/2015. So except for sections 13 and 14, the rest of the all the other provisions came into effect from 29/5/2015 with respect to Companies Amendment Act of 2015. Now, the salient features of the Amendment Act. 1. The figure of minimum paid up capital was deleted. The figure of minimum paid up capital of rupees 1 lakh for private companies, that is discussed in section 2 subclause 68, and of rupees 5 lakh for public company, that is discussed in section 2 subclause 71, has been deleted. So the minimum paid up capital is 1 lakh rupees for private company and 5 lakh rupees for it was 5 lakh rupees for public company. So this figure of minimum paid up capital was deleted. It is left to the central government to prescribe the same from time to time. So a fixed amount was deleted and it was up to the central government to prescribe it from time to time. Thus, now a private company or a public company can be started without a minimum paid up share capital. 2. The requirement of common seal is made optional. So previously this was a mandatory condition. Now Companies Act 2013, a common seal was required for a company to provide various authorizations and attestation on behalf of the company. The requirement of common seal has now been made optional and the director's signature is acceptable in lieu of the common seal of the company. Third one, Section 11 of the Companies Act 2013 is omitted and the requirement of filing of documents with the registrar before commencing business is dispensed with. So, as per Section 11 of Companies Act 2013, a company having a share capital could not start any business or exercise any borrowing powers unless two conditions are met. First condition, a declaration is filed with the registrar by a director that every subscriber to the memorandum has paid the value of the shares agreed to be taken by him. And the second condition, the paid up capital of the company is not less than 5 lakh in case of public company and 1 lakh in the case of private company. So, as per Section 11 of Companies Act 2013, a company having a share capital could not start any business or exercise any borrowing powers unless these two conditions were met. So, this was omitted and taken away by this amendment of 2015. Further, the company had to file with the registrar a verification of its registered office before starting its business. As Section 11 is omitted, a company can start its business without filing the required declaration of director and the verification by the company. Now, the fourth one, stringent penalty for company inviting or accepting deposit. Now, the Companies Act 2013 was silent with respect to penalty or fine for companies inviting or accepting deposits from public without the approval of the regulatory authorities. The Companies Amendment Act of 2015 has introduced stringent penalty for directors of companies that invite or accept or renew deposits contravening to the Companies Act of 2013. Through the Companies Amendment Act of 2015, a new section 76A has been inserted to the Companies Act 2013 prescribing penalty for inviting or accepting or renewing public deposit. Section 76A Punishment for contravention of Section 73 or Section 76. Where a company accepts or invites or allows or causes any other person to accept or invite on its behalf any deposit in contravention of the manner or the conditions prescribed under Section 73 or Section 76 or rules made thereunder, or if a company fails to repay the deposit or part thereof or any interest due thereon within the time specified under Section 73 or 76 or rules made thereunder or such further time as may be allowed by the tribunal under Section 73. In such a situation, A. The company shall, in addition to the payment of the amount of deposit or part thereof and the interest due, be punishable with fine which shall not be less than 1 crore rupees but which may extend to 10 crore rupees. So they should pay the amount of deposit or part thereof along with the interest, and in addition to that there will be penalty of minimum 1 crore and maximum, it can go maximum up to 10 crore. And there is one more thing: every officer of the company who is in default shall be punishable with imprisonment, which may extend to 7 years, or with fine, which shall not be less than 25 lakh rupees, but which may extend to 2 crore rupees, or with both. So, if such a default is there that someone is accepting or inviting a deposit or in contravention of the act, not only is the company liable, the company has to pay the amount and with interest, and will be having a penalty to pay minimum of 1 crore and maximum of 10 crore. Along with that, there's a personal liability for every officer of the company who is in default, and the person that of this officer who is liable may be punishable with shall be punishable with imprisonment, which may extend up to 7 years, or with a minimum fine of 25 lakhs, and it can go up to 2 crore rupees. So there is liability for the company as well as a personal liability for the officers who are in default. Now the fifth one is the dividend cannot be declared by company running at a losses. The Companies Act, Amendment Act 2015 has inserted a fourth proviso to Section 123 Subclause 1. So, to the existing proviso, a fourth proviso was added to Section 123 Subclause 1 to the effect that no company shall declare dividend unless carried over previous losses and depreciation not provided in the previous year or years are set off against profit of the company for the current year. Hence, the companies having losses or negative results cannot declare dividends. So, in addition to the above stated amendments, the Companies Amendment Act 2015 has made several other amendments in various sections of the Act of 2013 so as to bring the company administration more easy. So the most important 5 changes that was brought by Companies Amendment Act of 2015 were: 1. The figure of minimum paid capital was deleted. The requirement of common seal was made optional, and Section 11 of Companies Act 2013 was taken away. And then stringent penalty was brought for company inviting or accepting deposit in contravention of Companies Act 2013. And the last one, fifth one, dividend cannot be declared by company running at losses. The second topic is definition of company and the characteristics of company. So the word company is defined in clause 20 of subsection 2 of Companies Act 2013, that is section 2 subclause 20. Company means a company incorporated under this act or under any previous company law. The definition in the act does not disclose the real meaning of the word company and its characteristics. The word company is used to denote an association of persons who have associated together to conduct or to carry on a business for gain. The persons associating together will contribute some money for the conduct of business, and the total amount is known as share capital of the company. This share capital will be used by company to carry on its business. The profit deriving from the conduct of the business will be divided among the members who have contributed money towards the share capital of the company. This is known as dividend. The association of persons will be known by a separate name. The association will be incorporated or registered under Companies Act, and thereafter it will be a legal person having an artificial personality. A company is a corporation aggregate. It will be known by a separate name. It will be having perpetual succession. It is a legal person living only in the eyes of law. It can acquire properties in its own name. It can contract debts. The liability of a company will be its own. The members' liability will be only to the extent to the value of the shares they hold in the company. The company may have a common seal. It is a signature of the company. Before amendment in 2015, requirement of a common seal was mandatory. Now it is optional. Section 9 of the Companies Act 2013 declares the effect of incorporation. Declares the effect of registration of a company under the Companies Act. It is as follows. From the date of incorporation mentioned in the Certificate of Incorporation, such subscribers to the memorandum and all other persons as may from time to time become members of the company shall be a body corporate by the name contained in the memorandum, capable of exercising all the functions of an incorporated company under this act and having perpetual succession. So, earlier it also had and a common seal. Now these words are omitted by the 2015 amendment. With the perpetual succession with power to acquire, hold and dispose of property, both movable and immovable, tangible and intangible, to contract and to sue and be sued be the in the said name. So what section 9 says is that from the date of incorporation in the certificate of incorporation, the company gets its rights and a different personality, a individual personality. Company is a separate individual, and by this it has perpetual succession and it can acquire, hold, dispose any property that is movable, either immovable, tangible or intangible, or make contract or sue and be sued in the name of the company. The name mentioned in the memorandum will be the name of the company. Section 9 of the Act 2013 has been amended in 2015 and the words and a common seal have been omitted. The result is that now a company need not have a common seal. The advantage of registration of a company is in fact declared in section 9. So, essential characters of a registered company, which is also the advantages of incorporation, are as follows. 1. Separate legal entity. When a company is incorporated under the Companies Act, a new legal person will be born and thereafter the company will be regarded as an entity separate from its members. This separate legal personality confers upon the company some rights and liabilities apart from those of its members. The separate legal personality of the company was well established in the case of Salomon versus Salomon and Co. Limited in 1897. So, facts of the case. This is one of the important case with respect to Companies Act. One of the important case law in Companies Act and with respect to separate legal entity. So, the facts of the case. Salomon was a shoe manufacturer. He registered a company named Salomon and Co. Limited with a total share capital of £30,000. His wife and 5 children took up one share of £1 each. Salomon took 20,000 shares of £1 and 10,000 pounds debentures. The debentures gave the Salomon a charge over the asset of the company. The Salomon had 20,000 in a total investment of £30,000. His wife and 5 children took shares of £1 each. From the rest, Salomon took 20,000 shares of £1 each and 10,000 pounds of debentures. So the debentures gave Salomon a charge over the assets of the company. The company went into liquidation within a year due to general trade depression. Now, at the time of winding up, the company had an asset of £6,000. On the other hand, the liabilities of the company amounted to £17,000. So the company had asset of only £6,000, but the liabilities of the company amounted to £17,000. Salomon was entitled to get £10,000, which was secured by debentures. £7,000 were due to outside creditors. So, out of the total liability of 17,000, 10,000 was due to Salomon himself and 7,000 to outside creditors. The total asset that remained in the company was only £6,000. So this liability was over and above the claim of the shareholders of the company. The unsecured creditors claimed that the company was a merry agent of Salomon and hence they should be paid in priority to Salomon. The court held that as soon as the company was registered, it became a separate person, independent from Salomon. Salomon is only a member of the company. A company can borrow money from its members and create the security upon its assets. In this case, the debentures are secured and Salomon could claim priority over the unsecured creditors. A company is an artificial, invisible, and intangible person and lives only in the eyes of law. A company is an entirely different person from its members. A company is a legal person without physique and soul. It can act only through human agency. It can appoint any member as its servant. It will be liable to the employee member as in case of any other employee. So we have another case here which is again an important case law, that is Lee versus Lee's Airframing Limited 1960. Salomon and Salomon was 1897 and Lee versus Lee Farming Limited, it's Lee's Air Farming Limited, that is in 1960. So here the facts of the case is Lee formed the company with a share capital of £1,000. He took share of £2,999. So, except for £1, the rest of the share was taken by Lee. His wife took one share of £1. Mr. Lee was the director of the company. The company appointed Mr. Lee as the chief pilot of the company. While piloting the company's plane, he was killed in an accident. The workers of the company were insured and they were entitled to compensation on death or injury. Mrs. Lee claimed the compensation. Here, the court held that company is a separate legal person and it can appoint a member as its servant. Company would be liable to pay compensation to its workmen even though he is a member. If he has sustained any injury in the course of his employment, he is entitled for compensation. So this is regarding the separate legal personality of the company. And then we have perpetual succession. That is the second most important character and advantage. That is perpetual succession. A company is a legal person with perpetual succession. Perpetual succession means that the membership of a company may change from time to time, but that will not affect the continuity of the company. According to F. Bullock, a company's perpetuity is like the river Thames. The river Thames is still the same river, though the parts which compose it are changing every instant. The company will have a continuity in existence, irrespective of any change in the membership of the company. The members may come and go, but the company can go on forever until dissolved by the process of law. According to Gower, the company's existence will not be affected even though all the members of a company were killed by a bomb. Not even a hydrogen bomb can destroy it. And the third character we are going to discuss is limited liability. This is the third advantage of incorporation of a company. A company may be incorporated with limited liability. The liability may be limited by shares or by guarantee. If a company is registered with limited liability, the liability of the members will be only to the extent of face value of the shares which are held by them, or the amount guaranteed by them. If the face value of a share in a company is rupees 100, the person who holds a share is liable only to the extent of rupees 100. The creditors of the company cannot get their claim satisfied beyond the asset of the company. The creditors cannot proceed against the personal property of the shareholders for the satisfaction of their claim. Now, the fourth important advantage is separate property. A company is a legal person. It can acquire, own, enjoy, or dispose of properties in its own name. Although the capital of the company is contributed by its shareholders, they are not joint owners of a company's property. So, in a case law, that is Bacha F. Gusdar versus Commissioner of Income Tax 1955. Bacha F. Gusdar versus Commissioner of Income Tax 1955. Facts of the case. Bacha F. Gusdar was a shareholder of the company which was engaged in agricultural operation. The company gave dividend to Bacha F. Guftar. The Commissioner of Income Tax assessed the dividend to income tax. Bacha F. Gustar contended that the income is agricultural income and hence not liable to tax. The court held that income of the company is agricultural income and not liable to be taxed as far company is concerned. A member who received dividend from such a company cannot claim that it is agricultural income because a company is a legal person who can own, enjoy, and dispose of its own property. A member of a company has no insurable interest in the property of the company. And in another case law, that Makaura versus Northern Assurance Company. Makaura versus Northern Assurance Company. Facts of the case: Makaura, Macaura, Makaura, insured the timber of a company for £42,000. He was a major shareholder of the company. He insured the timber in his own name and not in the name of the company. Later, the timber was destroyed by fire. He claimed the insurance amount. The court held that over the company's properties, members have no insurable interest. So that was held in Makaura versus Northern Assurance Company. Now, the fifth most important advantage is transferability of shares. The shares of a public company are freely transferable, and a shareholder can sell his share in a public company in the open market. Then, sixth one, we have common seal. In England, the possession and use of common seal by companies is avoided by Companies Act 1989. In India, before the Companies Amendment Act of 2015, a company had to have a common seal. The seal of company represented its official signature. On the common seal, the name of the company had to be engraved. After the amendment in 2015, a company need not have a common seal of its own. The document of the company without its seal becomes valid after the amendment. Seventh one, capacity to sue. A company is a legal person which can sue and be sued in its own name. Eighth one, application of doctrine of ultra-vires. In the case of a company, the application of ultra-vires doctrine is an essential feature. It cannot go beyond the object clause of the Memorandum of Association. Ninth one, winding up. In order to terminate functioning of a company, special winding up procedure is prescribed by law. The company will cease to be in existence only by its compliance. So these are not all the advantages of incorporation of company, but only a few of them, few important ones. There are even more advantages that has been discussed. It is advised to do a further reading with regarding the case laws of each advantage if you want to write more on it. And there are even more advantages. Especially we have plenty of case laws in capacity to sue and capacity to be sued, that where it is discussed in relation to the separate entity that the people cannot sue the company for something before the incorporation or for the agreement before the incorporation. There are few case laws as such. So if you want to have a deeper look into it, please do a further reading. Now, that is with the definition of company and characters as discussed in this note. The next topic is doctrine of lifting the corporate veil, or it is also disadvantages of incorporation. So a company is a separate legal person apart from its members. The separate legal entity of the company is well established in the decision of the case of Salomon versus Salomon and Company Limited. This principle may be called as the veil of incorporation. The effect of this principle is that there will be a fictional veil between the company and its members. After the incorporation, the company can acquire properties in its own name. It can sue and be sued in its own name. The liability of the members will be limited to the face value of the shares held by them. The separate legal entity of the company has its own advantage, but the human ingenuity started to use the veil of corporate personality as a shield of committing fraud. The veil of incorporation may be used for defrauding shareholders, creditors, and even the government. The courts were compelled to break through or lift the corporate veil in order to find out the real beneficiary behind the company. The courts in such a situation ignore the separate legal entity of the company and punish the persons who have misused the company's name. For this purpose, the doctrine of lifting the corporate veil or breaking the wall of cooperation is evolved by the courts. By pulling off the mask, the court can verify who underneath is really liable. There is a case law, that is Life Insurance Corporation of India, that is LIC of India, versus Escorts Limited, and this is a 1986 case. In this case, the Supreme Court observed that a company is an independent and legal person distinct from the individuals who are its members. Corporate veil may be lifted and the individual members may be held liable for preventing the fraud or improper conduct. The circumstances under which the corporate veil may be lifted are as follows. 1. Protection of revenue. If the corporate entity of a company is used for tax evasion, the courts may ignore the corporate entity of the company. In Jugilal versus Commission of Income Tax 1969. In this case, that is Jugilal versus Commission of Income Tax 1969, the Supreme Court held that the corporate entity of the company will be disregarded when the name of the company is used to circumvent tax obligation. Further, in another case law, that is in re Sir Dinshaw Manakji Patit, that is 1927, and this is one of the most important case law regarding company law. Salomon and Salomon, Lee versus Lee Air Farming Limited, and in re Sir Dinshaw Manakji Patit. These are very important case laws. So in re Dinshaw Manakji Patit, that is 1927. Here, D was an assessee of income tax. He was receiving huge dividends and interest income from various companies. He formed 4 private companies. He agreed with each company to hold a block of shares and debentures. Thereafter, the dividend and interest income were received by these 4 companies in their own name, and he took pretended loans from these 4 companies. By doing so, he could avoid tax obligation. But the court held that the 4 companies were registered only for the purpose of receiving dividends and interest and to hand them over to D as loans. The companies were formed purely for avoiding super tax, and thus the court rejected the separate legal personality of the company. So this was discussed in Re Sir Dinshaw Manakji Patit in 1927. Now, the second situation where the corporate veil is lifted, that is prevention of fraud or improper conduct. The legal personality of a company may be disregarded by the court in the interest of justice. If the machinery of incorporation is used for some fraudulent purpose like defrauding creditors or avoiding specific performance of contract or defeating law, the court may disregard the legal personality of the company. Here we have a case, and that is also pretty important, that is Johns versus Lipman 1962. Johns versus Lipman. Here Lipman agreed to sell his land to Johns for £5,000. He subsequently changed his mind, and to avoid specific performance of the contract, he sold the land to a newly formed company. The company had only 2 members. One was Lipman and the other was a clerk of his solicitor. Jones brought an action for the specific performance of the contract against Lipman and the company. The court looked into the reality of the situation and held that the company should transfer the land to Jones. It is because the company was formed only for the purpose of avoiding specific performance of the contract. Now, the third situation is when the company is a sham. The court will lift the corporate veil of the company if it is merely cloak or sham. If the name of an incorporated company is used to avoid contractual obligations or to defraud the members or creditors of the company, the court may disregard the legal personality of the company. And we have a case here, that is Guilford Motor Company versus Horn. Guilford Motor Company Limited versus Horn, 1933. C.A. Horn was an employee of the plaintiff company. At the time of his retirement from the company, he agreed that he will not solicit the customers of the company. Subsequently, he formed a company and solicited the customers of the old company in which he was working. Had he solicited the customers of plaintiff company, it would have been breach of contract. In this situation, the court held that new company is only a sham or cloak for the purpose of enabling the defendant to commit a breach of his agreement. The court granted injunction against C.A. Horn and the new company. Now the fourth situation is determination of the character of the company. In order to determine the character of the company, that is whether it is enemy or not, the court may lift the corporate veil. So here we have a very important case, that is Daimler Company Limited versus Continental Tire and Rubber Co. Limited. A company was incorporated in England for the purpose of selling in England tires manufactured in Germany by a German company. This German company held the bulk of shares in English company. The remaining shareholders, except one, and all the directors were German residents. During the First World War, the English company commenced an action for recovery of trade debt. The English court held that the English company was an enemy alien and the English court held that the German company was an enemy alien and therefore the action was dismissed. Here what the court said was like, in a situation where a war is going on, if the court was to allow the claim, it would be like taking the money of the English citizen and handing it over to the enemy. So that is with lifting the corporate veil and the scenarios where the corporate veil is lifted. And next we have the type of companies. Public company, private company, and one-person company, or formation of a company. Section 3 of the Companies Act 2013 deals with the formation of company. By Section 3, Subclause 1 of the Companies Act 2013, a company may be formed for any lawful purpose by a. 7 or more persons where the company is to formed is to be a public company. 7 or more persons if it is to be a public company. B. 2 or more persons where the company to be formed is to be a private company. So 2 or more persons where the company is to be a private company. Now C. 1 person where the company to be formed is 1 person company. That 1 person company is also a private company, but generally in a private company there is 2 or more persons, but in 1 person company only 1 person is involved. These people by subscribing their name or his name to a memorandum and complying with the requirements of the Act in respect of the registration can form a company for any lawful purpose. So that is discussed in section 3 subclause 1. Now section 3 subclause 2. A company formed under subsection 1 may be either a company limited by shares, a company limited by guarantee, or an unlimited company. So the liability is discussed in section 3 subclause 2. This, the Companies Act 2013 recognized three types of companies. They are public company, private company, and one-person company, which is also a private company. Based on the liability of members, the companies formed may be classified into three, that is, a company limited by shares, a company limited by guarantee, or an unlimited company. Further, we will look into public company. So section 2 subclause 71 defines the expression public company. Public company means a company which is not a private company and has a minimum paid up capital as may be prescribed. So, a public company, which is defined in section 2 subclause 71, it shall not be a private company and has a minimum paid up capital as may be prescribed. Section 2 subclause 71 was amended by the Companies Amendment Act of 2015, and the requirement of minimum paid up share capital of 5 lakh rupees has been omitted. Before the amendment, a public company had to have a minimum paid up share capital of 5 lakh. Thus now a public company need to have a minimum thus now a public company need not have a minimum paid up share capital as may be prescribed earlier. Now the minimum paid up share capital may be prescribed by the central government. The central government has not yet prescribed the amount of minimum paid up share capital that which a public company ought to have. A company can be called a public company if it satisfies the following conditions. 1. It should not be a private company. 2. Along with the name of the company as shown in the memorandum, the word limited should be used as the last word. A minimum of 7 persons should have subscribed to the memorandum of the company. It should have a minimum paid up share capital as may be prescribed by the central government. The central government has not yet prescribed this minimum paid up share capital. The articles of association of the company should not restrict the right of its members to transfer its shares. So, transferability of shares should be there. The articles of association of the company should not contain any limit as to the maximum number of members. The articles of association of the company should not prohibit it from making any invitation to the public to subscribe for any securities, shares, and debentures of the company. The minimum number of persons required to form a public company is 7, and there is no limit to the maximum. Now we will look into the private company. Section 2 subclause 68 of the Act of 2013 defines the expression private company. A company registered under the Act can be called a private company if it satisfies the following condition. 1. A minimum of 2 persons should have subscribed to its memorandum except in the case of a one-person company. 2. Along with the name of the company as shown in the memorandum, the words private limited should be used as last words. 3. It should have minimum paid up capital as may be prescribed. Section 2, Subclause 68 was amended in the Companies Amendment Act of 2015, and the requirement of minimum paid up share capital of 1 lakh rupees has been omitted. Thus now a private company need to have minimum paid up share capital as may be prescribed by the central government. The central government has not yet prescribed the amount of minimum paid up share capital that which a private company ought to have. Now, the fourth point, the articles of the company should contain restriction as to the right of its members to transfer its shares. So in public company, it was not restricted, but in private company, the articles of the company should contain restriction as to the right of its members to transfer its shares. And the fifth one, the articles of the company should limit the maximum number of members to 200, excluding past and present employee members. If two or more persons hold one share in a company jointly, they shall be treated as a single member. The minimum number of members required to form a private company is 2, and the maximum is 200, excluding past and present employee members. The word private limited is to be added at the end of its name. Now, distinction between a public company and a private company. 1. The minimum number of persons required to form a public company is 7, whereas the minimum number of persons required to form a private company is 2. One person company is also treated as a private company, but it need to have only one member. The second point, in case of a public company, there is no restriction as to the maximum number of members, whereas in case of private company, the maximum number of members cannot exceed 200, that is excluding past and present employee members. The third point, a public company can invite general public to subscribe shares or debentures of the company. A private company cannot invite general public to subscribe the shares or debentures of the company. The fourth point, a public company's share can be freely transferred, whereas a private company's share cannot be freely transferred. The fifth point, a public company must have at least 3 directors in the board of directors, which as mentioned in section 149. A public company must have at least 3 directors in the board of directors as prescribed under section 149. A private company must have at least 2 directors. In the case of one person company, it should have 1 director in the board of the director. This is also discussed in section 149. Now, sixth point, the managerial remuneration, that is remuneration payable to its directors and managers of a public company, cannot exceed 11% of its net profits in a financial year. This is discussed in section 197 subclause 1 of the Companies Act 2013. Section 197 subclause 1, that is a managerial remuneration for a public company cannot exceed 11% of its net profit in a financial year. In the case of private company, there is no such restriction. Now, seventh point, in the case of public company, the quorum of general meeting is 5. So, in public company, the quorum of general meeting is 5. In case of private company, the quorum is 2. Now, we will look into the 1% company. It is a new concept introduced in the company law. A person who intends to start his business as a company with one person only can now register his business house under Companies Act with the benefits of limited liability. Section 2 subclause 62 of the Act defines the expression one-person company. It means a company which has only one person as a member. One-person company is treated as a private company for all purpose. Thus, the provisions applicable to a private company, except the requirement as a minimum and maximum members, are applicable to one-person company. A one-person company can be formed for any lawful purpose. The memorandum of the company should be subscribed by the person who intends to form the one-person company. The memorandum of a one-person company shall indicate the name of the other person or nominee with his prior written consent in the prescribed form, who shall, in the event of the subscriber's death or his incapacity to contract, become the member of the company. The written consent of that person, the nominee, shall also be filed with the registrar at the time of incorporation of the one person company, along with its memorandum and articles. In order to register a one person company, as in case of a private company, it should have paid up share capital as may be prescribed by the central government. The articles of one person company should have the following: 1. Prohibit any invitation to the public to subscribe for any securities of the company. 2. Restrict the right to transfer its shares. The Companies Incorporation Rules of 2014. Companies Incorporation Rules 2014 provides for the following rules in relation to one person company. Only a natural person who is an Indian citizen and resident in India shall be eligible to incorporate a one person company. Further, only a natural person who is Indian citizen and resident in India shall be a nominee for the sole member of the one person company. So the person starting the company as well as the nominee both should be natural person, Indian citizen and resident in India. The term resident in India means a person who has stayed in India for a period not less than 182 days during the immediate preceding calendar year. No person shall be eligible to incorporate more than a one person company or become nominee in more than one such company. So one person can incorporate only one person company, and one person can be nominee only to one person company. No minor shall become member or nominee of one person company or can hold share with beneficial interest. Such company cannot carry out non-banking financial investment activities, including investment in securities of any body corporate. So that is with regarding to the types of companies or the formation of company. The next topic is conversion of companies. Section 18 of the Companies Act 2013 permits conversion of companies from one class to another. Thus, a private company can be converted into a public company. So, also a public company can be converted into a private company. The conversion is to be effected by alteration of memorandum and articles of association of the company. Now, Section 14 provides for alteration of articles. Section 13 provides for alteration of memorandum, and Section 13 provides for 14. Here we have to consider Section 13, which provides for alteration of memorandum, and Section 14, which provides for alteration of articles. Voluntary conversion of one person company into a public company or a private company. A one person company can convert itself into a public company or a private company. The conversion is to be effected by alteration of the memorandum and articles of the company. Section 13 provides for the alteration of memorandum. Section 14 provides for the alteration of articles of association. In order to convert it to a private company, the number of members and the directors is to be increased to 2. It can be converted into a public company by increasing the minimum number of members to 7 and the number of directors to a minimum of 3. One person company cannot convert voluntarily into any kind of company unless 2 years have expired from the date of incorporation of one person company. However, if the threshold limit, that is, paid up share capital, is increased beyond 50 lakh rupees or its average annual turnover during the relevant period exceeds 2 crore rupees within 2 years of its incorporation, it shall cease to be entitled to continue as one-person company, and it has to convert itself within 6 months into either a private company or a public company. So if the threshold limit or paid up share capital is increased beyond 50 lakh, or if the turnover, average annual turnover, is exceeding 2 crore rupees, it cannot continue as one person company and it has to convert itself within 6 months into either a private company or a public company. The one-person company has to make an application to the registrar for the effecting conversion. The registrar shall, on the application made by the company, close the former registration and issue a certificate of incorporation in the same manner as its first registration. The conversion and the new registration of a company shall not affect any debts, liabilities, obligations, or contracts incurred or entered into by or on behalf of the company before conversion, and such debts, liabilities, obligations, and contracts may be enforced in the manner as if such registration had not been done. Conversion of one-person company by operation of law. Rule 6 of the Companies Incorporation Rules 2014 deals with the conversion of one-person company into a public company or a private company. By Rule 6, subclause 1 of the rules, uh, if paid up share capital of one-person company exceeds 50 lakh rupees or its average annual turnover during the relevant period exceed 2 crore rupees, it shall cease to be entitled to continue as one-person company. Such one-person company shall be required to convert itself within 6 months of the date on which its paid up share capital is increased beyond 50 lakh rupees, or the last day of the relevant period during which its average annual turnover exceeds 2 crore rupees, as the case may be, into either a private company with minimum of 2 members and 2 directors, or a public company with at least of 7 members and 3 directors. The one-person company shall, within a period of 60 days from the date on which it ceased to be a one-person company, give notice to the registrar informing that it has ceased to be a one-person company and that it is now required to convert itself into a private company or a public company because of its paid up share capital exceeded 50 lakh rupees or average annual turnover exceeded 2 crore. The one-person company shall, after its memorandum, alter its memorandum and articles by passing a resolution to give effect to the conversion. In order to convert into a private company, the number of members and directors is to be increased to 2. It can be converted into a public company by increasing the minimum number of members to 7 and number of directors to a minimum of 3. The one-person company has to make an application to the registrar for effecting conversion. The registrar shall, on the application made by the company, close the former registration and issue a certificate of incorporation in the same manner as its first registration. The conversion and the new registration of a company shall not affect any debt, liabilities, obligations, or contracts incurred or entered into by or on behalf of the company before conversion, and such debts, liabilities, obligations, and contracts may be enforced in the manner as such registration had not been done. Conversion of private company into one-person company. Rule 7 of the Companies Incorporation Rules 2014 provides for conversion of private company into a one-person company. A private company having paid up share capital of 50 lakh rupees or less and average annual turnover not exceeding 2 crore rupees may convert itself into 1% company by passing a special resolution in the general meeting. Before passing such resolution, the company shall obtain no objection in writing from the members and creditors. The company shall file copy of the special resolution with the registrar of companies within 30 days from the date of passing of such resolution. The company shall file an application for its conversion into 1% company. The following documents are to be attached along with the application. 1. A declaration of directors. The directors of the company shall give a declaration by way of affidavit confirming that all members and creditors of the company have given their consent for conversion. The paid up share capital of the company is 50 lakh rupees or less and the average annual turnover is less than 2 crore rupees. 2. A list of members and list of creditors. 3. The latest audited balance sheet and the profit and loss account. 4. The copy of non-objection letter of the secured creditors. If all the above conditions are satisfied, the registrar shall issue the certificate stating that it is 1% company. So, when there's a conversion of private company into 1% company, Rule 7 of Companies Incorporation Rules 2014 is applied. And when there is a conversion of 1% company to either a private company or a public company, Rule 6 of Companies Incorporation Rules 2014 has been applied. Further, we have already referred to the Companies Incorporation Rules 2014 earlier, which prescribes the rules in relation to 1% company. So that is with conversion of companies. So now we are gonna look into some other type of companies. Now the first one we'll be looking into is companies limited by shares. So on the basis of liability of members, companies can be classified into three heads. That is companies limited by shares, companies limited by guarantee, and companies with unlimited liability. In case of company limited by shares, the liability of each member is limited to the face value of the shares held by him. If the shares are fully paid, the liability of the shareholder is nil. However, to this general rule, there was one statutory exception. Under Section 45 of the Companies Act 1956, that is Companies Act 1956, Section 45, if at any time the number of members of a company is reduced below 7 in case of public company or below 2 in the case of a private company, the company carries on business for more than 6 months with reduced number. Every person who is a member of the company during the time that it carries business after 6 months is aware of the fact that the company carries on business with reduced number shall be severally liable for this whole debt of the company contracted after 6 months. So there is one exception to the company limited by shares. Now for an example, the number of members in a public company became reduced to 6 on 10th November 2004. The company incurs trade debt on 11th November 2004. 2nd April 2005, 17th May 2005, 18th May 2005. Discuss the liability of the members of the company. So here they said the company became reduced to 6 from 7 to 6 public company. So there is a minimum of 7 members required. It reduced to 6. It was reduced to 6 on 10th November of 2004. And the company incurs trade debt in the following day, that is 11th November 2004, then 2nd April 2005, then 17th May 2005 and 18th May 2005. Now let's discuss the liability of the company in this case. The members will be personally liable for those debts contracted after May 10th, 2005. So the company became reduced to 6th on 10th November 2004. So 6th month from that day is 10th May 2005. So any debt that the company incurred after 10th May of 2005, the members will be personally liable for those debts. Now, the Companies Act 2013 does not contain a provision similar to Section 45 of the old Act. So, this was with respect to the Companies Act 1956, Section 45. The present Companies Act 2013 does not have a provision similar to the Section 45 of Companies Act 1956. Thus, now no member will be personally liable even though the number of members is reduced below the required minimum if the company is registered as a limited company. In the case of companies limited by guarantee, the liability of members will be limited to the extent of guaranteed amount. In the case of unlimited companies, the members' liability will be unlimited as in case of unlimited partnership. So next we look into another type of classification, that is holding company and subsidiary company. Section 2 subclause 46 of the Companies Act 2013 defines a holding company, and section 2 subclause 87 defines subsidiary company. So holding company is defined in section 2 subclause 46 and subsidiary company in section 2 subclause 87. If a company has control over the affairs of another company, it is known as holding company. The company which is controlled by the holding company is known as subsidiary company. Under the following circumstances, a company becomes subsidiary company of a holding company. 1. If the composition of the board of directors of the company is controlled by the holding company. 2. If more than half in nominal value of equity share capital of the company is held by the holding company. That is, if more than half in nominal value of equity share capital is held by the holding company, and if the composition of the board of directors of the company is controlled by the holding company, one company will be subsidiary company of the holding company. If a subsidiary company has control over another company, that company will also be deemed to be the subsidiary company of the holding company. The holding company and its subsidiary company shall be treated as separate entities. The annual accounts of the subsidiary company will be annexed with the annual accounts of the holding company. Subsidiary company not to hold shares in the holding company. By section 19 subclause 1 of the Companies Act 2013, that is section 19 subclause 1 of the Companies Act 2013, a subsidiary company shall not hold any share in its holding company, and no holding company shall allot or transfer its shares to any of its subsidiary companies, and any such allotment or transfer of shares of a company to its subsidiary company shall be void. This section shall not be applicable to the following cases. First, if the subsidiary company holds such shares as the legal representative of a deceased member of the holding company. Second, if the subsidiary company holds such shares as a trustee. Or third, if the subsidiary company is a shareholder even before it became a subsidiary company of the holding company. The subsidiary companies holding the shares of a holding company as a legal representative or as a trustee only have right to vote at a meeting of the holding company. So the subsidiary companies holding the shares of a holding company as a legal representative or a trustee only have the right to vote at a meeting of the holding company. The subsidiary company became a shareholder before it became a subsidiary company shall not have right to vote at a meeting of the holding company. Now there is another type of company, that is government company. Section 2 subclause 45 of the Companies Act 2013 defines government company. If the central government or state government or, or the government, central and state together, hold at least 51% of the paid up share capital of a company, that company becomes government company. A subsidiary company of a government company will also be a government company. Special provisions applicable to government companies is contained in chapter 23, that is, special provisions applicable to government companies is contained in Chapter 23, Sections 394 and 395 of the Companies Act 2013. So 1. The auditor of government company shall be appointed by the Comptroller and Auditor General of India, that is CAG of India. The CAG shall have the power to direct the manner in which the company's accounts shall be audited by the auditor. The CAG shall also have the power to conduct a supplementary audit of the accounts of the company. The auditor of the company shall submit a copy of his audit report to the Comptroller and Auditor General of India. The CAG has a right to comment upon the audit report. The comment upon the audit report shall be placed before the annual general meeting of the company. If the central government is a member of the government company, it shall prepare an annual report on the working and affairs of the company within 3 months of its annual general meeting. The annual report shall be laid before both houses of the Parliament, together with a copy of the audit report and any comment upon the audit report made by the CAG of India. If a state government is a member of government company, the state government shall prepare an annual report on the working of the company within 3 months of its annual general meeting, and the annual report shall be laid before the state legislature along with audit report and any comment upon the audit report made by the CAG of India. So that is with respect to government company, that is defined in section 2 subclause 45. Now we have foreign company. Foreign company is defined in section 2 subclause 42, chapter 22, section government company is dealt in chapter 23, section 394 and 395, that is government company, and foreign company is dealt in chapter 22, section 379 to 393 of the Act, that deals with the special provisions applicable to companies incorporated outside India. A company which is incorporated outside India and has a place of business in India is called foreign company. A foreign company establishing a place of business within India shall, within 30 days of the establishment of the place of business, deliver to the registrar for registration of the following documents. 1. A certified copy of the charter, statute, or memorandum and articles of association or any instrument containing the constitution of the company. If the instrument is not in English language, a certified translation of the copy will have to be filed. 2. The full address of the registered or principal office of the company. 3. The full address of the directors and secretary of the company. 4. The name and address of any person or persons resident in India authorized to accept on behalf of the company service of processed and any notices required to have been served on the company. 5. The full address of the principal place of business in India. Now, the above stated documents have to be filed with the registrar of the state where the principal place of business is situated and with the registrar at New Delhi. A foreign company shall conspicuously exhibit on the outside of every office or place where it carries on business in India the name of the country where it is incorporated in English and in one of the local language. A foreign company shall in every calendar year make out a balance sheet and a profit and loss account and deliver 3 copies of those documents to the registrar. A foreign company may, even if it has no place of business in India, issue a prospectus offering shares or debentures for subscription. The prospectus must be registered with the registrar before it is issued to the public. If any foreign company ceases to have a place of business in India, it shall give notice to the fact to the registrar. If any foreign company fails to comply with any of the foregoing provisions, the company shall be punishable with fine which shall not be less than 1 lakh rupees but which may extend to 3 lakh rupees, and in case of a continuing offence with an additional fine which may extend to 50,000 rupees for every day during which the default continues, and every officer of the foreign company who is in default shall be punishable with the imprisonment for a term which may extend to 6 months or with fine which shall not be less than 25,000 rupees but which may extend to 5 lakh rupees or with both. So that is with foreign company. Now we also have illegal association. That is not a company but an illegal association. Section 464 of the Companies Act 2013 deals with the prohibition of association of partnership of persons exceeding certain numbers. By Section 464 of the Act, no association or partnership consisting of more than 50 numbers, that is by Rule 10 of the Companies Miscellaneous Rules of 2014, shall be formed for the purpose of carrying on any business that has for its object the acquisition of gain by the association or partnership or by the individual members thereof, unless it is registered as a company under the Act or is formed under any other law for the time being in force. There can be a cooperative society with more than 50 members. However, it is to be registered under Cooperative Societies Act. There can be a partnership business with more than 50 partners. If a partnership is formed with more than 50%, every member of the partnership shall be punishable with fine which may extend to 1 lakh rupees and shall also be personally liable for all the liabilities incurred in such business. So there cannot be a partnership business with more than 50 partners, but there can be a cooperative society with more than 50 members if it is a registered under Cooperative Societies Act, but a partnership cannot be made more than 50 with not more than 50 partners. And if they form a partnership with more than 50%, they are liable for punishment with a fine which may extend to 1 lakh rupees and shall also be personally liable for all the liabilities incurred in such business. If any association of 50 or more persons conduct an activity without an object of making profit, it does not require registration under the Companies Act. An illegal association cannot enter into any contract. It cannot sue any member or outsider. The prohibition in section 464 is not applicable to joint Hindu family carrying on a business. But if the business is carried on by two or more families in partnership and total number exceed 50, then section 464 will be applicable. The prohibition in section 464 is not applicable to an association or partnership if it is formed by professionals who are governed by special acts. So that is with illegal association. The next topic is promoter. In the formation of a company, certain preliminary steps are necessary. Usual steps in the formation of the company are following: 1. Preparation of memorandum of association of the company. 2. Preparation of articles of association of the company. 3. Entering into preliminary contracts. 4. Registration of the company. So these four steps are basic to the formation of the company. All these steps are taken by certain persons known as promoters. Individuals, firms, associations, or persons or syndicate can act as promoters. A promoter is a person who undertakes the necessary preliminary steps incidental to the formation of a company. According to Palmer, a promoter is a person who originates the scheme of the formation of the company. He prepares the memorandum and articles of association of the company. He settles the terms of preliminary contracts. He finds out the first directors. He prepares prospectus and make arrangement for advertising and circulating the prospectus. According to Gover, a promoter is the sole creator of the company, such as a port maker is the sole creator of the ports, a promoter is the sole creator of the company. The promoter settles the company's name. He settles the details of the company's memorandum and articles. He arranges for the printing of the memorandum and articles. He determines the nomination of directors, solicitors, bankers, auditors, and secretary. He arranges the registered office of the company. He arranges for the registration of the company. He is, in fact, responsible for bringing the company into existence. Section 2, Subclause 69 of the Companies Act 2013 defines the expression promoter. The following persons are treated as promoter of the company. 1. A person who has been named as promoter in a prospectus. 2. A person who is identified as a promoter by the company in the annual return to be filed with the registrar under Section 92 of the Act. 3. A person who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise. 4. A person in accordance with whose advice, directions, or instructions the board of directors of the company is accustomed to act. However, a person who is acting merely in a professional capacity would not be treated as a promoter. Legal relationship between promoter and company. A promoter is neither an agent nor a trustee of a proposed company. He is not an agent because there is no principal. He is not a trustee because the beneficiary is not in existence. However, from the moment he acts with the company in mind, a promoter stands in a fiduciary position towards the proposed company. The important consequence that follows from the creation of a fiduciary relationship between the promoter and the company he brings into existence are the following. The first one, disclosure of interest. A promoter shall not make any profit from the sale of his own property to the company without disclosing material facts. If a promoter contracts to sell his own property to the company without making a full disclosure, the company may either repudiate the sale or affirm the contract and recover profits made out of it by the promoter. In a case that is Erlanger versus New Sembrero Phosphate Company. Erlanger versus New Sembrero Phosphate Company, 1878. Here, Erlanger was head of a syndicate. The syndicate purchased an island containing mines of phosphate for £55,000. Erlanger then formed a company. Thereafter, a contract was made between X, a nominee of the syndicate, and the company for the purchase of the island at £110,000. The details of the sale were not disclosed to the shareholders. The company filed a suit to rescind the contract of sale. The House of Lords held that since the promoters had not disclosed the profit which they made, the company could rescind the contract. Now, the second one is secret profit. A promoter shall not make any profit at the expense of the company without knowledge and consent of the company. If he has earned secret profit, the company can compel him to account for it. There's a case law here in Gluckstein versus Barnes. Gluckstein, Gluckstein. Gluckstein versus Barnes in 1900. The court held that the promoters who have made secret profit should account for it, and they are bound to pay to the company the secret profits they made. Now comes remuneration of promoters. A promoter is entitled to a reasonable remuneration for the services of a promoter. He can take the remuneration for his service in one of the following ways. 1. He may sell his own property at a profit to the company for cash or fully paid shares, but the fact should be disclosed to the shareholders. 2. He may take a commission on the shares sold. 3. He may be given an option to buy a certain number of shares in the company at par. 4. He may be paid a lump sum by the company. So, the promoter can take the remuneration for his service in either of these four methods. Now we have duty of promoter as regards prospectus. The promoter who issues prospectus for inviting applications for shares should issue it with full particulars. The prospectus should not contain any untrue or misleading statements or should not omit any material fact. The promoter will be liable for false statement in the prospectus. Preliminary or pre-incorporation contracts. Preliminary contracts are the contracts made between the promoter and the third parties on behalf of the proposed company. The promoter of a company usually enters into contracts to acquire some property or right for the company which is yet to be incorporated. Such contracts are called preliminary or pre-incorporation contracts. So, in a case law, that is Kellner versus Baxter, 1866. Kellner versus Baxter. Here, the court held that a company which is formed subsequent to the preliminary contract cannot ratify the contract as it was not in existence at the time of entering into contract. So let's look into the facts of the case. In this case, the promoters of a hotel company signed an agreement for the purchase of wine on behalf of the proposed company. The company was incorporated and it ratified the contract made by the promoters. The wine was supplied by contracting party and the company consumed the wine. Before paying the price, the company went into liquidation. The suppliers of wine claimed the price from the liquidator. The court held that preliminary contracts could not be ratified by the company after its incorporation. The promoters are personally liable to pay the price. Thus, a company cannot, after its incorporation, enforce a contract made before its incorporation. A company cannot ratify a contract entered into by the promoters on its behalf before incorporation. The rule that a company is not bound by preliminary contracts is subject to an important statutory exception. Section 15 and 19 of the Specific Relief Act 1963 deals with specific performance of preliminary contracts. That is Section 15 and 19 of the Specific Relief Act 1963. It deals with specific performance of preliminary contracts. When the promoter of a company have, before its incorporation, entered into a contract for the purpose of the company, and such contract is warranted by terms of incorporation, specific performance may be obtained by the company or enforced against the company. The company, however, should have accepted the preliminary contract and communicated such acceptance to the other party in the contract. So that is with promoters. So the next topic is incorporation of a company or registration of a company. Application for incorporation of companies. By Rule 12 of the Companies Incorporation Rules 2014, for the registration of a company, an application shall be filed with the registrar within whose jurisdiction the registered office of the company is proposed to be situated, in form number INC2 for one-person company and form number INC7 other than one-person company, along with the fees as provided in the company's registration offices and fees rules 2014. Now, documents to be filed for registration. By Section 7 of the Act, Companies Act 2013, in order to register a company, the following documents and information are to be filed with the registrar within whose jurisdiction the registered office of a company is proposed to be situated. A. The Memorandum of Association and Articles of Association of the company duly signed by all the subscribers to the memorandum. B. A declaration in form number INC 8 by an advocate, a chartered accountant, cost accountant, or company secretary in practice who is engaged in the formation of the company, and by a person named in the Articles of Association as a director, manager, or secretary of the company, that all the requirements of the Act and the rules made thereunder in respect of registration have been complied with. C. An affidavit from each of the subscribers to the memorandum and from persons named as the first directors, if any, in the articles that he is not convicted of any offences in connection with the promotion, formation, or management of any company, or that he has not been found guilty of any fraud or misfeasance or any breach of duty to any company under the Act or any previous company law during the preceding 5 years, and that all the documents filed with the registrar for registration of the company contain information that is correct and complete and true to the best of his knowledge and belief. The affidavit shall be submitted by each of the subscriber to the memorandum and each of the first directors named in the articles in the form number INC 9. Now D. The address of correspondence till its registered office is established. E. The particulars of name, including surname or family name, residential address, nationality, and such other particulars of every subscriber to the memorandum, along with proof of identity. F. The particulars of the person mentioned in the articles as the first directors of the company, their name, including surname or family name, the director identification number, residential address, nationality, and such other particulars, including proof of identity. G. The particulars of the interests of the persons mentioned in the articles as the first directors of the company in other firms or bodies corporate, along with their consent to act as directors of the company. The registrar, on the basis of the documents and information filed, shall register all the documents and information in the register and issue a certificate of incorporation to the effect that the proposed company is incorporated under the Act. On and from the date mentioned in the certificate of incorporation, the registrar shall allot the company a corporate identity number, which shall be distinct identity for the company and which shall also be included in the certificate. The company shall maintain and preserve at its registered office copies of all documents and information as originally filed with the registrar until its dissolution. Punishment for fraud. By Section 7, Subclause 5 of the Act, if any person furnishes any false or incorrect in particulars of any information or suppresses any material information of which he is aware in any of the documents filed with the registrar in relation to the registration of a company, he shall be liable action under Section 447 of the Act. Section 447 provides for punishment of fraud. Any person who is found to be guilty of fraud shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years, and shall be liable to fine which shall not be less than amount involved in the fraud, but which may extend to 3 times the amount involved in the fraud. Now, by Section 7, Subclause 6, if at any time after the incorporation of a company, it is proved that the company has been got incorporated by furnishing any false or incorrect information or representation, or by suppressing any material fact or information in any of the document or declaration filed or made for the incorporating such company, or by any fraudulent action, the promoters, the persons named as the first directors of the company, and the persons making declaration, that is, the advocate, chartered accountant, etc., shall each be liable for action under Section 447 of the Act. Now, removal of the name of the company from the register. By Section 7, Subclause 7 of the Act, if a company has been got incorporated by furnishing any false or incorrect information or representation, or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporating such company, the tribunal may, on application made to it, a. pass such order as it may think fit for regulation of the management of the company, including changes, if any, in its memorandum and articles, in public interest or in the interest of the company and its members and creditors, or b. direct that liability of the members shall be unlimited, or c. direct removal of the name of the company from the register of the companies, or d. pass an order for the winding up of the company, or e. pass such other orders as it may deem fit. Before making any order, the tribunal shall give the company a reasonable opportunity of being heard in the matter. So, the punishment of fraud is discussed in section 447 of the Companies Act 2013, and the rest of the procedures is discussed in section 7 of the Companies Act. And for registration, rule 2 of Companies Incorporation Rules 2014 is applicable, and for the fees, Companies Registration Officers and Fees Rules of 2014 is applicable. Memorandum of Association of Company. In order to register a company, one of the documents to be filed with the registrar of the companies is Memorandum of Company. The memorandum is the charter of the company. It is the dominant instrument and it defines the limits of the company's powers and objects. Any act of the company beyond the limits of its powers and objects is defined in the as defined in the memorandum of the company will be ultra vires and void. The memorandum of a company is the constitution of the company. It defines the relation of the company with outside world and the scope of its activities. In Ashbury Railway Carriage and Iron Co. versus Risch, that is 1857 case, the court held that the memorandum of a company is its charter and defines the limitation of powers of the company. The case law is Ashbury Railway Carriage and Iron Co. versus Risch, 1857. In another case, that is in Cotman versus Brougham, that is in 1918. Cotman versus Brougham, the court held that the purpose of Memorandum of Association are twofold. One, the prospective shareholders who contemplate the investment of their saving should know the field in which it is going to be used. 2. It will give information to anyone who deals with the company to know whether the contract he intends to make with the company is within the objects of the company. Now, the memorandum of a company shall be printed, divided into paragraphs, numbered consecutively, and signed by 7 subscribers in the case of a public company. If it is a private company, at least 2 subscribers must sign the memorandum. In the case of one-person company, the person registering the company should sign it. The memorandum of a company is to be prepared as provided in the forms given in the Schedule 1. The forms of memorandum of different companies is given in the table contained in Schedule 1. There are 5 tables in Schedule 1. They are Table A, B, C, D and E. Table A is the form of Memorandum of Association of a company limited by shares. In Table B, we have Memorandum of Association of a company limited by guarantee and not having a share capital. Table C is the form of Memorandum of Association of a company limited by guarantee and having a shared capital. Table D is the form of Memorandum of Association of an unlimited company and not having a share capital. Table E is the form of Memorandum of Association of an unlimited company and having share capital. So, once again, in Table A, it is of a company limited by shares. In Table B, it is of a company limited by guarantee and not having a share capital. In Table C, it is of a company limited by guarantee and having a share capital. In Table D, it is of an unlimited company and not having a share capital. And in Table E is the form of an unlimited company and having a share capital. Now, contents of memorandum. Section 4 of the Companies Act 2013 states that memorandum of a company shall contain the following details. 1. Name. The memorandum of a company shall state the name of the company with the last word limited in the case of a public limited company, or last word private limited in the case of a private limited company. The name stated in the memorandum shall not a. be identical with or resemble too nearly to the name of an existing company, b. be such that its use by the company is undesirable in the opinion of the central government, c. be such that its use by the company will constitute an offence under any law for the time being in force. So the three conditions are mentioned for the name stated in the memorandum. One is that it should not be identical with or resemble any name of an existing company, resemble too nearly. The second condition is that such a name shall not be undesirable in the opinion of the central government. And the third condition is that such a use of the name shall not constitute any offence under any law in the time being in force. Now, Rule 8, Subclause 1 of the Companies Incorporation Rules 2014 give guidelines for the determination whether a proposed name is identical with another or not. So, also the Rule 8, Subclause 2 declares when the name shall be considered undesirable. So, Rule 8, Clause 1 of the Companies Incorporation Rules of 2014 deals with the determination of whether a name proposed is identical with another or not, and Rule 8 Subclause 2 declares when the name shall be considered undesirable. The Emblems and Names Prevention and Improper Use Act 1950. The Emblems and Names Prevention of Improper Use Act 1950 prohibits the use of following names, that is United Nations, the Government of India, State Government, etc. Now, a company shall not be registered with a name which contains any word or expression which is likely to give the impression that the company is in any way connected with or having patronage of central government or state government or any local authority, corporation or body constituted by the central government or any state government. However, a company using such a name can be registered if it has obtained previous approval of the central government for the use of such word or expression. If a company is registered with a name which resembles the name of an existing company, the old company can apply to the court for an injunction to restrain the new company from adopting the identical name. If the names of the two companies contain any word which is in common use, its use cannot be restrained. So, in a case that is Asiatic Government Security Life Insurance Co. Limited versus New Asiatic Insurance Company Limited, that is Asiatic Government Security Life Insurance Co. Limited versus New Asiatic Insurance Company Limited. A company was incorporated under the name New Asiatic Insurance Company Limited. Another company, Asiatic Government Security Life Insurance Company, which was registered earlier, filed a suit for restraining the new company from using the name on the ground that two names resemble to a large extent. The court held that the two names were not identical and the suit was dismissed. In another case, that is Ewing versus Buttercup Margarine Company, that is in 1970. Ewing versus Buttercup Margarine Company, 1917. Here, the plaintiff was carrying on trade under the name Buttercup Dairy Company. A new company registered under the name Buttercup Margarine Company. The plaintiff filed a suit for injunction. The court granted injunction. Now, change of name. The right of a company to alter its memorandum is contained in Section 13 of the Companies Act 2013. A company can at any time change its name. The formalities required are: 1. A special resolution, that is, a resolution passed by 3/4 majority in the general meeting of the members of the company, and second condition, the approval of the central government in writing. If a company changes its name, the registrar shall enter the new name on the register and shall issue a fresh certificate of incorporation. A change of name will not affect any right or obligation of the company. The company continues as if no change has taken place, as in the case of the old wine in new bottle. Now, rectification of name of company. By Section 16, Subclause 1 of the Companies Act 2013, if through inadvertence or otherwise a company on its first registration or on its registration by a new name is registered by a name which a, in the opinion of the central government, is identical with or too nearly resembles the name by which a company in existence had been previously registered, it may direct the company to change its name, and the company shall change its name or the new name within a period of 3 months from the issue of such direction, after adopting an ordinary resolution for the purpose. If an application is made to the central government by a registered proprietor of a trademark alleging that the name of the company is identical with or too nearly resembles to the registered trademark of such proprietor, the central government may direct the company to change its name. If such a direction is given, the company shall change its name after adopting an ordinary resolution for the purpose. After changing the name, the company shall, within a period of 15 days from the date of change, give notice of the change to the registrar along with the order of the central government. The registrar shall carry out necessary changes in the certificate of incorporation and the memorandum. If the company makes default in complying with any direction given by the central government, the company shall be punishable with fine of 1000 rupees for every day during which the default continues, and every officer who is in default shall be punishable with fine which shall not be less than 5000 rupees but which may extend to 1 lakh rupees. Office clause. So after name we have office clause. The second one is office clause. Now, the memorandum of association must mention the state in which the registered office of the company is to be situated. The situation of the registered office of the company determines its domicile and nationality. In the memorandum of association of the company, the office address need to be shown. However, by Section 12 of the Act, a company shall, on and from the 15th day of its incorporation and at all times thereafter, have a registered office capable of receiving and acknowledging all communications and notices as may be addressed to it. The company shall furnish to the registrar verification of the address and some documents of its registered office within a period of 30 days of its incorporation. The verification of the registered office is to be filed in the form number INC 22. The following documents are to be attached along with the form. A. The registered document of the title of the premises of the registered office in the name of the company. B. The notarized copy of lease or rent agreement in the name of the company along with a copy of rent paid received not older than 1 month. C. The authorization from the owner to use the premises by the company as its registered office and proof of ownership. D. The proof of evidence of any utility services like telephone, electricity, etc., showing the address of the premises in the name of the owner which is not older than 2 months. Every company shall paint or affix its name and address of its registered office and keep the same painted or affixed on the outside of every office or place in which its business is carried on in a conspicuous position. The name shall be engraved in legible characters on its seal, if any. Now, seal is not compulsory. If there is a seal, the name should be engraved in legible characters on it. In case of one-person company, the word one-person company shall be mentioned in brackets below the name of such company, wherever the name is printed, affixed, or engraved. Now, change of registered office. The registered office of a company may 1. Change from one place to another place in the same city, town, or village. 2. Change from one town to another town in the same state. 3. Change from one state to another state. In the case of change of office from one place to another place in the same city, town, or village, after changing the office, a verification is to be given to the registrar within 15 days of the change. In case of the change of office from one town to another town, a special resolution is required to be passed at a general meeting of the shareholders, and verification showing address and documents of title is to be filed with the registrar within 15 days. If the change of office has the effect of shifting the office from the jurisdiction of one registrar of companies to that of another within the same state, permission of the regional director must be obtained by filing an application in the prescribed form. The regional director has to confirm the company's application within a period of 30 days. After getting the confirmation of the regional director, the company must file a copy of the confirmation with the registrar of companies within 60 days. The registrar has to register the same and issue a certificate to the company within 30 days from the date of filing of confirmation. In case of shifting of office from one state to another state, a special resolution is required to be passed at the general meeting of the shareholders. In order to effect the alteration, the confirmation of the central government is to be obtained. When the confirmation is given by the central government, a certified copy of the order confirming the alteration shall be filed with the registrars of both the states. All the records of the company shall be transferred to the registrar of the state in which the registered office of the company is transferred. Now, the third clause in Memorandum of Association is the Object Clause. The Memorandum of Association of every company shall clearly state the objects of the company. So, first one is Name Clause, second one is the Office Clause, and then the third one is the Object Clause. The Object Clause shall state 1. The objects for which the company is proposed to be incorporated, the main objects. 2. Matters considered necessary for furtherance of main objects, that is incidental or ancillary matters to the attainment of the main objects. So, we are discussing the same case law we discussed earlier, that is Ashbury Railway Carriage Iron Company versus Rish, here 1875. Here the court held that the statement of objects in the memorandum has two purposes. It states affirmatively the ambit and extent of vitality and power of the company. 2. It states negatively that nothing shall be done beyond that ambit. Now, in this respect, we have doctrine of ultra vires. A company has power to do all acts which are recognized by the Companies Act and the Memorandum of Association. If a company does an act beyond the power conferred under the Companies Act or Memorandum of Association, the act will be ultra vires. Such an act is absolutely void. Even the whole body of the shareholders cannot ratify it and make it binding on the company. So in Ashbury case we discussed earlier, the company was formed with the object of carrying on business as mechanical engineers and general contractors. The directors of the company entered into an agreement with Risch to finance the construction of the railway line in Belgium. The contract was repudiated by the company subsequently. Risch filed a suit for breach of contract. The House of Lords held that the contract was beyond the scope of memorandum and thus ultra vires, and thus it is not binding on the company even though it was ratified by the shareholders. Then we have another case, that is A. Lakshmanaswamy Mudaliar versus LIC, that is 1963. A. Lakshmanaswamy Mudaliar versus LIC. Here, the directors of the company decided to donate 2 lakh rupees to a memorial trust. The shareholders have passed a resolution accepting the decision of the directors. The primary object of the company was to carry on life insurance business. Donating money to a memorial trust is not main or incidental object of the company. So the court held that the decision to donate money to the memorial trust is ultra vires. A company is competent to do all acts within the objects specified in the memorandum and it cannot travel beyond the objects. So, what is the effect of ultra vires transactions? So, the first one is injunction. Whenever an ultra vires act is about to be done, any member of the company can obtain an injunction against the company to restrain it from proceeding further. The second one is personal liability of the directors. If the capital of the company is used by the directors for ultra vires act, that purpose they will be personally liable. Third one is breach of warranty. If an outsider is induced to enter into a contract with the company by the directors, the outsiders can file a case against the directors for his loss resulted from the ultra vires contract. This is breach of warranty. Now, property acquired under ultra vires act. That is the fourth one. If the capital of the company is used to purchase some property, the company's right over such property will be declared valid even though the purchase is ultra vires to the object of the company. Ultra vires contracts. If a company has lent money to an outsider, it can recover it from the debtor even though the contract is ultra vires. If an outsider lends money to the company under an ultra vires contract, he has only the remedy of restitution. Now, change of objects. By section 13 subclause 8 of the Act, a company which has raised money from the public through prospectus and still has any unutilized amount out of the money so raised shall not change its objects for which it is raised the money through prospectus unless a special resolution is passed by the company. A special resolution is to be passed through postal ballot. The notice of the resolution for altering the objects shall contain the following matter. 1. The total money received. 2. The total money utilized for the objects stated in the prospectus. 3. The utilized amount of the money so raised through prospectus. 4. The particulars of the proposed alteration or change in the objects. 5. The justification for alteration or change in the objects. 6. The amount proposed to be utilized for the new objects. 7. The estimated financial impact of the proposed alteration on the earning and cash flow of the company. 8. the other relevant information which is necessary for the members to take an informed decision on the proposed resolution. 9. The place from where any interested person may obtain a copy of the notice of resolution to be passed. So, as per Section 13, Subclause 8 of Companies Act 2013, the details of the proposed resolution shall also be published in the newspaper, one in English and one in vernacular language, which is in circulation at the place where the registered office of the company is situated, and shall also be placed on the website of the company, if any, indicating therein the justification for such change. The dissenting shareholders shall be given an opportunity to exit by the promoters and shareholders having control in accordance with the regulations to be specified by the Securities and Exchange Board. The registrar shall register any alteration of the memorandum with respect to the objects of the company and certify the registration within a period of 30 days from the date of filing of the special resolution. Now the fourth clause is the liability clause. The memorandum must contain a statement as to the liability of the members of the company. The liability of the members may be limited by shares or unlimited or limited by guarantee. In case of a company limited by shares, it is to be stated in the memorandum that the liability of its members is limited to the amount unpaid, if any, on the shares held by them. In the case of a company limited by guarantee, it is to be stated in the memorandum the amount which each member undertake to contribute to the assets of the company in the event of it being wound up. Now, the fifth clause is the capital clause. The memorandum shall contain the amount of share capital with which the company is proposed to be registered and the division of it into shares of a fixed amount. The capital with which the company is registered is called registered capital or authorized capital or nominal capital. Alteration of capital clause. By Section 61 of the Act, a company limited by shares can alter its share capital if so authorized by the Articles of Association. The share capital can be altered by increasing its authorized capital or consolidating and dividing all or any part of its share capital into shares of larger amount or convert fully paid share into stock. That is, the share capital can be altered by increasing its authorized capital, that is option 1, or consolidating and dividing all or any part of its share capital into shares of larger amount. And the third option is convert fully paid shares into stock. So these are the three methods one can use to alter the shared capital. Now, an ordinary resolution shall be passed in the general meeting to exercise the power of alteration. The company must give notice of alteration to the registrar within 30 days. That is mentioned in Section 64. And the sixth clause is association and subscription clause. That is the final clause in Memorandum of Association. Association and subscription clause. So here in the association and subscription clause of a public company, there should be at least 7 subscribers and they should have signed and should be attested by the witnesses. In case of a private company, at least 2 persons should subscribe and put their signatures. The name and address of the subscribers should be mentioned in the clauses. The subscribers should have given an undertaking to take shares from the company. The number of shares each subscriber has undertaken to take should be mentioned in this clause. Even though a subscriber has not taken the agreed share, he will be liable to pay the value of such share at the time of company's winding up. So we discussed regarding contents of the memorandum of association. We discussed 4 clauses, and first one is the name clause, and second one is the office clause, third one the object clause, and the fourth one is the liability clause, fifth one is the capital clause, and the sixth one association and subscription clause. So that is with memorandum of association. The next topic we have is articles of association. Articles of association is another document which is to be produced along with the memorandum for registration of a company. Section 5, subclause 1 of the Companies Act 2013 says that the articles of a company shall contain regulations for management of the company. The Articles of Association is a document that contains rules and regulations relating to the internal management of the company. By Section 5, subclause 6 of the Act, the articles of a company shall be in respective forms specified in tables F, G, H, I, and J in Schedule 1. So with respect to Memorandum of Association, we discussed table A, B, C, D, and E in Schedule 1. So with respect to Articles of Association, we will be discussing about table F, G, H, I, and J in Schedule 1 as may be applicable to such company. Table F to J are model articles of association of different kinds of companies. Table F is for company limited by shares. Table G for company limited by guarantee and having a share capital. Table H, company limited by guarantee and not having a share capital. Table I, unlimited company having a share capital. Table J, unlimited company not having a share capital. By Section 5, subclause 7 of the Act, a company may adopt all or any of the regulations contained in the model articles applicable to such company. The Articles of Association should be printed and divided into paragraphs and consecutively numbered. It must be signed by the subscribers to the memorandum, and the signatures are to be attested by witnesses. An article of association shall contain provisions for the following purposes: 1. Share capital and variation of rights. 2. Underwriting commission. 3. Lien on shares. 4. Calls on shares. 5. Transfer of shares. 6. Transmission of shares. 7. Forfeiture of shares. 8. Alteration of capital. 9. Capitalization of profits. 10. Buyback of shares. 11. General meetings. 12. Proceedings at general meetings. 13. Adjournment of meeting. 14. Voting rights of members. 15. Proxy. 17. Board of directors. Then 18. Proceedings of the board. 19. Chief executive officer, manager, company secretary or chief finance officer. 20. The seal of the company. 21. Dividends and reserve. 22. Accounts. 23. Winding up. And 24. Indemnity. In indemnity, the clause, the right of officer of the company to be indemnified out of the asset of the company against any liability incurred by him in defending any proceedings, whether civil or criminal, in which judgment is given in his favor, or in which he is acquitted, or in which relief is granted to him by the court or tribunal, will be provided. Now, alterations of articles. By Section 14 of the Act, the Articles of Association of Company can be altered only by a special resolution. alteration should not be contrary to the provisions of the Memorandum of Association or the Companies Act. The alteration of the articles by special resolution may be to the effect of conversion of a private company into a public company, or a public company into a private company. If a private company alters its articles in such a manner that they no longer include the restrictions and limitations which are required to be included in the articles of a private company under the Act, the company shall, as from the date of such alteration, cease to be a private company. Any alteration having the effect of conversion of a public company into a private company shall not take effect except with the approval of the tribunal. So, in a private company alters its articles in such a manner that they no longer include the restriction and limitations which are required to be included in the articles of a private company under the Act, the company shall, as from the date of such alteration, cease to be a private company. But when it comes to the other conversion, that is conversion of a public company into a private company, then it shall, any alteration having the effect of conversion of a public company into a private company shall not take effect except with the approval of the tribunal. Every alteration of the articles and a copy of the order of the tribunal approving the alteration shall be filed with the registrar together with the printed copy of the altered articles within a period of 15 days. Who shall register the same? Any alteration of the articles registered shall be valid as if it were originally in the articles. Now, the provisions for entrenchment. The power to alter the articles is a statutory power, and any provision in the articles making the articles unalterable is void. If the articles of a company contain any restriction that the company shall not alter its articles, it will be contrary to the Companies Act and therefore inactive. However, by Section 5 subclause 3, the articles may contain provisions for entrenchment to the effect that specified provisions of the articles may be altered only if conditions and procedures as that are more restrictive than those applicable in the case of a special resolution are met or complied with. The provisions for entrenchment shall only be made either on formation of a company or by an amendment in the articles agreed to by all the members of the company in case of a private company, and by a special resolution in the case of a public company. If the articles contain provisions for entrenchment, whether made on formation or by amendment, the company shall give notice to the registrar of such provisions in the prescribed form. There is a case law, that is Mallison versus National Corporation 1894. In Mallison versus National Corporation 1894, it was held that a provision in the articles depriving the company of its power of alteration would be void. A company may alter its articles at any time by passing a special resolution. The provisions of articles cannot be altered by an ordinary resolution. Even clerical errors in the articles should be set right by a special resolution. Any alteration having the effect of conversion of a public company into a private company shall not take effect except with the approval of the National Company Law Tribunal. There is a case law again, that is in Madhrubhumi Painting and Publishing Company versus Vardhavamar Publishing Limited. Madhrubhumi Printing and Publishing Co. Limited, Vardhavamar Publishing Limited, 1992. Here the Kerala High Court held that the power conferred on the company under Section 31 to alter the articles by special resolution should not be abused by the majority of the shareholders in order to oppress the minority. So, in Madhubhumi Printing and Publishing Co. versus Vardhamar Publishing Limited, 1992, the Kerala High Court held that the power conferred on the company under Section 31 to alter articles by special resolution should not be abused by the majority of shareholders in order to oppress the minority. The alteration must not sanction anything which is illegal. The alteration must be made bona fide for the benefit of the company. The alteration must not constitute an oppression or a fraud on the minority shareholders. In another case law, that is Brown versus British Abrasive Wheel Co. Limited, 1919, a company was in financial difficulties. The majority of the shareholders were willing to provide more capital if the remaining shareholders, that is about 2% of the whole, would sell them their shares. The majority then passed a special resolution of altering the articles of association so as to enable the 98% of the shareholders to buy out any other shareholders. The court held that the alteration was not made bona fide for the benefit of the company. It is an oppression on the minority shareholders. The alteration must not in any way increase the liability of the existing members to contribute to the share capital of the company unless they agree in writing. So the case law we discussed is Brown versus British Abrasive Wheel Co., where the 98% of the shareholders agreed to increase the capital, provide more capital if the remaining 2% would sell them their shares. The court found this as being oppressive and not made in bona fide. So it was not upheld. This alteration was not upheld. Now the alteration must not be in any way increases the liability of the existing members to contribute to the share capital of the company unless they agree in writing. If the company is a club or association formed for the purpose of promoting art, the articles may be altered to provide for subscription at a higher rate. The alteration must not cause a breach of contract with an outsider. A company cannot, by altering the articles, justify a breach of contract. In Southern Foundries Limited versus Shirlaw, 1940, the plaintiff was appointed as a managing director of the company. The appointment was for 10 years. After 2 years, the company was amalgamated with another company. The new articles empowered the dismissal of the managing director. The plaintiff was dismissed from the service. He claimed compensation for dismissal. The court held that a company cannot justify a breach of contract by altering the articles. So this was held in Southern Foundries Limited versus Sherlaw in 1940. In Articles of Association is altered by a special resolution. The altered articles is to be registered with the Registrar of Companies. It is to be done within 15 days of passing of the resolution. In case approval of tribunal is required, the copy of the approval order is also to be produced along with the altered articles for registration. Effects of registration of memorandum and articles. By Section 10, Subclause 1 of the Act, the memorandum and articles shall, when registered, bind the company and the members thereof to the same extent as if they respectively had been signed by the company and by each member, and contained covenants on its and his part to observe all the provisions of the memorandum and of the articles. By Section 2, Subclause 2, by Section 10, Subclause 2, all monies payable by any member to the company under the memorandum or articles shall be a debt due from him to the company. So with respect to Articles of Association, we discussed it need special resolution and it is discussed under Section 5. Now we also discussed about the tables F, G, H, I and J in Schedule 1, and then Article 14 for alteration of articles, and the effect when the conversion takes place from a private company to public company, and how it is different from a public company conversion into a private company. Then we discussed about the provision of entrenchment. Then we discussed few case laws, how it is not fair, it is not allowed, legally allowed, and not bona fide for the majority shareholders to oppress the minority shareholders, and the alteration should be in benefit of the company. Further, the alteration shall not increase the liability of a member unless they have agreed to it in writing. So these were discussed in articles of association, and the effect of registration of memorandum and articles were discussed with respect to section 10 subclause 1 and section 10 subclause 2. So that is with articles of association. The next topic is constructive notice of memorandum and articles. The memorandum and articles of association of a company are to be registered with the registrar of companies. On registration, they become public documents. They are open for public inspection in the office of registrar of companies on payment of prescribed fee. Every person dealing with the company is presumed to have read the memorandum and articles of association and is deemed to have knowledge of the contents of these documents. This imputation of knowledge is known as constructive notice of memorandum and articles of association. In a case, Kotla Venkataswamy versus Ramamurthy, Kotla Venkataswamy versus Ramamurthy, 1934, the articles of association of a company required that all deeds should be signed by the managing director, the secretary, and a working director on behalf of the company. The plaintiff accepted a deed of mortgage executed by the secretary and a working director. The court declared the mortgage invalid. The court held that the plaintiff had constructive notice of the contents of the articles. Now, in Rajendra Nath Datta versus Shibendra Nath Mukherjee, 1982. Rajendra Nath Datta versus Shibendra Nath Mukherjee. In this case, the court held that the articles of association of a company is a public document, and anyone who deals with a registered company must have taken notice of the articles. By operation of the doctrine of constructive notice, every person dealing with a company is presumed to have knowledge of the contents of memorandum and articles of association. The doctrine of constructive notice operates against outsiders who are dealing with a company. The doctrine prevents them from alleging that they have no knowledge that the memorandum and articles of the company rendered a particular act ultra vires. However, this doctrine is subject to the limitations contained in the principles of indoor management. The next topic is doctrine of indoor management, also known as check and rule. The doctrine of indoor management is a limitation on the doctrine of constructive notice. The doctrine of indoor management allows outsiders who are dealing with a company to assume that, as far as the internal proceedings of the company are concerned, everything has been properly done. Anyone who is dealing with a company is bound to read the registered documents. They must see that the proposed dealing is not inconsistent with the memorandum and articles of the company. However, they need not inquire into the regularity of the internal proceedings as required by the memorandum and articles. This limitation to the doctrine of constructive notice is known as the doctrine of indoor management, or the rule in Turkman's case. The doctrine of constructive notice imposes a duty upon those who are dealing with a company to know the constitution of the company. It tries to protect the company against outsiders. The doctrine of indoor management, on the other hand, allows those who are dealing with the company to dispense with the knowledge of what is taking place within the doors that are closed to them. They can assume that the company's internal regulations, which are necessary to implement a contract, have been complied with. The doctrine of indoor management seeks to protect outsiders against the company. Royal British Bank versus Turkwand, 1856. Royal British Bank versus Turkwand. Royal British Bank lent £2,000 to a company. The director of the company gave a bond to Royal British Bank.
The articles of the company had empowered them to issue such bonds provided they were authorized by a resolution passed by the shareholders at a general meeting of the company. Royal British Bank sued Turquand, who was the managing director of the company, for the amount due on the board. The company claimed that the resolution authorizing the directors to issue bonds had not been passed and thus the bond was issued without authority. The court held that Royal British Bank could recover the amount of the bond from the company on the ground that the Royal British Bank was entitled to assume that the required resolution has been passed. The doctrine of indoor management is based on public convenience and justice. So this doctrine of indoor management is based on public convenience and justice. Exceptions to the doctrine of indoor management. There are certain exceptions to the doctrine of indoor management. They are 1. Knowledge of irregularity. So, knowledge of irregularity is one of the exceptions to the doctrine of indoor management. If a person who is dealing with a company has actual or constructive notice of the irregularities regarding the internal management, he is not allowed to claim the benefit under the doctrine of indoor management. Howard versus Pallant Ivory Company, that is 1888 case. Howard versus Pallant Ivory Company. The articles of the company empower the directors to borrow up to £1,000 without approval of the shareholders in the general meeting. But for any amount beyond £1,000, they had to obtain the consent of the shareholders. H. Howard was a director of the company. He lent to the company an amount of £2,000 without consent of the shareholders. The court held that the director had the notice of the internal irregularity and hence the company was liable to pay only £1,000. Now T.R. Pratt Bombay Limited versus E.D. Sasson and Co. Limited. Here the director of the company A and company B was same. Company A lent money to company B on a mortgage of its asset. The procedure prescribed in the articles were not complied with. The court held that the lender had notice of the irregularities and hence the mortgage was not binding. Now the second exception to the doctrine of indoor management is negligence. So the first one is knowledge of irregularity and the second one is negligence. If a person who is dealing with a company could discover the irregularities by proper inquiry, he cannot claim the benefit of the rule of indoor management. So here Anand Bihari Lal versus Dinshaw and Company. Anand Bihari Lal versus Dinshaw and Company, 1942. Here the accountant of a company sold company's property to A. The transaction was apparently beyond the scope of accountant's authority. The court held that A could not claim the benefit of Turquand rule. He ought to have made proper inquiry as the authority of the accountant. Now the third exception to the doctrine of indoor management is forgery. The protection of indoor management will not be available in the case of forgery committed by the company's officials. If the secretary of a company has forged signatures of directors in the share certificate and issued it to an outsider under the seal of the company, the outsider cannot claim protection of the indoor management. Forgery makes a document void. So that is with the doctrine of indoor management, also known as the rule in Turquand case or Turquand rule. So we discussed three exceptions to the doctrine of indoor management, that is knowledge of irregularity, negligence and forgery. And the doctrine of indoor management itself is a limitation on the doctrine of constructive notice. The next topic is prospectus. After the incorporation of a company, it can raise necessary finance for the conduct of its business by issuing securities, that is shares and debentures. A public company may issue securities A to public through prospectus, also known as public offer, or B through private placement, or through rights issue or a bonus issue. So this is regarding a public company. A private company may issue securities A by way of rights issue or bonus issue, or B through private placement. So the issue of securities to public through prospectus, known as public offer, is available only for a public company. A public company can invite the general public to subscribe its shares and debentures through prospectus. A prospectus is a document issued by the public company in order to invite the public to make offers for shares and debentures of the company. A private company cannot issue prospectus to invite the public to subscribe its shares or debentures. A prospectus inviting the public to make offers for its shares or debentures is a window through which a proposed investor can look into the soundness of the company. Section 2, Subclause 70 of the Companies Act 2013 defines the term prospectus. Any document described or issued as a prospectus, or any notice, circular, advertisement, or other document inviting offers from the public for the subscription or purchase of any securities of a body corporate can be called a prospectus. It includes a red herring prospectus and a shelf prospectus. Every prospectus issued by a public company shall be dated and signed by the directors and shall state the following information. 1. Names and addresses of the registered office of the company, company secretary, chief financial officer, auditors, legal advisors, bankers, and underwriters. 2. Dates of the opening and closing of the issue. 3. A statement by the board of directors about the separate bank account where all monies received out of the issue are to be transferred. 4. A statement by the board of directors disclosing detail of all monies utilized and unutilized monies out of the previous issue. 5. Details about the underwriting of the issue. 6. Consent of the directors, auditors, and bankers to the issue. 7. Procedure and time schedule for allotment and issue of securities. 8. Capital structure of the company. 9. Main object of the public offer. 10. Main objects and present business of the company and its location, schedule of implementation of the project. 11. Risk factors specific to the project. 12. Gestation period of the project. 13. Extent of progress made in the project. 14. Deadlines for completion of the project. 15. Any litigation or legal action pending or taken by a government department or a statutory body during the last 5 years against the promoter of the company. Then 16. Minimum subscription and amount payable by way of premium. 17 is detail of directors, appointment, remuneration, etc. And 18, report of auditor with respect to its profit and losses and assets and liabilities. So these information shall be included in the prospectus being issued along with the date and sign of the directors. Date of issue and sign of the directors. So a copy of the prospectus duly signed by every director or proposed director must be delivered to the registrar before its publication for the registration. On the face of the prospectus, it should be mentioned that a copy of it has been delivered to registrar for registration. The prospectus should be issued within 90 days after the date on which a copy was delivered to the registrar of registration. If a prospectus is issued without a copy delivered to the registrar for registration, the company and every person responsible for the issue of prospectus are liable to be punished. The company shall be punished with fine which shall not less than 50,000 rupees but which may extend to 3 lakh rupees. Every person who is responsible for the issue shall be punishable with imprisonment for a term which may extend to 3 years or with fine which shall not be less than 50,000 rupees but which may extend to 3 lakh rupees. Now, securities to be dealt with within stock exchanges. By Section 40 of the Act, every company making public offer shall, before making such offer, make an application to one or more recognized stock exchange or exchanges and obtain permission for the securities to be dealt within such stock exchange or exchanges. This is by Section 40 of Companies Act 2013. By Section 40, Subclause 3 of the Act, all monies received on application from the public for subscription to the securities shall be kept in a separate bank account in a scheduled bank and shall not be utilized for any purpose other than a. For adjustment against the allotment of securities, if the securities have been permitted to be dealt with in the stock exchange specified in the prospectus. B. For repayment of monies within the time specified by the Securities and Stock Exchange Board received from applicants in pursuance of prospectus, where the company is for any other reason unable to allot securities. If any default in complying with the above said provisions, the company shall be punishable with a fine which shall not be less than 5 lakh rupees, but which may extend to 50 lakh rupees, and every officer of the company who is in default shall be punished with imprisonment for a term which may extend to 1 year, or with fine which shall not be less than 50,000 rupees, but which may extend to 3 lakh rupees, or with both. Now, misstatement in prospectus and the consequence. So, this is also known as the golden rule of prospectus. Prospectus is a window through which an investor can look into the soundness of a company's venture. It must give investors a complete picture of company's activities and its position. The prospectus must make fullest disclosure of all materials and essential particulars of the company. A prospectus is a document which gives information to the public as the company's sound or to the company's soundness. The prospectus must be full, frank, and honest disclosure of all material facts with scrupulous accuracy. No material fact should be misstated or withheld. Greatest care should be taken in its preparation. The persons who are responsible for the preparation and issue of prospectus should not only state all relevant facts but also not to omit any material facts. This is the golden rule as to framing of prospectus. This rule was laid down in New Brunswick and Canada Railway and Land Co. versus Muggeridge. So this rule, the golden rule of framing prospectus, was laid down in New Brunswick and Canada Railway and Land Company versus Muggeridge in 1860. Now the liability of misstatements. A misstatement in a prospectus gave rise to civil as well as criminal liability. With respect to civil liability, a person who was induced to subscribe shares of a company on the faith of a misstatement in the prospectus has fourfold civil remedies. So, first remedy is rescission of contract. Anyone who purchases shares from a company on the faith of a misstatement in the prospectus can apply to the court for the rescission of the contract. Ross versus Estate Investment Company, 1868. Ross versus Estate Investment Company, 1868. The prospectus of a company contained a statement that the company had contracted for purchase of a property, but in fact there was only negotiation for such purchase. The court held that it was misstatement, and a person who purchased shares on the faith of the prospectus can file a suit for rescission of the contract. Henderson versus Lacan, 1867. Henderson versus Lacan. The prospectus of a company stated that the directors and their friends had subscribed large portions of capital and the remaining shares only are offered to the public. The fact was that the directors had only subscribed 10 shares. The court held that the subscribers could resign the contract. Now, Rex versus Lord Kilsont. Rex versus Lord Kilsont. A prospectus issued by a company stated that it paid dividend every year between 1921 to 1927. That is the years of depression. The company paid dividend out of the past reserves. Actually, the company was running at a loss during that period. The court held that there is a suppression of material fact and it amounts to misstatement. The shareholders could rescind the contract. Now, the rescission of contract was the first remedy in civil liability, and the second, we have 4 remedies under civil liability, and the second remedy is damage for deceit. If a person is induced to take shares from a company on the faith of misstatement in the prospectus, he can sue the company for the compensation. So, damage for deceit is the second remedy in civil liability. And the third remedy is sued against directors for compensation. A person who has taken shares of a company on the faith of misstatement or fraud in the prospectus can claim compensation from the directors who are responsible for the issue of prospectus. Terry vs. Peake, 1889. Terry vs. Peake. In this case, the directors made a misstatement without fraudulent intention, and the court held that since there is only misrepresentation, the directors are not liable to pay compensation. As a consequence of the decision in Terry vs. Peake, the Directors' Liability Act was passed in England in 1890. The Act imposes personal liability upon the directors even for innocent misrepresentation. Now, the last remedy under civil liability is the liability under Section 35 of the Companies Act. By virtue of Section 35 of the Companies Act 2013, the directors and every person, the promoters and experts responsible for the issue of prospectus are liable to pay compensation to the subscriber of shares on the faith of false statement in the prospectus. That was with civil liability. Misstatement in prospectus also has criminal liability. Section 34 of the Companies Act 2013 prescribes punishment for the issue of prospectus containing untrue statements. Every person who is responsible for the issue of prospectus containing untrue or misleading statements shall be punishable for the offence of fraud. The punishment for fraud is provided in Section 447 of the Act. 447, Section 447 of Companies Act 2013. By Section 447, any person who is found to be guilty of fraud shall be punishable with imprisonment, which shall not be less than 6 months, but which may extend to 10 years, and shall also be liable to fine, which shall not be less than the amount involved in the fraud, but which may extend to 3 times the amount involved in the fraud. So that is with the checkpoint rule. That is with the prospectus. So we have discussed how a public company can issue securities, how a private company can issue securities, and what is the difference, and what should be contained in a prospectus, and that it should be dated and signed by the directors, and what are the penalties if there is a misstatement, and in case of public offers, how to carry out the procedure. That is discussed in Section 40. So that was discussed here in with respect to prospectus. So we discussed about prospectus, and now we will be discussing about the private placement. What is private placement? In prospectus, we read that there can be public offer, private placement, and different kind of prospectus. So the 3 ways in public company was public offer, private placement, and through rights issue and bonus issue. So right now, once we have discussed about prospectus, now we are going to look into what is private placement. A public company may issue securities, A, to public through prospectus known as public offer, then B, through private placement, C, through rights issue or bonus issue. A private company may issue securities, A, by way of rights issue or bonus issue, B, through private placement. So, The expression private placements means any offer of securities or invitation to subscribe securities to a select group of persons by a company, other than by way of public offer through issue of private placement offer letter. By Section 42 of Companies Act 2013, a company may make private placement through issue of private placement offer letter. A company shall not make a private placement of its securities unless the proposed offer of securities have been previously approved by the shareholders of the company by a special resolution for each of the offers. The offer of securities or invitation to subscribe securities shall not be made to more than 200 persons in the aggregate in a financial year. Any offer made to qualified institutional buyers or to employees of the company under a scheme of employees' stock option shall not be considered while calculating the limit of 200 persons. The restriction of 200 persons would be reckoned individually for each kind of security, that is equity share, preference shares or debentures. All offers shall be made only to such persons whose names are recorded by the company prior to the invitation to subscribe. The offer should be made to them by name. It should be accompanied by an application addressed to the person to whom the offer is made. It should be sent to him either in writing or in electronic mode within 30 days from the recording the names of such persons. The value of such offer per person shall be with an investment size of not less than 20,000 rupees of face value of the securities. A complete record of private placement offers shall be kept by the company, and complete information about such offer shall be filed with the registrar within the period of 30 days from the date of making private placement offer. The payment to be made for subscription to the securities shall be made from the bank account of the person subscribing to such securities, and the company shall keep the record of the bank account from where such payments for subscription have been received. Statement in lieu of prospectus. Section 70 of the Companies Act 1956 dealt with statement in lieu of prospectus. Please note it's Section 70 of Companies Act 1956. Now, if the promoters of a public company were confident of obtaining the required capital by issuing share to their friends and relatives, no prospectus need be issued to the public. In such a case, they had to prepare a draft prospectus containing the information required for an actual prospectus. This document is called Statement in lieu of prospectus. A copy of it ought to have filed with the registrar before 3 days of any allotment of shares. Such statement should not contain any false statement. If a statement in lieu of prospectus contained any untrue statement, any person who authorized the delivery of the statement in lieu of prospectus for the registration was punishable with imprisonment for a term which may extend to 2 years, or with fine which may extend to 50,000 rupees, or with both. So that is regarding private placement. The next topic is shelf prospectus. Section 31 of the Companies Act 2013 provides for filing of shelf prospectus with the registrar. Shelf prospectus means a prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues over a certain period without issue of a further prospectus. The general principle regarding the issue of securities is that whenever a public company offers to the public to subscribe its securities, it has to issue a prospectus. But in the case of notified companies, by filing a shelf prospectus, the requirement of issuing prospectus on every issue of securities can be avoided. Any class or class of companies, as the Securities and Exchange Board of India (SEBI) may provide by regulation in this behalf, may file a shelf prospectus with the registrar of companies. A company filing a shelf prospectus with the registrar shall not be required to file prospectus afresh at every stage of offer of securities by it within the period of validity of such shelf prospectus. A shelf prospectus shall be valid for a period of 1 year from the date of opening of the first issue of securities under that prospectus. A company filing a shelf prospectus shall also file an information memorandum on all material facts relating to new charges created and changes in the financial position prior to the making of a second or subsequent offer of securities under the shelf prospectus. When an information memorandum is filed every time an offer of securities is made, such memorandum, together with a shelf prospectus, shall be deemed to be prospectus. So, shelf prospectus means a prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issue over a certain period without issue of a further prospectus. So, that is with shelf prospectus. And the next topic is red herring prospectus. Section 32 of the Companies Act 2013 provides for the issue of red herring prospectus. It means a prospectus which does not include complete particulars of the quantum or price of the securities included therein. A company proposing to make an offer of securities may issue a red herring prospectus prior to the issue of a prospectus. A company proposing to issue a red herring prospectus shall file it with the registrar at least 3 days prior to the offer and opening of the subscription list. Upon the closing of the offer of securities, the prospectus stating therein the total capital raised, whether by way of debt or share capital, and the closing price of the securities and any other detail as are not included in the red herring prospectus shall be filed with the registrar and Securities Exchange Board of India, that is SEBI. A red herring prospectus shall carry the same obligation as are applicable to a prospectus, and any variation between the red herring prospectus and a prospectus shall be highlighted as variations in the prospectus. That is with red herring prospectus. Now, issuing houses and deemed prospectus, that is the next topic. Issuing houses and deemed prospectus. The provisions relating to the preparation and issue of prospectus are most stringent. The company and persons responsible for the issue of prospectus are liable for misstatement in the prospectus. In order to evade the onerous requirements, a company may allot the whole of the shares or debentures to an intermediary known as issuing house without offering the shares or debentures to the public. The issuing house then offers the shares or debentures to the public by means of an advertisement of its own. The advertisement, in the strict sense, is not a prospectus issued by the company. Thus, the company can evade the rules applicable to the issue of prospectus and the liability resulting from the misstatement. In order to avoid such practices, Section 25 of the Companies Act 2013 provides that an offer for sale advertised by an issuing house shall be deemed to be a prospectus issued by the company. That is discussed in Section 25 of the Companies Act 2013, which provides that an offer for sale advertised by an issuing house shall be deemed to be a prospectus issued by the company. Thus, the responsibility of the company, its directors and promoters for misstatement in the advertisement shall be the same as if it is the company's prospectus. So that is with the type of prospectus. So the next topic is global depository receipts. By Section 41, a company may, after passing a special resolution in its general meeting, issue depository receipts in any foreign country. Section 2, subclause 44 of the Act defines the expression global depository receipt. It means any instrument in the form of a depository receipt by whatever name called created by a foreign depository outside India and authorized by a company making an issue of such depository receipts. So, global depository receipt? It means any instrument in the form of a depository receipt by whatever name called, created by a foreign depository outside India and authorized by a company making an issue of such depository receipts. The manner and condition for such issue are provided in the company's Issue of Global Depository Receipts Rules of 2014. A company may issue depository receipt provided it is eligible to do so in terms of the scheme and relevant provisions of the Foreign Exchange Management Rules and Regulations. So it should be eligible in terms of the scheme and relevant provisions of the Foreign Exchange Management Rules and Regulations. The word scheme means the foreign currency convertible bonds and ordinary shares through Depository Receipt Mechanism Scheme 1993. So the word scheme means foreign currency convertible bonds and ordinary shares through Depository Receipt Mechanism Scheme 1993. The depository receipts shall be issued by an overseas depository bank appointed by the company, and the underlying shares shall be kept in the custody of a domestic custodian bank. The underlying shares shall be issued in the name of the overseas depository bank, and against such shares the depository receipts shall be issued by the overseas depository bank abroad. A holder of the depository receipt may become a member of the company and shall be entitled to vote as such only on conversion of the depository receipts into underlying shares after following procedures provided in the scheme and provisions of the Companies Act. The proceeds of the issue of depository receipts shall either be remitted to a bank account in India or deposited in an Indian bank operating abroad, or any foreign bank having operations in India, with an agreement that the foreign bank shall take responsibility for furnishing all information which may be required, and in the event of a sponsored issue of depository receipt, the proceeds of the sale shall be credited to the respective bank account of the shareholder. So that is with global depository receipt. It is discussed under section 41 and defined under section 2 subclause 44. And here the scheme means foreign currency convertible bonds and ordinary shares through depository receipts mechanism schemes of 1993. So that is with global depository receipts. The next topic is share capital. The word share capital refers to the money raised by the issue of shares. A company limited by shares can issue shares. The share capital of the company can be classified under several heads. They are as follows. 1. Nominal capital or authorized capital or registered capital. In the memorandum of a company, there will be provision for the maximum capital which the company can collect by issuing shares. This is known as the authorized or nominal or registered capital. Now the second one is issued capital. It is the aggregate nominal value of shares which are offered to the public for subscription. That is issued capital. It is an aggregate nominal value of shares which are offered to the public for subscription. Third one is subscribed capital. It is a part of the issued capital which is taken up by the public. Subscribed capital is that part of the issued capital which is taken up by the public. The fourth one is called up capital. It is the aggregate of the amount called up on the shares actually subscribed. Called up capital, it is the aggregate of the amount called up on the shares actually subscribed. Now the fifth one is paid up capital. It is a part of the subscribed capital which is paid up by the shareholders. So paid up capital is the part of the subscribed capital which is paid up by the shareholders. The sixth one is the uncalled capital. It is a part of the subscribed capital which is not yet called up. So, called up capital is the aggregate of the amount called up on the shares actually subscribed. Uncalled capital is the part of the subscribed capital which is not yet called up. Then we have the last one, reserved capital. This is the part of the uncalled capital which can be called only at the time of winding up of the company. So reserved capital is a part of the uncalled capital which can be called only at the time of winding up of the company. So 7 type of capitals are discussed. That is, the capital of the company is classified under several head. We discussed 7 of them. That is nominal or authorized or registered capital, then the issued capital, then the subscribed capital, then the called up capital, then the paid up capital, then the uncalled capital and the reserved capital. By Section 43 of Companies Act 2013, the share capital of a company is limited by shares shall be of 2 kinds, namely equity share capital and preference share capital. So that we have equity share capital and preference share capital. By Section 43 of the Companies Act, the share capital of the company limited by shares shall be of 2 kinds, equity share capital and preferential share capital. Equity share capital. It means all share capital of a company limited by shares other than preference share capital. It may be with voting rights or with differential right as to dividend or voting. Rules applicable to equity shares with differential rights. A company limited by shares can issue equity shares with differential rights as to dividend or voting. Rule 4 of the company's Share Capital and Debentures Rules 2014 prescribes the conditions to be satisfied for issuing equity shares with differential rights as to dividend or voting. That is Rule 4 of Companies Share Capital and Debentures Rules of 2014 prescribes the conditions to be satisfied for issuing equity shares with differential right as to dividend or voting. 1. Condition number 1. The articles of association of the company should authorize the issue of shares with differential rights. 2. The issue of shares with differential rights should be authorized by an ordinary resolution passed at a general meeting of the shareholders. If the equity shares of the company are listed on a recognized stock exchange, the issue of shares with differential rights shall be approved by the shareholders through postal ballot. Third condition, the shares with differential rights shall not exceed 26% of the total post-issue paid up equity share capital, including equity share with differential rights issued at any point of time. So the third condition is that the shares with differential rights shall not exceed 26% of the total post-issue paid up equity share capital, including equity share with differential right issued at any point of time. Then we have the fourth point, that is, the company should have consistent track record of the distributable profit for the last 3 years. The fifth point, the company should not have defaulted in filing financial statements and annual returns for 3 financial years immediately preceding the financial year in which it is decided to issue such shares. The company has no subsisting default in the payment of a declared dividend to its shareholders, or repayment of its matured deposits, or redemption of its preference shares or debentures that have become due for redemption, or payment of the interest on such deposit or debentures, or payment of dividend. Condition number 7. The company has not defaulted in payment of the dividend on preference shares or repayment of any term loan from a public financial institution or state level financial institution or scheduled bank that has become repayable, or interest payable thereon, or dues with respect to statutory payments relating to its employees to any authority, or default in crediting the amount in investor education and protection fund to the central government. Eighth condition, the company has not been penalized by court or tribunal during the last 3 years for any offence under Reserve Bank of India Act 1934, the Securities and Exchange Board of India Act 1992, the Securities Contract Regulation Act 1956, the Foreign Exchange Management Act of 1999, or any other special act under which such companies being regulated by sectoral regulators. The company shall not convert its existing equity share capital with voting rights into equity share capital carrying differential voting rights, and vice versa. The holders of the equity shares with differential rights shall enjoy all other rights such as bonus shares, rights shares, etc., which the holders of the equity share are entitled to, subject to the differential rights with which such shares have been raised. If a company issues equity shares with differential rights, the register of members shall contain all the relevant particulars of the shares so issued, along with the details of the shareholders. Now, discussing about preferential share capital. It is a part of the issued share capital of the company limited by shares which carries or would carry a preferential right with respect to 1. Payment of dividend, either as fixed amount or an amount calculated at fixed rate, which may either be free or subject to income tax. And the second one, repayment in the case of winding up or repayment of capital. So that is the difference between preference share capital and equity share capital. Now, alteration of share capital. Section 61 and 64 of the Act discuss about alteration of share capital. The share capital of the company may be altered if the power to alter the capital is given by the Articles of Association of the company. If no such power is given by the Articles, by a special resolution, the Articles is to be altered first and incorporate a provision allowing the alteration of capital. If there is a provision in the Articles for the alteration of capital, the share capital of the company may be altered in several ways, like 1. By increasing the authorized share capital, 2. By consolidating any part of the share capital into shares of larger amount, 3. By converting fully paid share into stock. The power to alter the capital must be exercised by the company by passing an ordinary resolution in the general meeting. So it has to be exercised by the company by passing an ordinary resolution in the general meeting. The company has to give notice of alteration of capital to the registrar within 30 days. Now, reduction of share capital. That is discussed in Section 66 of Companies Act 2013. Section 66 of the Act deals with reduction of share capital. A company limited by shares can reduce its share capital by a special resolution. There should be provision in articles of association of the company allowing such reduction. The company may reduce its share in the following methods. 1. By extinguishing or reducing the liability on any of its shares in respect of share capital not paid up. 2. By writing off or cancelling any paid up capital which is lost or unrepresented by available asset. Third, by paying off capital which is in excess of the wants of the company. A company shall first pass a special resolution for the reduction of share capital. Thereafter, it has to apply to the National Company Law Tribunal for an order confirming the reduction of capital. The tribunal must give opportunity to the creditors of the company to object to the reduction of the share capital. The tribunal can settle a list of such creditors who raised objection. If a creditor does not consent to reduction, the tribunal may secure his interest. After securing the claims of the creditors, the tribunal may confirm the reduction. The order of the tribunal confirming the reduction shall be produced before the registrar and a copy shall be filed with him for registration. So, reduction of share capital is discussed in 66. The alteration of share capital is discussed in 61 and 64. And in share capital, we have equity shares, share capital and preferential share capital. Under equity share capital, we have equity share capital with differential rights or equity share capital with voting rights. And we discussed several heads of capital, 7 heads, that is authorized or nominal or registered capital, then issued capital, subscribed capital, called up capital, paid up capital, uncalled capital, and reserved capital. So that is with an introduction to share capital. The next topic is share and different types of share. Share is the share in the share capital of the company. The capital of a company is divided into certain indivisible units of a fixed amount, and such units are called shares. So, the capital of a company is divided into certain indivisible units of a fixed amount, and such units are called shares. The shares of a member in a company shall be movable property. Types of shares. The Companies Act 2013 authorizes the issue of 2 types of shares: preference shares and equity shares. Preference shares. Preference shares are those shares which enjoy preferential right with respect to dividend and repayment of capital on winding up of the company. Preference shares may be of the following type. 1. Cumulative preference shares. The holders of the cumulative preference shares have a right to claim fixed dividend in all years. If in a particular year there is no profit, the preference shareholder can claim that year's profit out of the next year's profit. The dividends payable on these shares goes on accumulating till it is fully paid off. The second one is non-cumulative preference shares. Non-cumulative preference shareholders are entitled to get fixed dividend out of current year's profit. If in a particular year there is no profit, they cannot claim the dividend in the next year. Then we have participating preference shares. The holders of a participating preference shares are not only entitled to a fixed rate of dividend but also to share in the surplus of profit which remain after the claim of equity shareholders are met. Now, non-participating preference shares. The holders of non-participating preference shares are entitled to a fixed rate of dividend. They do not share in a surplus profit of the company along with equity shareholders. Convertible preference shares. The holders of these shares have a right to convert them into equity shares within a certain period. Non-convertible preference shares. The holders of these shares have no right to convert shares into equity. So preference shares are of type that is cumulative preference shares and non-cumulative preference shares, participating preference shares and non-participating preference shares, convertible preference shares and non-convertible preference shares. Now, issue and redemption of preference shares. A company having a share capital may, if so authorized by its articles, issue preference shares. In order to issue preference shares, the following conditions should be satisfied. 1. The issue of such share is to be authorized by passing a special resolution in the general meeting of the company. 2. The company, at the time of such issue of preference shares, has no subsisting default in the redemption of preference shares issued earlier and in the payment of dividend due on any preference shares. So the second condition is that the company, at the time of such issue of preference shares, has no subsisting default in redemption of preference shares issued earlier and in the payment of dividend due on any preference shares. A company may redeem its preference shares only on terms on which they were issued. The preference shares may be redeemed A. At a fixed time or on the happening of a particular event. B. At any time at the company's option. C. At any time at the shareholder's option. The next one is equity shares. Equity shares are those which are not preference shares. Equity shares do not carry any preferential right. It may be with voting rights or with differential rights as to dividend or voting. Nature of shares or debentures. By Section 44 of the Act, the shares or debentures of a company shall be a movable property transferable in the manner provided by the Articles of Association of the company. Now, sweat equity shares. Section 2, Subclause 88 of the Companies Act 2013 defines the expression sweat equity share. Sweat equity share means equity shares issued by the company to its employees or directors at a discount or for consideration other than cash for providing know-how or making available rights in the nature of intellectual property rights. Section 54 of the Act deals with sweat equity shares can be issued only on satisfying the following conditions, and three conditions are laid down. First one, the issue of sweat equity share is to be authorized by a special resolution passed by the company in the general meeting. The resolution should specify the number of shares, current market price, consideration if any, and the class or classes of directors or employees to whom such equity shares are to be issued. 3. Not less than 1 year should have been elapsed since the company had commenced its business. The rights, limitations, restrictions, and provisions as are applicable to equity shares shall be applicable to sweat equity shares. The holders of such shares shall rank pari passu, that is equal with other equity shareholders. And then we have bonus shares. So section 63 of the Act deals with the issue of bonus shares. By section 63 subclause 1, a company may issue fully paid up bonus share to its members out of 1. its free reserves, 2. the security premium account, or 3. the capital redemption reserve account. So, a company may issue fully paid up bonus share to its member out of either the free reserve or the security premium account or the capital redemption reserve account. No issue of bonus share shall be made by capitalizing reserves created by the revaluation of assets. By Section 63 Subclause 2, a company shall not capitalize its profits or reserves for the purpose of issuing fully paid up bonus shares unless A. It is authorized by its articles, B. It has, on the recommendation of the board, been authorized in general meeting of the company, C. It has not defaulted in payment of the interest or principal in respect of fixed deposit or debt securities issued by it, D. It has not defaulted in respect of the payment of statutory dues of the employees, such as contribution to provident fund, gratuity, and bonus. E. The partly paid up share, if any outstanding on the date of allotment, are made fully paid. So, if these conditions are met by Section 63 Subclause 2, a company shall not capitalize its profit or reserve for the purpose of issuing fully paid up bonus share unless these conditions are met. So, if these conditions are met, the company can capitalize its profit or reserves for the purpose of issuing fully paid up bonus shares. The company which has once announced the decision of its board recommending a bonus issue shall not subsequently withdraw the same. So once the company has announced the decision of the board, then subsequently it cannot withdraw the same. The bonus share shall not be issued in lieu of dividend. The bonus share shall not be issued in lieu of dividend. The next topic we have is rules to be followed for allotment of shares. A public company can, by issuing a prospectus, invite public to subscribe its shares. Application for shares is an offer from the part of a member of the public. The offer may be accepted by the company and communicated to the offerer. The shares are then said to be allotted to the applicant. The allotment creates a binding contract between the applicant and the company. The following are the rules governing the first allotment of shares. 1. Minimum subscription. 2 is the application money. Third one is the opening of the subscription list. Fourth one is the shares to be dealt in one or more recognized stock exchange. 5 is returns of allotments. So first one, minimum subscription. By Section 39 Subclause 1 of the Act, no allotment of any securities of a company offered to the public for subscription shall be made unless the amount stated in the prospectus as the minimum amount has been subscribed and the sums payable on the application for the amount so stated have been paid to and received by the company by check or other instrument. The first allotment shall not be made unless the minimum amount required for the initial expenses has been subscribed. The amount of minimum subscription has to be stated in the prospectus. The application money on such subscribed share capital should be received by check or other instrument. If there is no minimum subscription, shares shall not be allotted to the applicant. Now the second one, application money. The money payable on application for each share shall not be less than 5% of the nominal value of the share. So the money payable on application for each share shall not be less than 5% of the nominal value of the share. An allotment shall not be made without the application money is received by check or other instrument. The amount received from the applicants for shares shall be deposited in a scheduled bank. If the stated minimum amount has not been subscribed and the sum payable on the application is not received within a period of 30 days from the date of issue of the prospectus, the amount received shall be returned within a period of 15 days from the closure of the issue, and if such money is not so repaid within such period, the directors of the company who are officers in default shall jointly and severally be liable to pay that amount with interest at the rate of 15% per annum. Allotment of shares without receiving minimum subscription is irregular. Irregular allotment of shares made by a company is voidable at the option of the applicant. The directors are liable to compensate the company and the allottees for loss. Now the third one, opening of subscription list. When shares of a company are offered to the public by issuing a prospectus, no allotment is to be made until the beginning of the fifth day from the date of the prospectus. It is known as the opening of subscription list. So no allotment is to be made until the beginning of the fifth day from the date of the prospectus. It is known as the opening of subscription list. If the allotment is made before the opening of subscription list, the directors responsible for it shall be liable to fine. The fourth one is shares to be dealt in one or more recognized stock exchanges. A company intending to offer shares to the public by the issue of a prospectus shall, before such issue, make an application to one or more recognized stock exchanges for permission to deal with those shares in that stock exchange. In the prospectus, the name of the exchange should be given. An allotment of shares made will be void if permission is not granted within 10 weeks from the closing of the subscription list. So in the prospectus, the name of the exchange should be given. An allotment of share made will be void if permission is not granted within 10 weeks from the closing of the subscription list, and the subscription list opens at the fifth day from the prospectus. If the company does not apply for permission or an application for permission is rejected, the company shall repay within 8 days all money received from the applicants. If the company fails to repay the money within 8 days, it will be liable to pay interest. Now the last, returns of allotments. An allotment is to be made by a resolution of the board of directors. It must be made within a reasonable time. The allotment must be communicated to the applicant. Allotment must be absolute and unconditional. Every company making an allotment of shares has to deliver the allottee a certificate of shares within 3 months after the allotment. A company allotted shares should file with the registrar a statement known as return of allotment within 30 days. It should contain names, address, and occupation of the allottees and the amount paid on each share. So that is with allotment of shares. The next topic is certificate of shares. Section 46 of the Act deals with certificate of shares. Share certificate is a document of title issued by the company certifying that the allottee is entitled to a particular number of shares in the company. A certificate issued with the seal of the company specifying the shares held by any person shall be prima facie evidence of the title of the member of such shares. Every person whose name is entered as a member in the register of members of a company has a right to receive certificate of his shares. A share certificate shall be issued under the common seal, if any, of the company. It shall state the name and address of the shareholder, number of shares held by him, distinctive number of shares, class of share, amount paid on each share, day and date of issue, revenue stamp, and number of certificate. Duplicate certificate. If any share certificate is worn out, defaced, mutilated, or torn, or if there is no further space on the back of the endorsement of transfer, then upon production and surrender thereof to the company, a new certificate may be issued in lieu thereof. If any certificate is lost or destroyed, then upon proof thereof to the satisfaction of the company and on execution of such indemnity as the company deem adequate, a new certificate in lieu thereof shall be given. New certificate will be issued only on payment of 20 rupees for each certificate. Application of doctrine of estoppel. A share certificate of the company creates two kinds of estoppels against the company: estoppel as to title and estoppel as to payment. Estoppel as to title. If a company issue a share certificate in the name of a person, it cannot afterward be alleged that the person is not entitled to those shares. Estoppel as to payment. A company is estopped from alleging that the amount stated in the share certificate as being paid has not been paid. If the share certificate stated that the shares are fully paid, the company cannot afterwards allege that they are not fully paid. If the share certificate are forged one, the company can deny the liability. The doctrine of estoppel is not applicable in such a case. For example, B was a share broker. C entrusted 4,000 shares to B for sale. B had forged C's signature and applied to the company to transfer the shares in his name. The company issued a new certificate in the name of B. B sold these shares to A. C had sent a letter to the company that the shares should not be transferred in the name of B or any other person. Before this letter is received by the company, the shares were transferred in the name of B. A applied to the company for transfer of shares in his name. Whether the company is bound to register the shares in the name of A. If the company is not bound, what is the remedy available to A against the company? In this example, the company is not bound to transfer the shares in the name of A. A being a bona fide purchaser of share on the faith of the share certificate issued by the company, he can claim value of the share at the market price from the company. The company cannot deny the title of B because the share certificate is issued under the seal of the company and it is not a forged one. So the company is not bound to transfer the shares in the name of A. The company cannot deny the title of B, but A being a bona fide purchaser of shares on the faith of share certificate issued by the company, he can claim value of the shares at the market price of the company. Now, the next topic is securities at a premium or shares at a premium. By section 78, a company can issue its securities, shares and debentures at a premium, that is at a price higher than their nominal value. Example, the nominal value of a share is 100 rupees. If the company issues it at 120 rupees, the shares are issued at a premium. The memorandum or articles of association need not authorize such issue. The premium so received must be transferred to a separate account called the securities premium account. The premium so collected can be utilized for the following purpose. 1. For issuing fully paid bonus share. 2. To write off preliminary expenses. 3. To write off expenses, commission or discount on the issue of securities and debentures. 4. To pay premium on redemption of redeemable preferential shares or of any debentures of the company. And the next topic is shares at a discount. Section 53 of the Companies Act 2013 prohibits issuing shares at discount for a price lesser than the nominal value. By Section 53, Subclause 1, a company shall not issue shares at a discount rate. However, there is an exception. A company can issue sweat equity shares at a discount to its directors or employees. By Section 53, Subclause 2, any share issued by a company at a discount price shall be void. If a company issues shares at a discount, the company shall be punishable with fine which shall not be less than 1 lakh rupees but which may extend to 5 lakh rupees, and every officer who is in default shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which shall not be less than 1 lakh rupees but which may extend to 5 lakh rupees, or with both. So that is share at discount. So we discussed certificate of shares, then shares at premium, shares at discount, and next we are going to discuss about calls on shares. A call is a demand made by a company to its shareholders to pay the whole or part of the balance remaining unpaid on each share. It is to be made after passing a resolution of the board of directors at a meeting of the board. The call must be made strictly in accordance with the provisions of the articles. The power to make calls is in the nature of trust and must be exercised bona fide for the benefit of the company. If the directors make a call upon the shareholders to pay without clearing their own dues on the shares, or if the directors make a call only to enable them to draw their pay, there is no good faith. Example, Company X had no money to pay director's fee. The directors thereupon paid into the company's bank account the amount remaining due on their shares and took the amount as fees. The directors have not exercised their power to make a call bona fide and for the benefit of the company. So the payment by the directors of the amount remaining due on the shares would not discharge them from the liability to pay on their share. And the next topic we have is lien on shares. So a company has a first and paramount lien on every share not being fully paid share for all monies, whether presently payable or not, called or payable at a fixed time in respect of that share. The company's lien on a share extends to all dividends payable in respect of such shares. The company may sell any share on which the company has a lien. The company can sell the share only if the sum in respect of which the lien exists is presently payable. The company can sell the share only if sum in respect of which the lien exists is presently payable. Before selling such share, 14 days notice in writing should be given to the registered holder demanding payment. If the company sells such share, the purchaser's name should be registered as holder of the shares. The next topic is the forfeiture of shares. When a person to whom shares are allotted fails to pay any calls on his shares, the company may proceed to sue him for the payment, or it may forfeit his shares. Shares can be forfeited for the non-payment of a call only if special power is given to the board of directors by articles. A company can forfeit the shares of a shareholder for the non-payment of a call if the following conditions are satisfied. 1. A forfeiture for non-payment must be authorized by articles of the company. 2. Before shares can be forfeited, The company must serve a notice on the defaulting shareholder requiring the payment of the call with interest. The notice must give not less than 14 days time. It must state the possibility of forfeiture for the failure to pay within the period. 3. If the defaulting shareholder does not pay the amount within the specified time, the directors must pass a resolution forfeiting the shares. If the resolution is not passed, the forfeiture will be invalid. 4. The directors must exercise the power of forfeiture in good faith and for the benefit of the company. Only in these four conditions the directors can forfeit a share. And now the effect of forfeiture. 1. A person whose shares have been forfeited ceases to be a member in respect of the forfeited shares. Forfeiture relieves the shareholder of liability to pay future calls, but he remains liable to pay all money which were payable by him to the company in respect of shares at the date of forfeiture. Second one, the liability of a member whose shares are forfeited ceases as and when the company receives the payment in full in respect of the shares. If there is a winding up of a company within 1 year from the date of forfeiture of share, the member whose shares have been forfeited is liable to put on the list B of contributors. Reissue of forfeited shares. The forfeited shares may be reissued by the board of directors in order to reissue the forfeited shares. The board of directors should pass a resolution. Thereafter, the forfeited shares are transferred in the name of the buyer. Now the next topic is surrender of shares. If the articles of association give power to the directors to accept the surrender, the shareholder can give back his shares to the company. The surrender of shares by a member shall be valid if the directors have accepted the surrender to save the company from going through the formalities of forfeiture. In case of fully paid up share, the directors can accept the surrender in exchange for new shares of the same nominal value. The effect of the surrender is the termination of membership of a shareholder. And then the next topic we have is transfer and transmission of shares. Transfer of shares. The shareholders of a public company have a right to transfer their shares. It is a statutory right and cannot be taken away by any provisions in the Articles of Association. Shares of a company are movable property. The shareholders' right to transfer include the right to pledge or hypothecate the shares. A public company's Articles of Association may provide for the regulations of transfer, but the right to transfer cannot be absolutely restricted. In fact, easy transferability of share is one of the essential features of a public company. In order to register a transfer of shares, an instrument of transfer duly stamped and executed by the transferor and transferee together with the share certificate should be submitted to the company. The instrument of transfer shall specify the name, address, and occupation of the transferee. It shall be in the prescribed form. If the company registers transfer, the transferee becomes the member of the company. The company has to issue new share certificate in the name of the transferee within 1 month. In Madhubhumi Printing and Publishing Co. Limited vs. Vardhaman Publisher Limited, the court held that transfer becomes complete and the transferee becomes a shareholder only when the transfer is registered in the company's register. If a company refuses to register a transfer, it shall inform the transferor and transferee within 1 month the fact of refusal. The transferor or transferee may appeal to the National Company Law Tribunal against the refusal to register the transfer. The appeal shall be preferred within 2 months of the notice of such refusal. Forgery in transfer. If shares are transferred on the basis of a forged instrument of transfer, the following are the consequences. 1. A forged transfer is a nullity and the original owner of the shares continues to be the shareholder and the company is bound to restore his name to the register of members. 2. If the company has issued a share certificate to the transferee and he has sold the shares to an innocent purchaser, the company is liable to compensate such purchaser if it refuses to register him as a shareholder. 3. If the company has been put to loss by reason of the forced transfer, it may recover indemnity from the person who lost it. So these are the consequences of forgery in transfer. Now, transmission of shares. When the ownership of shares change from one to another by operation of law, it is called transmission of shares. So transferring is happen when the transfer the shares by agreement, and when the transfer happens by operation of law, that is transmission of shares. Death of a registered member shall necessitate change in the ownership. The legal representatives of the deceased shareholder are entitled to get it registered in their name. The instrument of transfer is not required in the case of transmission of shares. A mere application by legal representative is sufficient to get his name registered as a member. The company has to issue new certificate in the name of the legal representative within 1 month. If the company refuses to register a transfer, it shall inform the applicant within 1 month the fact of refusal. The legal representative may appeal to National Company Law Tribunal against the refusal to register his name in the register of members. The appeal shall be preferred within 2 months of the notice of such refusal. So we went to the certificate of share, then the securities at premium or shares at premium, shares at discount, calls on share, lien on share, forfeiture of share, surrender of share, and transfer and transmission of share. The next topic is preemptive right of shareholder or rights issue. Section 62 of the Act deals with preemptive right of shareholder. If a company proposes to increase a subscribed capital by allotment of further shares, such shares shall be offered to the existing equity shareholders in the ratio of shares held by them. The right of shareholders to be offered new shares to them before they are offered to the public is known as shareholders' right of preemption. The preferential right of the shareholders is otherwise known as rights issue. The offer for new shares shall be made by notice specifying the number of shares offered. The notice shall give a minimum 15 and maximum 13 days time to accept the offer. If the offer is not accepted within the time, the shares may be sold to the public. A company can offer the new shares to the public without offering it to the existing shareholders if a special resolution is passed by the company in its general meeting authorizing the directors to allot shares to outsiders. Now the next topic is debentures. Section 71 of the Act deals with debentures. A company must have necessary capital to carry on its business. The initial capital is collected by the issue of shares. Another method by which the company can raise the necessary fund is by issuing debentures. Section 2 subclause 30 of the Act defines the word debenture. It is an instrument issued by the company evidencing a debt. It includes debenture stock and bonds of a company. A debenture is a document which either creates a debt or acknowledges the debt. In Levy versus Abercrombie's Slate and Slab Company, Levy versus Abercrombie's Slate and Slab Company, the court held that the debenture is the description of an instrument which creates or acknowledges a debt. According to Palmer, debenture is an instrument under seal and evidencing a debt. The essence of it is admission of indebtedness. A debenture is an instrument issued by a company for acknowledging the indebtedness of a specified sum. It usually gives a charge by way of security upon the property of the company. By Section 71, Subclause 1, a company may issue debentures with an option to convert such debentures into shares, either wholly or partly at the time of redemption. In order to issue such debentures, a special resolution passed at general meeting is required. No company shall issue any debenture carrying any voting rights. If debenture are issued by a company, it shall create a debenture redemption reserve account out of the profits of the company available for payment of dividend. The amount credited to such account shall be utilized only for the redemption of debentures. The company has to pay interest and redeem the debentures in accordance with the terms and conditions of their issue. If a company fails to redeem the debentures on the date of their maturity or fails to pay interest on the debenture when it is due, the tribunal may, on the application of any or all debenture holders, direct by order the company to redeem the debentures forthwith on payment of principal and interest due thereon. If the order of the tribunal is not complied with, every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 3 years, or with fine which shall not be less than 2 lakh rupees, but which may extend to 5 lakh rupees, or with both. The provisions applicable to transfer and transmission of shares are applicable to debentures also. The characteristic features of a debenture are the following. 1. Debenture is a document given by a company as evidence of a debt. 2. It is issued under the company's seal. 3. It is usually specifies the date of repayment. 4. It specifies the rate of interest. 5. It generally creates a charge on the undertaking of the company or some part of its property. 6. A debenture holder does not have any right to vote. Fixed and floating charges. When debentures are issued by a company, a charge may be created on the assets of the company. The charge may be fixed. A charge may be fixed charge or a floating charge. When charge is created on some ascertained and fixed assets of the company, it is known as fixed charge. If the fixed charge is created on the assets, the company is prevented from dealing with that property without the consent of the charge holder. Floating charge is created on some assets which is constantly changing. A charge on stock in trade or raw materials or book debts is an example of floating charge. The company can deal with the property on which a floating charge is created until the charge crystallizes. Crystallization is the conversion of a floating charge into fixed charge. When the company goes into liquidation, or when the company defaults in paying the principal or interest, and the holder of floating charge brings an action, the floating charge will be crystallized. Then the next topic is right to nominate. By Section 72 of the Act, every holder of securities, that is shares and debentures, of a company may at any time nominate any person to whom his securities shall vest in the event of his death. It is to be done in the prescribed form. If the securities are held by two or more persons jointly, the joint holders may together nominate any person to whom all the rights in the securities shall vest in the event of death of all the joint holders. If a nomination is made, the nominee shall, on the death of the holder of securities, become entitled to all the rights in the securities to the exclusion of all other persons. If the nominee is a minor, the holder of the securities may appoint another person to become entitled to the securities in the event of the death of the minor nominee during his minority. So that is with right to nominate.
The next topic is membership. The persons who collectively constitute a company as a corporate entity are called members. The terms member, shareholder, and holder of shares are used interchangeably in the case of a company limited by shares. But in case of a company limited by guarantee, without a share capital, a member may not be a shareholder. Thus, all the shareholders are members, but all the members are not shareholders. The subscribers of the memorandum of association of a company shall be deemed to be the member of the company. Now, who can be a member of the company? Membership of a company is open to every person who is competent to contract. An artificial person is also qualified to become a member of the company as an ordinary person. 1. Minors. The general principle is that a contract of a minor is void ab initio. However, a minor in India may apply for shares and receive an allotment of shares subject to a right to repudiate liability on him before or within a reasonable time after attaining majority. In the case of a company limited by shares, there is no objection to issue fully paid up shares to a minor. In Naveen Chandra versus Govardhan Das, that is 1967, the court held that if a minor's name is entered into the register of members as an allottee, the company cannot afterwards suo motu delete his name. In Devin Singh versus Minerva Films Limited, 1958, in Devin Singh versus Minerva Films Limited, a 1958 case, it was held that there is nothing in the law to prevent minors from acquiring or holding shares in a company if they are properly represented by lawful guardian. So the second one is a company. The first one was a minor and the second one a company. A company can become member of another company if so authorized by its articles. By Section 19 of the Act, a subsidiary company is prohibited from holding any shares in its holding company. A holding company shall not allot or transfer its shares to any of its subsidiary companies. Any such allotment or transfer shall be void. If the subsidiary company was a shareholder even before it became a subsidiary company of the holding company, there is no illegality in continuing as a member. However, the subsidiary company shall not have right to vote at a meeting of the holding company. By Section 67 of the Act, a company limited by shares or by guarantee and having a share capital cannot buy its own shares. A company cannot become a member of the very same company. A company other than a banking company shall not make a loan to purchase its shares. A banking company can make a loan in ordinary course of its business to a person for purchasing its own shares. So, also where loans are made to employees, they can be permitted to purchase fully paid up shares to be held as beneficial owners. In Trevor versus Whitworth, 1887, the Articles of Association of a company authorize the company to purchase its own shares. Whitworth sold his shares to the company. Before the full price of the shares was paid, the company went into liquidation. Whitworth claimed the balance of the price of the shares from the liquidator. The liquidator denied the claim of Whitworth. The court held that a company had no power to purchase its own shares, and even if there is permission in Articles of Association, it is ultra vires to the company law, and hence the claim of Whitworth failed. Now the next one we discuss here is buyback of shares. By virtue of Section 68 of the Companies Act 2013, a company may purchase its own shares out of three conditions, that is, out of its free reserves,
or the securities premium account or the proceeds of any shares. A company shall not purchase its own shares unless the buyback is authorized by its articles and a special resolution has been passed in general meeting authorizing the buyback. The buyback should be less than 25% of the paid up capital. The buyback of equity shares in any financial year shall not exceed 25% of its total paid up equity capital. So, the buyback of equity shares in any financial year shall not exceed 25% of its total paid up equity capital. The buyback should be less than 25% of the paid up capital. A declaration of solvency has to be filed with the registrar and Securities and Exchange Board of India, that is SEBI, before the resolution of buying back is implemented. If a company has bought back its securities, it has to extinguish them and physically destroy them within 7 days of the last day on which the buyback process is completed. If a company has resorted to the buying back of its securities, it cannot make further issue of securities within a period of 6 months. Now the third person here, that is, first we discussed about minor, second the company, a company, and third we are going to discuss about partnership firm. A partnership firm is not a person in the eye of law and it cannot be a member of a company. However, a partnership firm can buy the shares of a company in the individual name of its partners. Now, the fourth one we are going to discuss is foreigners. Foreigners can become members of companies registered in India. The rights of the foreigners as members will be suspended if they become an enemy alien. Now we'll be discussing about modes of acquiring membership of a company. So earlier we discussed who can be a member of the company. We discussed about minors, a company, the partnership firm, and foreigners. Now, modes of acquiring membership of a company. A person can become a member of a company under the following circumstances. 1. By subscribing to memorandum. A subscriber to the memorandum become a member on the registration of the company even though there is no application of shares or allotment. So, we have a case here, official liquidator versus Suleiman Bhatt. Official liquidator versus Suleiman Bhatt, 1955. Here, Suleiman Bhatt subscribed to a company's memorandum for 200 shares. He took only 20 shares. The company went into liquidation. The official liquidator claimed the value of 180 shares from Suleiman Bhatt. The court held that a subscriber to memorandum is liable for all the shares which he has undertaken to take. So here Suleiman Bhatt was liable to pay the value of the 180 shares. Now the second mode of acquiring membership is by application and allotment. An application for shares is an offer to take shares. Allotment is acceptance of that offer by the company. When shares are allotted to an applicant, he becomes a member. Punishment for the use of fictitious names. By Section 38 of Companies Act 2013, a person who makes application in fictitious name to a company for acquiring shares or debentures or subscribing any shares shall be liable to punishment provided in Section 447 of the Act. By Section 447, any person who is found to be guilty of fraud shall be punishable with imprisonment, which shall not be less than 6 months, but which may extend to 10 years, and shall also be liable to fine, which shall not be less than the amount involved in the fraud, but which may extend to 3 times the amount involved in the fraud. Now, the third mode of acquisition or being a member is by transfer. When a person who purchased the share from the open market applies to register his name in the place of original shareholder, and when his name is entered in the register of members, he becomes a member by transfer. So when a person who purchased the shares from the open market applies to register his name in the place of the original shareholder,
and when his name is entered in the register of members, he becomes a member by transfer. Now, the fourth mode is by transmission. When the legal heirs of a deceased shareholder applies for registering their names, and when the company entering their name, they become members of the company. So earlier we already discussed about transfer and transmission of shares. Now, the fifth mode and the last mode we discuss here is by undertaking to take qualification shares. A director who has signed an undertaking to take and pay for the qualification shares is also in the same position as subscriber of memorandum. So that is the 5 modes of acquiring membership of a company. One is by subscribing to memorandum, second one by application and allotment, third by transfer, fourth by transmission, and fifth by undertaking to take qualification shares. Now we are going to discuss about cessation of membership. So we discussed who can be a member, then how to acquire membership, and now we are going to discuss about cessation of membership. A member of a company will ceases to be a member under the following circumstance. First one, by transfer. A person will cease to be a member if he transfers his share to another person. Second, by forfeiture. If the shares of a member are forfeited, he will cease to be a member. The third one is by rescinding the contract. A person who purchases the shares from the company can file a suit to rescind the contract on the ground of misrepresentation or fraud in the prospectus. When the court passes a decree rescinding the contract, he will cease to be a member. Now the fourth one is by redemption. A company can redeem the redeemable preference share. So a company can redeem the redeemable preference shares. When a company redeems the shares, the shareholder will cease to be a member. Fifth one, by surrender. If a shareholder surrenders his shares to the company, he will cease to be a member. In order to surrender shares, there should be provisions in articles allowing surrender. The sixth one is by issue of share warrants. If share warrants are issued to a member in exchange of fully paid shares, he will cease to be a member. The seventh one, by death. On the death of a shareholder, his legal representatives can register their names in the place of the deceased, and the deceased person ceases to be a member. Eighth one is sale in execution. When shares are sold in the execution of a decree of court, the shareholder will cease to be member. And the ninth one is insolvency. So the shares of an insolvent vest in the official assignee or the receiver, and the assignee can apply to transfer the shares in his name. When a transfer is effected on the basis of an application, the share will cease to be the shareholder will cease to be the member of the company. So here 9 ways of cessation of membership is discussed, that is by transfer, by forfeiture, by rescinding the contract, by issue of share warrants, by death, by then sale in execution, and insolvency. So the next topic is meeting of shareholders. The word meeting means the gathering or assembly of a number of persons of certain purpose for a certain purpose. In the administrative work of a company, the meeting has very much important role. Company administration is based upon democratic principle, so the majority opinion is to be obtained in the meeting. Different kinds of meeting of shareholders. The first one is annual general meeting, or commonly known as AGM. By section 96 of the Companies Act 2013, every company other than a one-person company shall in each year hold a general meeting of its members as its annual general meeting. The notices calling such meeting shall specify that it is an annual general meeting. The first annual general meeting shall be held within a period of 9 months from the date of closing of the first financial year of the company. The second and subsequent annual general meeting are to be held within a period of 6 months from the date of closing of the financial year. There shall not be more than 15 months interval between the date of one annual general meeting and the next one. If a company holds its first annual general meeting within 9 months, it shall not be necessary to hold any annual general meeting in the year of its incorporation. The registrar may, for any special reason, extend the time within which any annual general meeting other than first annual general meeting shall be held by a period not exceeding 3 months. Every annual general meeting shall be called during business hours, that is between 9 a.m. and 6 p.m. on any day that is not a national holiday. It is to be held either at the registered office of the company or at some other place within the city, town or village in which the registered office of the company is situated. Now, ordinary business and special business. The business of annual general meeting can be classified into two heads that is ordinary business and special business. The following business transacted at a meeting is known as ordinary business. A. Consideration of accounts, balance sheet and reports of the board of directors and auditors. B. The declaration of dividend. C. The appointment of directors in the place of those retiring. D. The appointment of auditors and fixing their remuneration. All business to be transacted in the general meeting other than those stated above shall be special business. An annual general meeting or any other general meeting, if any special business is to be transacted, a statement of the matters to be transacted in the meeting is to be annexed to the notice calling such meeting. Power of tribunal to call annual general meeting. So, if any default is made in holding annual general meeting of a company on the application of any member of the company, the tribunal may call or direct the calling of an annual general meeting of the company. Now we have extraordinary general meeting. Extraordinary general meeting is the meeting of the shareholders other than annual general meeting. It can be called at any time to transact a business which cannot be postponed until next annual general meeting. All the business at an extraordinary general meeting are special business. The extraordinary general meeting may be convened by board of directors on its own motion or on the requisition of shareholders. The directors should convene the extraordinary general meeting on the requisition of members holding not less than 1/10 of the paid up capital carrying the right to vote. The requisition must set out the matters for consideration. When a requisition is made, the directors should call a meeting and it should actually be held within 45 days from the date of requisition. If the directors fail to do so, the members who have given requisition may call a meeting within 3 months after the date of the deposit of the requisition. If a meeting is not convened within 3 months, the requisition will lapse. The members who have not paid a call on the shares are not entitled to give requisition of extraordinary general meeting. Now, essentials of a valid meeting. 1 is proper authority should call the meeting. The first important requisite of a valid meeting is that it must be called or convened by proper authority. Normally, the board of directors is the convening authority for every general meeting. They should pass a resolution to call a meeting of the shareholders at a duly convened board meeting. If they fail to call the meeting, the tribunal or the members who have given requisition to convene an extraordinary general meeting may call the meeting. The second one is the notice of meeting should be given to persons entitled. The notice of meeting should be given at least 21 days before the date of general meeting. It may be given in writing or through electronic mode. A general meeting may be called after giving a short notice if the consent is given in writing or electronic mode by not less than 95% of the members entitled to vote at such meeting. A general meeting may be called after given a short notice if consent is given in writing or electronic mode by not less than 95% of the members entitled to vote at such meeting. Every notice of a meeting shall specify the place, date, day, and hour of the meeting and shall contain a statement of the business to be transacted at such meeting. The notice of every meeting of the company shall be given to A. Every member of the company, legal representative of any deceased member of the assignees of an insolvent member, B. the auditor or auditors of the company, and C. every director of the company. Any accidental omission to give notice to or the non-receipt of such notice by any member or the other persons who is entitled to receive such notice for any meeting shall not invalidate the proceeding of the meeting. Smith versus Darley, 1849. Smith versus Darley. In this case, the court held that the deliberate omission to give notice of a meeting even to a single member will invalidate the meeting. An accidental omission to give notice does not invalidate the proceedings at the meeting. In Re West Canadian Collieries Limited, here 9 members holding a total of 101 shares out of the 6,92,718 issued shares of the company were not given notice of a meeting at which a special resolution for reduction of capital was passed. So, 9 members holding a total of 101 shares out of the 6,92,718 shares issued. So, they were not given notice of a meeting at which special resolution for reduction of capital was passed. The validity of the resolution was challenged. The address cards containing the names and address of these 9 members was removed from the file because dividend warrant sent to them were returned uncashed. The company wished to verify their address, and for that purpose, the address cards were removed from the file. When notice to members were issued, the company could not issue notice to these 9 members because the address cards were not replaced in the file. The court held that this was an accidental omission and the meeting was valid. Now, the third one is there should be quorum for meeting. Quorum means the minimum number of members required to be present for transacting a legally binding business at the meeting. If the quorum is not present, there is no meeting and the proceedings held there are invalid. The quorum is generally fixed by the Articles of Association. Unless the articles provide for a larger number, in case of a public company, 5 members personally present shall be the quorum of a meeting. If the number of members as on date of meeting is not more than 1,000, it is 15. If the number of members of the company exceeds 1,000 but up to 5,000, it is 30. And if the number exceeds 5,000. So, in case of a public company, 5 members personally present shall be the quorum of meeting if the number of members as on the date of meeting is not more than 1,000. So up to 1,000, a minimum of 5 members is the quorum. Then from 1,000 to 5,000, a minimum of 15 members is the quorum. And for 5,000 and above, a minimum of 30 members is the quorum. In case of a private company, 2 members personally present shall be the quorum for a meeting. So, with respect to public company, the minimum is 5 if the number of members is less than 1,000. If the number of members is 1,000 to 5,000, then minimum quorum is 15. And if the number of members is above 5,000, the minimum quorum is 30. And if it's a private company, 2 members personally present shall be the quorum for a meeting. Only members present in person and not proxies can be counted for the purpose of quorum. The following provisions shall apply with respect to the quorum at meeting of a public or private company. 1. If within half an hour a quorum is not present, it will stand adjourned to the same day in the next week at the same time and place, or to such other day and such other time and place as the board may determine. If the meeting was called upon the requisition of the members and there is no quorum within half an hour, the meeting will stand cancelled. The second one, If at the adjourned meeting also a quorum is not present within half an hour, the members present are the quorum. So they will wait for half an hour, and if the quorum is not met, generally it is postponed to the same day, same place, same time next week, and they can also assign another day as the board may determine. So if this is a meeting that is held by a requisition, it will stay cancelled. Now in the second scenario, if the meeting is already adjourned and yet again there is no quorum, then the meeting is then the members present are the quorum. So in the case of a meeting called by the tribunal, it may order that one member of the company present in person or by proxy shall be deemed to constitute a meeting. So when it is a meeting called by the tribunal, it may order that one member of the company present in person or by proxy shall be deemed to constitute a meeting. Now, the fourth one is chairman of the meeting. At the general meeting, a chairman is to be elected by the members to preside over the proceeding of the meeting. It is the responsibility of the chairman to keep order and see the meeting is properly conducted. He has to put resolutions to the meeting, count votes, and declare the result. He should authenticate the minutes by his signature. And the fifth one is minutes of the meeting. Minutes are the official record of the proceedings of the meeting. They are the permanent record of decisions and resolutions arrived at the meeting. Every company must keep minutes containing summary of all the proceedings of the general meeting. The sixth one is the voting and poll. The term vote means an expression of a wish or opinion in an authorized formal way for or against any proposal. Every holder of equity shares have the right to vote on every motion placed at a general meeting. The preference shareholders do not possess voting rights. They have right to vote only on resolutions which directly affect the rights attached to the preference shares. The voting may be by show of hands or by taking a poll. Now we discussed about proxies. What are proxies? The word proxy is used in two senses. The instrument by which a person is appointed to vote for the shareholders in a general meeting is called proxy. The person so appointed is also known as proxy. So the instrument by which a person is appointed to vote for the shareholders in a general meeting is called proxy, and the person thus appointed by this instrument is also called proxy. By section 105 of the Companies Act 2013, a member of a company is entitled to appoint a proxy to vote at the meeting. A proxy need not be a member of the company. The proxy shall not have the right to speak at the meeting. However, he can demand a poll. A proxy is not entitled to vote except on a poll. The instrument of proxy shall be in writing and signed by the shareholder. It must be deposited with the company 48 hours before the meeting. Proxies can be inspected by every member of the company who is entitled to vote at a meeting. A member who wants to inspect proxies should give notice to the company 3 days before the date of meeting of his intention to inspect the proxies. A member who has appointed a proxy can directly attend the meeting and vote. In such a case, the proxy will be revoked. And we discussed about resolutions, that in a meeting we come to our resolutions. So a resolution is the formal decision at a meeting on a proposal before it. When a motion is proposed at a meeting is passed, it becomes a resolution of the company. So when a motion that is proposed at a meeting is passed, that becomes the resolution of the company. There are three kinds of resolutions, that is ordinary resolution, special resolution, and resolution requiring special notice. So ordinary resolutions. A resolution passed by a simple majority of the shareholders is known as an ordinary resolution. An ordinary resolution is normally used for transacting the ordinary business and in the annual general meeting. Second one is a special resolution. A special resolution is passed by 3/4 majority of the members voting at a meeting. So, special resolution needs 3/4 majority of members voting at a meeting. In ordinary resolution, it just needs a simple majority. And special resolution needs 3/4 majority of members voting at a meeting. The intention to propose the resolution by a special resolution must be specifically stated in the notice calling the meeting. In the following cases, special resolution is necessary. 1. Change of name of the company, change of registered office from one state to another state, change of object of the company, alteration of articles of association, reduction of share capital, and voluntary winding up. So in these cases, we need a special resolution. Now there is resolution requiring special notice. It is a kind of ordinary resolution with difference that the mover of the proposed resolution should give to the company not less than 14 days notice before moving the resolution. The company must give its members notice intimating the notice of the resolution. It must be done 7 days before the meetings. So, here the mover of the proposed resolution should give to the company not less than 14 days notice before moving the resolution. The company must give its members notice intimating the notice of resolution. This must be done 7 days before the meeting. Special notice is required in the following matters. That is resolution requiring special notice. That is required in the following matters. 1. Appointment of an auditor other than the retiring auditor. 2. Removal of a director before the expiry of his term. Third one, appointment of another director in the place of the removed director. So that is with the resolutions that we have three kind of resolution: ordinary resolution with simple majority, special resolution with 3/4 majority, and resolution requiring special notice. And then we discussed about proxies and how the proxies will be proxy will be revoked if the person who assigned a proxy is there in the meeting and voting. And before that, we discussed about the membership, who is the general meeting of a shareholder, annual general meeting, then ordinary business and special business, then extraordinary general meeting, and what are the essentials of a valid meeting. So we have ordinary business and special business, and what comes under ordinary business is that one is consideration of accounts, balance sheet and reports of the board, directors and auditors, the declaration of dividend, the appointment of directors in the place of those retiring, the appointment of auditors in the fixing their remuneration. These come under ordinary business. Anything other than these come under special business. And in the essentials of valid meeting, we said that there should be proper authority. A proper authority should call the meeting, and then notice to meeting should be given to the persons entitled. There should be a quorum for the meeting, and then chairman of the meeting, minutes of the meeting, and voting and poll. So that is with the meetings. Before this, we also discussed about membership, and now the meetings, the proxy, and the kind of resolutions. So that's with meetings. So the next topic is Board of Directors. Section 149 to 172 of the Companies Act 2013 deals with the appointment of directors, remuneration of directors, disqualification of directors, vacation of office by directors, etc. A company is a legal person living only in the eyes of the law. It is a creation of law which lacks both body and mind. It cannot act just like a human being. It can act only through some human agency. Directors are those persons through whom a company acts and does business. They are collectively known as Board of Directors. So the Board of Directors is discussed in sections 149 to 172 of Companies Act 2013, and it deals with appointment, remuneration, disqualification, and vacation of office of directors. Now, in Bath versus Standard Land Company 1910, that is Bath versus Standard Land Company 1910, here the court observed that the Board of Directors are the brain and the only brain of the company, which is the body, and the company can do an act only through the Board of Directors. So in this case, the court held that the Board of Directors are anomalous to the brain and the only brain of the company where the company is the body. So the company can act only through board of directors. That was discussed and observed in Bath versus Standard Land Company 1910. By Section 149, Subclause 1 of the Companies Act 2013, every company shall have a board of directors. The board of directors shall consist of individuals as directors. In the case of a public company, a minimum 3 directors are required to constitute its board. It is 2 in the case of a private company, and it is 1 in the case of a one-person company. The maximum number of directors in the board is fixed at 15 directors. Please note the maximum number of directors in the board is fixed at 15 numbers as per the Companies Act, but if the company passes a special resolution, there can be a board consisting of more than 15 directors. So if the company passes a special resolution, there can be a board consisting of more than 15 directors. The following companies shall appoint at least one woman director. So the Companies Act says that there should be minimum of 3 directors in public company, minimum of 2 in private company, and minimum of 1 director in one person company. Along with it, it says that in some companies, it shall have at least 1 woman director. And what are such companies? 2 types of companies are said here. One is every listed company. So every listed company should have at least 1 woman director. And the second one is every other public company which is having a shared capital of 100 crore rupees. So every public company which has a share capital of 100 crore rupees or 100 crore rupees or more, plus if the public company has a turnover over 300 crore rupees, that is 300 crore rupees or more turnover, then also there should be at least a woman director. So the 2 instances, if the company is a listed company, then there should be a 1 woman director. And the second one, in case of a public company, if it has a paid up share capital of 100 crore or more, in that case there should be a 1 woman director. And in the case of a public company where there is a turnover for more 300 crore or more, there should be a woman director. Now we will be discussing about independent directors. So every listed company shall have at least 1/3 of the total number of directors as independent directors. So note here, every listed public company. So every listed public company shall have at least 1/3 of the total number of directors. So it is discussing only about the class of companies, that is listed public company. And now here the following classes of the companies also shall have at least 2 directors as independent directors. So in the first we said that every listed company should have 1/3 of the total directors as independent directors. Along with it, there are some classes of companies that should always have at least 2 directors as independent directors. So what is the specific classes of companies? That is 1, the public companies having paid up share capital of 10 crore rupees or more. So the public company, if it is having a paid up share capital of 10 crores or more, then there should be at least a minimum of 2 independent directors. And the second class is that the public companies having turnover of 100 crore rupees or more. So if a public company is having a turnover of 100 crore rupees or more, in that case too, it should have at least 2 directors as independent directors. Now the third scenario or the third class of company, that is the public companies which have in aggregate outstanding loans, debentures and deposits exceeding 50 crore rupees. So in both scenario, what we discussed is similar to the case that we discussed for at least 1 woman director. So in 1 woman director, there should be at least 1 woman director for every listed company and for every public company having a paid up share capital of 100 crore rupees or more, and every other public company having turnover of 300 crore rupees or more. So this is somewhat similar for the independent directors too. Here every listed company should have at least 1/3 of the total number of directors as independent directors. That is with respect to listed company. And again we are considering public company in 3 scenarios. That is, there should be at least 2 directors as independent directors with respect to public companies in 3 conditions. That is, if the paid up share capital is 10 crores or more, or if the turnover is of 100 crores or more, or in aggregate there is an outstanding loan, debenture or deposit that exceeds 50 crore rupees. So public company, if it satisfies these 3 conditions, in that case there should be at least 2 directors as independent directors. An independent director means a director other than a managing director or a whole-time director or a nominee director. So an independent director is not a managing director and he's not a whole-time director or a nominee director. So a director who is not either of this is an independent director. And there are some characteristics that should be found in an independent director. Let's look into it. So first one is that in the opinion of the board should have an opinion that this person is of integrity and possesses relevant expertise and experience. And then he should not be a promoter or a relative of a promoter of the company or its holding or subsidiary or associate company. And the other one, the next one is that this person should not have any pecuniary relationship or should not be a relative of a person having a pecuniary relationship with the company, its holding, subsidiary or associate company or their promoters or directors during the 2 immediately preceding financial years or during the current financial year. And then it says that this person should hold only maximum of 2% of the total voting power of the company. So these are the main 3 criteria that was put forward. So it was explained detailed as 5 points, such as A, who in the opinion of the board is a person of integrity and possesses relevant expertise and experience. B, who is not a promoter of the company or its holding, subsidiary or associate company. C, who is not related to promoters or directors of the company, its holding, subsidiary or associate company. D, who has or had no pecuniary relationship with the company, its holding, subsidiary or associate company or their promoters or directors during the 2 immediately preceding financial years or during the current financial year. E, none of his relatives has or had pecuniary relationship with the company, its holding, subsidiary or associate company or their promoters or directors during the 2 immediately preceding financial years or during the current financial year. And the last one, F, who holds only less than 2% of the total voting power of the company. So such a person who satisfies these criterions, along with that this person is not a managing director or a whole-time director or a nominee director, such a person can be defined, said to be an independent director. Now, independent directors are appointed from a data bank of persons offering to become independent directors. So, the central government has a data bank of persons who would like to be independent directors, and the independent directors are appointed from this data bank by the notified by the central government. The appointment of the independent director shall be approved by the company in a general meeting. Now, director elected by small shareholders. So a listed company may have one director elected by the small shareholders. Small shareholders means shareholders holding shares of nominal value of 20,000 rupees or less in a public company. So small shareholders means a shareholder holding shares of nominal value of 20,000 rupees or less in a company. So far with respect to board of directors, we discussed that the board of directors is discussed in section 149 to 172 of Companies Act. Then we discussed about how the anomaly of a company to the board of directors, that the board of directors act as the brain and the company as the body, and this was observed in the case law, that is Bath versus Standard Land Company in 1910. And further we saw the provisions where there should be where there is a minimum number of directors for the public company is 3, For the private company is 2 and 1% company is 1. And we also discussed about the classes of where there must be at least one woman director. And then we discussed about the independent directors and the conditions there, that every listed company shall have at least one third of the total number of directors as the independent director. Along with it, there are some classes of the some conditions or classes of the companies that is under public companies that should have at least 2 independent directors. We discussed that. And then we discussed about who is the independent director and what characters should be there, or what are the criteria for an independent director. And then we had a check into the directors elected by small shareholders. We discussed that every listed company shall have a small shareholder directors elected by the small shareholder. And who's a small shareholder? It means that a shareholder holding shares of nominal value of 20,000 rupees or less in a public company. So with that, we have discussed about the board of directors and a basic constitution of it. Now we will be discussing about the appointment of directors. So with respect to appointment of directors, we have first directors. The first directors are usually named in the articles of association. If the first directors are not named in the articles, the subscribers of the memorandum shall be deemed to be the directors of the company until directors are duly elected by the members in the general meeting. Now we look into the appointment of directors by the shareholders. The directors must be appointed by the shareholders in the general meeting of the company. No person shall be appointed as a director unless he has been allotted the director identification number, and it is allotted by the central government. So earlier we discussed that a director is elected from the data bank of that is allotted by the central government. So we discussed it under the heading of under the heading of independent directors. We said that independent directors are appointed from a data bank of persons offering to become independent directors, and it is notified by the central government. So this we discussed already. So with that, when there is appointment of directors by the shareholders, the person who is interested to be a director should have a director identification number, and this number is allotted by the central government. So how does a person get this director identification number? So an individual intending to be appointed as a director shall make an application for the allotment of director identification number to the central government. Within 1 month of the application, the central government allot a director identification number to the applicant. Not that within 1 month of the application, the central government allots a director identification number to the applicant. Every person proposed to be appointed as a director by the company in general meeting shall furnish his director identification number along with a declaration. And what shall be the declaration of? A declaration that he is not disqualified to become a director under the act. So this is a mandatory thing for every person who wants to be a director. And if the person wants to propose his appointment to in a general meeting, his director identification number along with the declaration has to be submitted to the meeting, has to be furnished in the general meeting. Now, every person appointed as a director shall not act as a director unless he gives his consent to hold the office as director, and such consent has been filed with the registrar within 30 days of his appointment. So within 30 days of the appointment, the director shall submit his written consent to the registrar. He shall file the written consent with the registrar. So in case of a public company, 1/3 of the total number of directors can be given permanent appointment. So this is only with respect to public company. 1/3 of the total number of directors can be given permanent appointment. The remaining 2/3 are liable to retire by rotation. So once they rotate, there is no disqualification to be elected again. A retired director can be elected again. A company can adopt by its articles the system of voting. A retiring director is eligible for re-election. So the next one is appointment of directors by the board. So right now we discussed the appointment of director by the shareholders, and then we discussed about first directors, and now the third one is appointment of directors by the board. So the board of directors is empowered to appoint 3 kinds of directors, that is additional director, alternate director, and directors filling casual vacancy. So, additional directors. The directors may appoint additional directors if so authorized by articles of association. The number of directors and additional directors together must not exceed the maximum limit fixed for the board by the articles. So, we already discussed it is 15, and by special resolution it can be increased. They can have more than 15 directors. So, by act, it is mentioned as maximum as 15, but special resolution can override it. Now, the additional directors shall hold office only up to the date of the next annual general meeting. So, the important point here is that the total number of directors is not calculated separate for the directors as well as the additional directors. They together are come under the maximum limit as that by the articles of association. So, if there is, for example, if there is 10 directors and 8 additional directors, this is not possible. This is not possible if by articles of association it is not permitted. If it is not permitted by articles of association, because by default the act says maximum of 15. But if the article of association says that this company can have maximum of 20 directors, then 10 directors and 8 additional directors is allowed. So, next is alternate directors. The board of directors of a company may appoint alternate directors if so authorized by the articles. He is appointed to act for a director who will be absent for a period of at least 3 months from the state in which the meetings of the board are held. He cannot hold office for a period longer than that permissible to the original director in whose place he is appointed. He has to vacate office on the return of the original director. So, if a director is away from the state in which the meetings are conducted, and that staying away out of station should be at least of 3 months, then an alternate director can be appointed. But in this case, the alternate director can hold the office only as per the eligibility of the original director. He cannot exceed the term. And once he returns, the alternate director has to give up his position to the original director. That is, he has to vacate the office on the return of the original director. And the kind of director that the board of appointment of directors by the board, the third category is casual vacancy. That is, the directors appointed to fill the casual vacancy. So, who are the kind of directors that can be appointed by the board? That is additional director, alternate director, and directors filling casual vacancy. So, casual vacancy. If the office of any director is vacated before the expiry of his term, the board of directors may fill up the vacancy. A casual vacancy may occur by reason of death, resignation, insolvency, or failure to obtain qualification share, or failure to accept the office. Now, the director so appointed will hold office till the end of the term of directors in whose place he is appointed. So that is with casual vacancy. So we are discussing about the appointment of directors. We discussed the first directors, and then the appointment of directors by shareholders, then the appointment of directors by the board, and next we will be discussing about appointment of directors by third parties, that is nominee directors. So, the articles of association of a company may give right to debenture holders, financial institutions, or banking companies who have advanced loan to the company to appoint their nominees to the board of directors. The number of directors so appointed should not exceed 1/3 of the total strength of the board. So, the number of directors so appointed, that is nominee directors, should not exceed 1/3 of the total strength of the board. That are the 4 types of appointment. That is first directors, the directors appointed by the shareholders, directors appointed by the board, and directors appointed by the third parties or the nominee directors. Now we will be discussing about the disqualification of directors. Only an individual can be appointed as a director of a company. An individual is disqualified for the appointment as a director under the following circumstances. So we are going to discuss when are they disqualified to be a director. So the first one, if he is of unsound mind. Second one, if he is an undischarged insolvent. Third, if he has applied to be adjudicated as an insolvent and his application is pending. Fourth one, if he has been convicted by a court for any offence involving moral turpitude and sentenced to imprisonment for a minimum period of 6 months and a period of 5 years has not elapsed from the date of expiry of sentence. So here, if he's involved in any offence of moral turpitude and if he has been sentenced for at least 6 months, that is within 5 years period. Now, the next one is if he has been disqualified by an order of the court or tribunal on the ground of fraud in the promotion, formation or management of the company. And the last one is if he has not paid any calls in respect of any shares of the company held by him and 6 months have elapsed from the last day fixed for the payment of the call. So in these situations, a person is disqualified to be a director. Now, restriction on number of directorship. A person cannot hold office of director in more than 20 companies at a time. So, here we are not discussing about the restriction on the number of directors, but on the number of directorship. Restriction on the number of directorship. That is, in how many companies can a person be director at the same time. So, a person cannot hold office of director in more than 20 companies at a time. The maximum number of public companies in which a person can be appointed at the same time as director is 10. So, with respect to public companies, a person can be appointed as a director at the same time only in 10 public companies. If a person holds office as a director of more than the prescribed limits, he shall be punishable with fine which may extend to 25,000 rupees for every day during which the contravention continues. So, not he may be punished up to an extent of 25,000 per day for every day during which the contravention continues. So, next we are discussing about remuneration of directors. The remuneration payable to the directors of the company is determined either by the articles or by the resolution passed in the general meeting. The amount of remuneration payable to the directors and managers in respect of a financial year shall not exceed 11% of the net profits of the company. So, the maximum limit is 11% of the net profit of the company. That is the amount of remuneration payable to directors and managers in respect of financial year. Now, legal position of directors. In the eyes of law, directors are agents of the company for which they act. If the directors make a contract in the name of the company will be bound by it. However, the contract should be within the scope of their authority. If they have exceeded the powers given to them by the memorandum or the articles of association, they will be personally liable. Directors are not trustees in the real sense of the word because they are not vested with ownership of the company's property. The directors stand in a fiduciary relationship to the company. They must exercise their power honestly and in the interest of the company. They should not exercise their power for their own benefit. A director is not an employee of a company. He is not entitled to any privilege or benefit granted to the employees of the company. However, there is nothing to prevent a director from being an employee. Now, he may be employed in a different capacity, not as a director, but in a different capacity. So, in a case we have discussed earlier, that is with the when we discuss about the characters of the incorporation of a company, we discussed Lee versus Lee Air Farming Co. Limited, 1961. The same case we are going to discuss here. There, the director was also appointed as pilot of the company. He died in an accident. His widow claimed compensation under Workmen's Compensation Act. The court held that the widow was entitled to get the compensation. So, Lee himself was the owner of the company and he was also the chief pilot of the
company. So when he died in an accident, his widow could claim the compensation. Court upheld it, saying that though a director is not an employee of the company, there is no restriction that he cannot be an employee. A director can be an employee of the company in a different capacity. Now, duty to disclose interest. By virtue of Section 184 of the Companies Act 2013, every director shall at first meeting of the board in which he participate as a director, and thereafter at the first meeting of the board in every year disclose his concern or interest in any company or companies or bodies, corporate firms or other association of individuals, which shall include shareholdings. It is to be done in writing in the prescribed form. The director who fails to make such a disclosure shall be punishable with imprisonment for a term which may extend to 1 year, or with which shall not be less than 50,000 rupees, but which may extend to 1 lakh rupees, or with both. So, if a director is also director in another company, or if he has his own company, or any other case, if he has a debenture or some other financial or other interest in other undertakings, so if such a scenario occurs, it is his duty to disclose, like as soon as he's appointed as a director, the very first meeting he should disclose all his interests and concerns in other body, corporate or other undertakings. And in every financial year, it's not just at the first meeting. If he acquires new interest or anything, he has to update each of it in every board meeting. And this is not just a casual discussion, it has to be done in writing and in prescribed form. Default of this is punishable, and it is punishable with imprisonment for a term which may extend to 1 year. So the punishment can go to maximum up to 1 year of imprisonment, and the fine may be fine shall not be less than 50,000 rupees. It can be either imprisonment or fine or both. So, a director of a company who is in any way, whether directly or indirectly concerned or interested in a contract entered into or be entered into by or behalf of the company, shall disclose the nature of his concern or interest at a meeting of the board of directors. He shall not participate in the board meeting in which such contract or arrangement is discussed. In natural justice principle, we discussed that one cannot be the judge of his own cause. This principle is somewhat similar to that. And now, a contract or arrangement entered into by the company without disclosure of interest of the director or with the participation of interested director shall be voidable at the option of the company. So, such a agreement or such a contract shall be voidable at the option of the company. So, it depends upon the decision of the company. Further, the interested director shall be punishable with imprisonment for a term which may extend to 1 year, or with fine which shall not be less than 50,000 rupees, but which may extend to 1 lakh rupees, or with both. So, this is the same punishment we discussed earlier for the default of non-disclosure. Now, moreover, he shall be liable to vacate the office of director. So, not only is he punishable with imprisonment or fine or both, he shall also be liable to vacate the office of director. Now, loans to directors. By Section 185 of the Companies Act, a company shall not make a loan directly or indirectly to any of the following persons or institution without obtaining the previous approval of the central government. So, who are they? 1. Any director of the company or relative of any director. 2. Any firm in which director or relative of a director is a partner. So, we are discussing about loans to directors, and here we are going to discuss about those people too. They cannot be sorry, I will read it out once again. That is, by Section 185 of the Companies Act, a company shall not make a loan directly or indirectly to any of the following persons or institution without obtaining the previous approval of the central government. So there is no bar in giving loan, but it has to get the previous approval of the central government. So who are these people? One, the director of the company or the relative of any director. Second, any firm in which a director or a relative of a director is a partner. Third, any private company of which a director is a director or member. Four, any body corporate of whose meeting a director has 25% of the total voting power. And fifth, any body corporate whose board of director is accustomed to act in accordance with the directions of the board of directors of the lending company. So in this scenario, if they want to give a loan, they should get the previous approval of the central government. A company is prohibited from giving a guarantee for a loan taken by a director from any other person and providing for any security for any such loan. A company is prohibited from providing any guarantee or security for a loan given by the director to any person. So a company is prohibited from giving a guarantee for loan taken by director from any other person and providing for any security of for any such loan. A company and the company is prohibited also from providing a guarantee or security for loan given by a director to any person. So in the first case, the loan is taken by the director. In the second case, the loan is given by a director. So in both cases, the company is prohibited from providing any guarantee or security. Now, if any loan is advanced or a guarantee or security is given in the contravention of the law, the company shall be punishable with fine which shall not be less than 5 lakh rupees but which may extend to 25 lakh rupees. So if they default in it, the company shall be punishable with fine which shall not be less than 5 lakh rupees but it may go up to 25 lakh rupees. Now, the directors or the other persons to whom loan is advanced shall be punishable with imprisonment which may extend to 6 months and with fine which shall not be less than 5 lakh rupees but which may just a second, okay, or with fine which shall not be less than 5 lakh rupees but which may extend to 25 lakh rupees or with both. So the director or the other person, that is if the director takes the loan, the director, or if the director is given to the other person, so the director or the other person shall be punished with imprisonment which may extend up to 6 months and the fine shall be minimum of 5 lakh rupees, shall not be less than 5 lakh rupees. So minimum of 5 lakh rupees and maximum of 25 lakh rupees. It can be imprisonment or fine or maybe both. So the liability of the company shall be punishable with fine which shall not be less than 25 lakh but which may extend to 25. Okay. The company's liability is varying from 5 lakh rupees to 25 lakh rupees. So a minimum of 5 lakh rupees to maximum of 25 lakh rupees. And the personal liability for the director or the other person will be punishment up to 6 months or the fine which is minimum of 5 lakh rupees to maximum of 25 lakh rupees or with both. Now, duties of directors. By section 166 of the Act to the Companies Act 2013, a director of a company shall act in good faith in order to promote the objects of the company for the benefit of its members as a whole and in the best interest of the company, its employees, the shareholders, the community, and for the protection of the environment. So what are the duties of the director? He should act in good faith to promote the objects of the company. So that is one, act in good faith. For what? To promote the objects of the company and for the benefit of its members as a whole. So promote the objects of the company for the benefits of the members as a whole and in the best interest of the company. So let's split this into smaller sections. So the duty of the director, first thing, he should act in good faith, and this act should be to promote the objects of the company, and that promotion is for the benefit of the company. Promotion of the objects of the company that is beneficial for the members as a whole. And now
all this should be in the best interest of the company, its employees, the shareholders, and the community as a whole, plus for the protection of the environment too. So all this, the objects of the company, the benefits of the company and its employees, shareholders, the community, plus the protection of the environment, and all this in good faith. All this is part of the duty of the director, and this is set in section 166 of the Companies Act 2013. A director of a company shall exercise his duties with due and reasonable care, skill and diligence, and shall exercise independent judgment. So what shall he exercise while making? We said that he should do it in good faith and in the benefit of the company and the people and for promoting the object. So during doing this, what should be the precautions he should take, or how should this good faith be proved? For that, his duties, he shall exercise these duties with due and reasonable care. That is one, due and reasonable care. The second one is skill and diligence, and shall exercise in independent judgment. So he should not. It's not that someone who is a senior or someone more expert in this field is suggesting him that, oh, this will be option A is a better option compared to the one you choose as option C. He cannot do that. He has to think on his own and his own expertise and decide which option is to be chosen. So because he is a person who will be liable and it is his duty. So a director of a company shall not involve in a situation in which the personal interest conflicts with the interest of the company. So there shall not be a personal bias for him in this. He shall think and decide unbiased in a due diligence with skill. So the director of a company shall not involve in a situation in which his personal interest conflicts with the interest of the company. A director shall not achieve or attempt to achieve any undue gain or advantage either to himself or to his relative. In case he makes any undue advantage, he shall be liable to pay an equal amount so gained to the company. So in case he makes any undue advantage, he shall be liable to pay an equal amount so gained to the company. And further, a director of a company shall not assign his office, and any assignment so made shall be void. So he cannot assign his office, and any assignment so made shall be void. A director who violates the above stated principle shall be punishable with fine which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees. So if he is defaulting in his duties, he might be punishable with minimum of 1 lakh rupees to maximum of 5 lakh rupees. Now what we are going to discuss is vacation of office by directors. So by virtue of section 167 of the Companies Act 2013, the office of a director shall become vacant under the following circumstance. Let's see what is the circumstances. So first one, if he is found to be of unsound mind by a court of competent jurisdiction. Then we have if he applies to be adjudicated as an insolvent. So these are also what we saw in disqualification. So vacation of office and disqualification has some of the points that is similar to each other. In the disqualification, we discussed that if he's sound mind, if he's insolvent, such that. And here in vacation of office, we are discussing is if he's found to be unsound mind by a court of competent jurisdiction. And the second one, if he applies to be adjudicated as an insolvent. Third one, if he is adjudged as an insolvent. So if he applies to be adjudicated as an insolvent, or if he is adjudged as an insolvent, both his vacation of office happens. And then if he is convicted by a court of any offence involving in moral turpitude and sentenced to imprisonment for not less than 6 months. So the same we also discussed in disqualification. Now the next point is if he fails to pay any call in respect of shares of the company held by him within 6 months from the last date fixed for the payment of the call, yet again discussed in disqualification too. And then if he absents himself from all the meetings of the board of directors held during the period of 12 months with or without seeking leave of absence of the board. So if he absents himself from all the meetings of the board of directors
held during a period of 12 months with or without seeking leave of absence of the board. Then the other circumstances, if he enters into a contract with the company without disclosing his interest in the contract to the board. So we already discussed the punishment for this. Now, which that such a contract shall be voidable, and there is also punishment, and the director may be advised to vacate his office. We already discussed that. And the last scenario we discussed here is if he has been disqualified by an order of the court or tribunal on the ground of fraud in the promotion, formation, or management of the company. So this point is also there in disqualification. So the points of vacation of office and disqualification of office is very similar to the fact that all the points discussed in disqualification also comes under vacation. In addition to those, we have a few additional points in vacation, that is if he misses all the meetings of the board with or without seeking leave for the past 12 months. Some points such as that is also added. Else we have all the points we discussed in disqualification in vacation of office by directors too. So in this we are going to look into resignation of directors. So a director may resign from his office by giving a notice in writing to the company. The board shall not receive receipt of such notice. Okay, the board shall, on receipt of such notice, take note of the same. The company shall intimate the registrar the fact of resignation within 30 days. Within 30 days from the date of receipt of notice of resignation. The director who resigned shall also send to the registrar a copy of the resignation stating reasons for resignation. It is to be done within 30 days. So the company shall also inform the registrar within 30 days, and the director himself shall also send a copy of his resignation to the registrar within 30 days with the reasons for resignation. Now, removal of directors. A company may, by ordinary resolution, that is not by ordinary resolution, remove a director other than a director appointed by the tribunal. Note, other than a director appointed by the tribunal before the expiry of the period of his office. He should be given a reasonable opportunity to be heard. So, this is not regarding the director appointed by the tribunal. The other directors can be removed by the company by a ordinary resolution. There is no need of special resolution. It can be done by ordinary resolution. A director other than the one appointed by the tribunal can be removed before the expiry of the period of his office, and a reasonable opportunity to be heard shall be given to this director. So under board of directors, this is with board of directors, and let's summarize what we discussed. The board of directors is discussed in section 149 to 172 of Companies Act, and here we discussed about appointment, remuneration, disqualification, vacation, etc. And we said that the board of directors is the brain of the company, where the company is the body. Now, a company is a legal person and lives only in the eyes of law. So, if it has to function, it has to function through the directors. And this collection of directors is called the board of directors. They are collectively known as board of directors. And we have different kind of directors here. Then we discussed about what are the minimum directors needed for public company, private company, and one-person company. For public company, it's 3. Private company, it's 2. And one-person company, it's 1. And we also discussed where there shall be at least 1 woman director in certain companies. That is in every listed company. And in case of public company, if the paid-up share capital is above 100 crore rupees and or the turnover is 300 crore rupees or more, there should be at least 1 woman director. And we discussed about independent directors, that every listed company shall have at least 1/3 of the total number of directors as independent directors. And in the case of public companies, there should be at least 2 independent directors where the paid up share capital is of 10 crores or more, and if the turnover of there is a turnover of 100 crores or more, or if in an aggregate there is an outstanding loan or debenture and deposit exceeding 50 crore or more, then in these conditions the public companies shall have at least 2 independent directors and more. And then we discuss what is the nature of an independent director, that this independent director is not a managing director or a whole-time director or a nominee director, and we also discuss about some of the characters, like how should this independent director be, such as like in the opinion of a board, the person should be of integrity and possess relevant expertise and experience, and this person is not a promoter or relative of a promoter of the company or its holding or its subsidiary or associate company. Further, this person does not have a fiduciary relationship, or the relative of this person, independent director, does not have a pecuniary not fiduciary, pecuniary relationship with the company or its holding or subsidiary or associate, plus their promoters or directors during the current financial year and the last two immediately preceding financial years, and he has at most the maximum is 2% of the total voting power. So this is regarding independent directors. Then we also discussed that by the provision we say that there is a maximum of 15 directors in a company, but it also depends upon the articles of but they can increase the number of directors with special resolution by the members. And then we have a director elected by small shareholders. So every listed company may have one director elected by the small shareholder. It is may have, that is not mandatory, but it is preferred. Then who is a small shareholder? So these are people who holds shares of nominal value, that is of less than 20,000 rupees, that is 20,000 rupees or less, in a public company. And then we discuss about the appointment of directors, that is in 4 ways. That is the first directors, then appointment of directors by the shareholders, then appointment of directors by the board. By the board, it is the additional director or the alternate director or the directors filling casual vacancy. Only those directors are appointed by the board. And then we have appointment of director by the third parties, also known as the nominee directors. And then we discuss about the disqualification of directors. All the points in disqualification of directors also comes under the vacancy of office. Plus we have some additional 2 points in vacancy of office. Then we discuss about the restriction on number of directorship. It's not the restriction on number of directors, it is the restriction on number of directorship. So a person can at most be a director in cannot be in director in more than 20 companies at a time, and more than 10 in a public director of a public company. In case of public companies, it's maximum of 10 public companies at a time, and in general it is maximum 20 companies at a time. A person can hold the office of director only in 20 companies at a time. In case of public company, it's 10. So if he does not adhere to this provision, he is also punishable. And then we discuss the remuneration of directors. So the amount of remuneration payable to the directors and managers in respect of a financial year shall not exceed 11% of the net profits of the company. Then we discuss about the legal position of the directors. We discuss about the duty to disclose interest and the punishment for it if in default. Then we discuss about the loans to directors, then duties to directors, then vacation of office by directors, resignation of directors, and removal of directors. The next topic is meeting of board. The directors of the company are empowered to do several acts for the successful management of the company. Directors of the company exercise most of their powers at the meeting of the board. The following are the rules relating to the meeting of the board. 1. Number of meetings. Every company shall hold the first meeting of the board of directors within 30 days of the date of its incorporation. That is, the first meeting should be within 30 days of the date of its incorporation. Thereafter, it shall hold a minimum number of 4 meetings of the board of directors in every year. Between 2 meetings, there should not occur an intervention of more than 120 days. So, there should be a meeting within 30 days of the date of the company's incorporation, and thereafter there shall be a minimum of 4 meetings of the board of directors in every year. Between 2 meetings, there should not occur an intervention of more than 120 days, that not more than 4 months difference. And now the participation of directors in a meeting of the board may either in person or through video conferencing or other audio visual means. The participation of the directors in a meeting may be through of the board may be through either in person
or through video conferencing or other audio visual means. The second one is notice of meeting. So we are discussing the rules relating to the meeting of board. So we discussed the number of meeting, and the next one is notice of meeting. A meeting of the board shall be called by giving not less than 7 days notice in writing. So there should be a 7 days notice in writing. The notice is to be given to every director. The notice should be sent to the registered address with the company. It may be sent by hand delivery or by post or by electronic means. And now the third one, with regard to the rules regarding meeting, is quorum of meeting. The quorum of meeting of the board is 1/3 of its total strength or 2 directors, whichever is higher. So either 1/3 of its total strength or 2 directors, whichever is higher. The participation of directors by video conferencing or by other audio visual means shall also be counted for the purpose of quorum. Now the fourth one is adjournment of meeting. If a meeting of the board cannot be held for want of quorum, it automatically stands adjourned to the same day in the next week. That is the same day in the next week. But this is by default, but the board of directors can also fix another day if they decide so. Now the minutes book. The proceedings of every meeting of the board are to be recorded in the minutes book. And the sixth one is restriction on voting. When a director or his relative or a firm in which he or his relative is a partner has to enter into contract with a company for sale, purchase or supply of goods, materials or service, the contract should be approved by the board by a resolution passed at its meeting. In the board meeting, the interested director shall not participate or vote. His presence would not be counted for the quorum. So he cannot vote and his presence will not be counted for the quorum. So with respect to the rules of the meeting of board, first one is the number of meeting, and then the notice of meeting. Then we have quorum of meeting, adjournment of meeting, minutes book, and restriction of voting. So the number of meetings first meeting shall be within 30 days from the incorporation of the company. Thereafter, every year there shall be minimum of 4 meetings, and between 2 meetings there shall not be an intervention of more than 120 days. Now even the video conferencing and other audio visual means is also considered for the quorum. Now the notice of meeting shall be given 7 days time, that is in writing. The notice should be in writing and it shall be given to the every director. Now the quorum, for the quorum in general rule is 1/3 of its total strength or 2 director, whichever is higher. Now adjournment in general rule, if a meeting doesn't happen due to the lack of quorum, then it stays adjourned to the same day next week. That is by general rule, but the board can also decide another day if they agree unanimously. And now the minutes book, which shall record all the proceedings of it's like a summary of every meeting that was held. It shall record all the proceedings. And then the restriction on voting. So if there is a meeting that is to enter into contract, the meeting is to enter into a contractual relation to someone the director is interested in or has a relation to, then in that meeting that particular director's presence is not calculated for quorum and he doesn't have voting right to. So that is with board meeting of board. Now the next topic is prohibition regarding political contributions. By section 182 of the Act, that is the Companies Act of 2013, a company other than a government company and a company which has been in existence for less than 3 financial years may contribute any amount directly or indirectly to any political party. A political party means a political party registered under section 29A of the Representation of Peoples Act 1951. So political party means a political party registered under section 29A of the Representation of Peoples Act 1951. So who can make a political contribution? That is a company other than a government company. So a government company cannot make a political contribution. Further, this company which has been in existence for less than 3 financial years. So a company which has been in existence for less than 3 financial years may contribute any amount directly or indirectly to any political party. And political party as defined in section 29A of the Representation of Peoples Act 1951. The aggregate contribution amount shall not exceed 7.5% of the net profit in a financial year. So there is a restriction to the amount that can be contributed in political contribution. So that shall not exceed, the aggregate shall not exceed 7.5% of the net profit in any financial year. A resolution authorizing payment passed at a meeting of the board of directors is required to make political contribution. Further, this should be authorized by a resolution passed at the meeting of board of directors. That is a political contribution, and the maximum contribution that can be given is in aggregates at most 7.5% of the total net profit. Now, the company shall be discussed in its the company shall disclose in its profit and loss account any amount contributed by it to any political party during the financial year. The name of the parties and the amount paid to each is to be mentioned. If a company makes any contribution in violation of the above stated principles, the company shall be punishable with fine which may extend to 5 times the amount so contributed. That is severe punishment. The company shall be punished with fine which may extend to 5 times the amount so contributed. Every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 6 months and with fine which may extend to 5 times the amount so contributed. So the company has a liability as well as there is personal liability for the person who is in default. This is a company may be punished with a fine that may extend up to, that is maximum up to 5 times the amount so contributed, and the officer may be punished with a simple imprisonment up to 6 months along with a fine which may extend up to 5 times the amount so contributed. And that is and, so imprisonment and fine, that is not an or. So the next topic we have, that is with prohibition regarding political contribution, and the next topic we have is auditors. An auditor is a watchdog but not a bloodhound. So that is what is said. An auditor is a watchdog but not a bloodhound. So chapter 10, sections 139 to 148. So already discussed the sections from 148 to 172. That was in board of directors, I believe. Let me recheck that. I believe it's board of directors. 149 to 170. Yes, 172. I'm sorry, 149 to 172. Board of directors. So we are going to discuss about sections till 148 now. 139 to 148, I believe. Yes, 139 to 148. So 149 to 172, it's about board of directors, and auditors is discussed in section 139 to 148. So that these are the consecutive sections, and auditors is discussed in chapter 10, that is section 139 to 148 of the Companies Act 2013. So these sections deals with the appointment, removal, remuneration, powers, duties, etc. of auditors of the company. So the term audit means an examination of books of account by an authorized person. So the term audit means an examination of books of account by an authorized person. The person who is so authorized to examine the books of accounts of the company is called auditor. A company carries on business with the capital furnished by persons who buy its shares. The contributors of the capital are not in direct control of its application. The directors and superior officers of the company utilize the funds contributed by the shareholders. The Companies Act therefore provides for the employment of an auditor who is the servant of the shareholders and whose duty is to examine the affairs of the company on their behalf at the end of a year and report to them what he has found. So a company gets its share from the shareholders, but these shareholders cannot directly be involved with the function of the company. The directors and the superior officers function the company. So there has to be someone who acts on behalf of the shareholders. So the auditor actually acts on behalf of the shareholders. So what does the auditor do? He's a servant of the shareholders, and his duty is to examine the affairs of the company on their behalf, that is the behalf of the shareholders, at the end of a year, that is annually at the end of a year, and report to them what he has found. So the auditor report is relevant to the shareholders, and the auditor has to report it to the shareholders. Now, by section 139 of the Act, every company shall, at the first annual general meeting, that is AGM, first annual general meeting, appoint an individual or a firm as an auditor. The auditor so appointed shall hold office from the conclusion of the meeting till the conclusion of its sixth annual general meeting. So, in the first annual general meeting, they shall appoint a person or a firm as an auditor, and from the conclusion of that meeting till the conclusion of the sixth annual general meeting, this auditor or firm holds the office of the auditor. Now, thereafter, the auditor appointed by the members in the general meeting shall hold office till the conclusion of every sixth meeting. Now, so this keeps repeating. So it's always for the every sixth meeting that the auditor holds the office. It can be an individual or a firm. Now, before appointing an auditor, a written consent of the auditor shall be obtained. A company shall inform the auditor of his appointment. The company shall also file a notice of such appointment with the registrar within 15 days of the meeting in which the auditor is appointed. So, this appointment shall be informed to the registrar within 15 days from the date of appointment. A listed company shall not appoint or reappoint an individual as auditor for more than one term of 5 consecutive years. So, if it is a listed company, the listed company shall not appoint or reappoint an individual as auditor for more than one term of 5 consecutive years. Now, a firm shall not be appointed or reappointed as auditor for more than 2 terms of 5 consecutive years. So, with respect to a listed company, the how it is effective, what is the effect on individual and what is the effect on firm is different. So the effect of individual is that the company cannot appoint or reappoint the individual as an auditor for more than one term of the 5 consecutive years. So in 5 years he can be appointed only for one term. As with respect to a firm, in a period of 5 years, 5 consecutive years, he can be appointed only for 2 terms. So a firm shall not be appointed or reappointed as auditor for more than 2 terms of 5 consecutive years. So, an individual or a firm who has completed his or its term shall be ineligible for reappointment as auditor in the same company for 5 years from the completion of his or its term. So, this bar is only for 5 years. After 5 years, they may be appointed or reappointed after this 5 years. The board may fill any casual vacancy occurring in the office of the auditor. The auditor may be removed from office before the expiry of the term by the company in general meeting after obtaining the approval of the central government. So the removal requires the approval of the central government, and it is decided in the general meeting. The remuneration of an auditor is fixed by the company in general meeting. A person is entitled for appointment as auditor of a company only if he is a chartered accountant, that is CA. The following persons shall not be qualified for the appointment as auditor of a company. So we are going to discuss about the disqualification of a person to be a person or firm to be a like auditor, to be appointed as auditor. The first one, a body corporate. Second one, an officer or employee of the company. Third, a person who is a partner of an officer or employee of the company. Fourth, a person who is in the employment of an officer or employee of the company. Fifth, a person holding any security in the company. So all this is to avoid bias. So a body corporate, an officer or employee of the company, a person who is a partner of an officer or employee of the company. So all this is to avoid bias, undue influence, etc. It is to ensure the proper functioning of the auditing. Now, powers and rights of the auditor. The first one, the auditor of a company has a right of access to the books and accounts and vouchers of the company. Books, accounts, and vouchers of the company. Now, the second one, he is entitled to require from the officer of the company information and explanation for the performance of his duties as auditor. So he can he's entitled. That is, it is his right to ask the company for a feedback or how he is performing as an auditor. So, for the information as well as explanation. The third one, he has right to receive notice of any general meeting of the company. Fourth one, he has a right to attend any general meeting. So he also has a right to attend any general meeting. Fifth one, he has right to receive remuneration, obviously. So the powers and rights of the auditor, the first thing is that he, of course, he's an auditor. He has the right to access the books, accounts, and vouchers of the company. And the next one is that he has a right to inquire about his performance as an auditor. That is, require the officers of the company information explanation of the performance of his duties as auditor. And the third one is he has right to receive notice about the general meeting, any general meeting of the company. Then he has a right to attend any general meeting. And the last one, he has right to receive remuneration. Now, duties of auditor. The first one is that he has a duty to inquire whether the loans and advances made by the company on the basis of security are properly secured. So, first duty is that he has a duty to inquire whether the loans and advances made by the company on the basis of security are properly secured. The second one is whether loans and advances made by the company are shown as deposits. Third one, he has to inquire whether personal expenses are charged to revenue account. Fourth one, he has to inquire whether cash is actually received on the issue of shares. Fifth one, he has to inquire whether the book of accounts are properly maintained. So, to summarize his duties, he has to know whether any loans and advances made by the company has been secured properly, and then he has to make it sure that the personal expenses are not charged to revenue account, and he has to ensure that the cash is actually received after issuing the shares. The cash is actually received, and then he also has to make sure that all the accounts are maintained properly. So these are the 5 duties of the auditor. Now, the auditor owes the duty to check the accuracy of accounts. An auditor is not bound to be a detective or to approach his work with a suspicion, but he is a watchdog but not a bloodhound. He can believe the servants of the company. So he has to watch, but he doesn't have to hunt. So he can believe the servants of the company. He is entitled to assume that they are honest. He is only bound to be reasonably cautious and careful. So that is with auditors that we looked into the sections which deals with auditors. That is chapter 10, section 139 to 148. Here we also discussed that the next portion of these sections, that is 149 to 172, is dealing with board of directors. So please study these in relation. Auditors, section 139 to 148, chapter 10. And then we discuss what does audit means, and then the how an auditor is appointed, what are the duties of duties and powers of the auditor, and the disqualification of an auditor. And then we also looked into the liability, or like how keen an auditor should be, that he can believe the employees of the company. He has to be a watchdog. He has to ensure the accuracy, but he doesn't have to stay in high alert and be suspicious of the employees. He acts as a watchdog but not a bloodhound. So he can believe the servants of the company, and he's entitled, it's his right to assume that they are honest. So he's only bound to be reasonably cautious and careful. And with that, we go move to the next topic, which is supremacy of majority and protection of minority, which is commonly known as rule in force versus habit. And this is one of the important topic. rule in Force versus Harbottle and its exception, that is prevention of oppression and mismanagement. That is the next one of the most important topic you can say. So, rule in Force versus Harbottle or prevention of oppression and mismanagement. Company administration is based upon democratic principles. The overall power of controlling the affairs of the company is vested with the members. The question relating to the management of the affair of the company is to be declared upon either by a simple majority or by a special majority. So, the principle of a company management is that the majority decision must prevail because we take simple majority or special majority. So, it's always the majority that prevail. Now, the rule of supremacy of majority of shareholders was legally recognized in the well-known case of Force versus Harbottle. So, always remember this case, Force versus Harbottle, 1843. In this case, an action was brought by two shareholders in a company alleging that the directors were guilty of fraudulent acts which resulted in a loss to the company. In the general meeting of the company, the majority of the shareholders resolved not to take any action against the directors. The court dismissed the suit filed by the minority shareholders on the ground that the decision of the majority should prevail. The result of this decision is that if at a validly convened meeting a resolution is passed by majority, it is binding upon the minority and the court will not interfere to protect the minority against the consequences of the resolution. This basic rule is known as rule in Force versus Harbottle. So, exceptions to this rule, that is, this rule may not, from the facts of the case you can see that this is not injustice, this is not justice to the minority. So, let's see to the exceptions of this rule. The general rule enunciated in Force versus Harbottle recognizes that the will of the majority must prevail over the minority. However, there are a number of occasions on which the minority shareholders can bring an action challenging the validity of the majority decision. They are the exceptions to the rule in Force versus Harbottle. These exceptions are based on the principle of natural justice and fair play. There it is. That is what we are looking for. The principle of natural justice and fair play. The following are the exceptions in the rule in Force versus Harbottle. The first one, acts ultra vires or illegal. If the decision of the majority is ultra vires, the ultra vires to the memorandum or Companies Act, the minority can bring a suit to challenge the validity of the majority decision. So we have a case law here, that is Edward versus Halliwell. Edward versus Halliwell, 1950. In this case, the minority shareholders challenged the validity of majority decision to pay dividend out of capital. The payment of dividend out of capital is an illegal act. The court held that such a situation, even a shareholder can apply to the court for an injunction restraining the company from doing the act. Even a single shareholder can challenge this act because this is an illegal act, and this was held in Edward versus Halliwell, 1950. So it is regarding acts ultra vires or illegal. So this was relating to any act that is ultra vires to the memorandum or the Companies Act. The second exception we have is to prevent fraud on minority. If the majority of the company's member use their power to defraud the minority, the court will interfere at the instance of the minority and will upset the majority scheme for doing harm. So here we have a case law, that is Menier versus Hooper's Telegraph Works Limited. Menier versus Hooper's Telegraph Works Limited, 1874. The majority members of the company A were also members of company B. At the meeting of company A, the majority resolved to compromise an action against company B in a manner favorable to company B. The court held that the minority members of the company A could bring an action to set aside the compromise decision. If the majority of a company takes a decision to the benefit themselves at the expense of minority, the court will interfere to protect the minority. So it's clear that the majority shareholders of A were the majority shareholder of B. So they made a decision in favor of B because it was in a way favorable to themselves. But the minority shareholders of A suffered in this. So the court was of the opinion that here it is injustice to the minority shareholders and they can bring an action against this. Now the third scenario is acts against the articles. So earlier we discussed an act that is ultra virus to the memorandum as well as Companies Act or memorandum or the Companies Act. Now we are going to discuss acts against the articles of association. If the majority resolve to do an act inconsistent with the articles of association of a company, the minority can bring an action to restrain the majority from doing an act. So we have a case law here, that is Brown versus British Abrasive Wheel Company. Brown versus British Abrasive Wheel Company, 1919. Here, a majority decided to buy out of the minority with a view to expand the capital. The minority refused to sell their shares. The majority then altered the articles by passing a special resolution in order to enable them to buy the shares of the minority. The court held that the alteration was for the benefit of the majority and not for the benefit of the company as a whole. Hence, the alteration could be restrained. So the fact itself is very clear. The alteration of articles of association was done to carry out something that is not beneficial for the company but for personal benefit. The court held that if this is not possible. So if the same act was done for the benefit of the company, then the court wouldn't have intervened with it. Now the fourth situation is violating personal rights of individual members. If the majority decision violates the rights of a single shareholder conferred under the Companies Act or the articles of the company, the court will interfere at the instance of even a single shareholder. So even a single shareholder can bring an action if the personal rights is violated. Now the fifth situation is oppression and mismanagement. So this is dealt in chapter 16, that is section 241 to 246. So oppression and mismanagement is dealt in section 241 to 246. So we have this 5 situations where the court may interfere with the majority decision. That the first one is the acts ultra vires or illegal. Then the second one is to prevent fraud on minority. Third one is acts against articles. Fourth one is violating personal rights of individual members. And the fifth one is oppression and mismanagement. So these are the situations where the court will intervene with the majority decision. Now we are yet to see what is oppression and mismanagement. This is an important topic as such for short essay as well as problem. So here oppression and mismanagement is discussed under chapter 16. That is sections 241 to 246. Sections 241 to 246 of the Companies Act 2013 provides for prevention of oppression and mismanagement. The power to prevent oppression and mismanagement of a company's affair is vested with the National Company Law Tribunal. So this is vested with National Company Law Tribunal. Any member or members of a company may apply to the tribunal to prevent oppression or mismanagement. The member who applies for a relief should be holding not less than 1/10 of the issued share capital of the company, and he should have paid all calls and other sums due on his share. So what is the condition here? The member who applies for a relief. So it should be applied to the National Law Tribunal, and the one who applies for a relief shall be holding not less than 1/10 of the issued share capital of the company, and he should have paid all calls and other sums due on his share. So he should have paid everything that he owes to the company. That is in short. If the affair of the company have been conducted in a manner prejudicial to the public interest or in a manner prejudicial or oppressive to him, any member can apply to tribunal for appropriate relief. So, if the affairs of the company have been conducted in a manner prejudicial to public interest or to oppressive to him, that is the one who applies, or to prejudicial or oppressive to the person who is applying, any member. Here we are not keeping a restriction of 1/10 of the issued share capital. It says any member can apply to the tribunal for appropriate relief. In the case of a company having a share capital not less than 100 members, so in the case of a company having a share capital not less than 100 members or not less than 1/10 of the total number of its members, whichever is less. So not less than 100 members or not less than 1/10 of the total number of members, whichever is less, can also make an application jointly and seek remedy from the tribunal. In an action for prevention of oppression and mismanagement, the tribunal can pass appropriate orders for bringing an end to the matters complained of. So, who are the people who can move to the National Law Tribunal? In the first case, we discussed about a member who holds minimum of 1/10 of the share capital, and this person should have paid all the money that he owes to the company, that he has paid all the calls and he has paid all dues. He doesn't owe any money to the company. That person, or in case the company is conducting the affairs of the company in a prejudicial manner, in the prejudicial to the public interest, or the prejudicial or oppressive to the person who is applying. In that case, any member need not be a 1/10 shareholder or something. Any member can approach the court. And in the third scenario, what they say is that if in a company having a share capital, if not less than 100 members or not less than 1/10 of the total number of members. So it's not the share capital we discuss here, it is the number of members we are discussing here. That is minimum of 100 members or 1/10 of the total number of members, whichever is less, they can jointly seek remedy from the tribunal. So the tribunal can act inter alia pass 1. An order to regulate the conduct of the affairs of the company in future. Second, an order terminating or setting aside or modifying any agreement between the company and the managing director or any other director or manager. So we are discussing what are the orders that can be passed by the tribunal. The tribunal here we are discussing is the National Law Tribunal. So 1. An order to regulate the conduct of the affairs of the company in future. 2. An order terminating or setting aside or modifying any agreement between the company and the managing director or any other director or manager. 3. An order terminating or setting aside or modifying any agreement between the company and any other person. Now 4. An order removing managing director, manager or any of the directors of the company. 5. An order prescribing the manner in which the managing director or manager of the company is to be appointed subsequent to an order removing the existing manager, director or manager. 6. An order to recovery of undue gains made by managing director, manager or any other director during the period of the appointment. Then 7. An order restraining the company from committing an act which is ultra vires to the articles or memorandum. 8. An order to restrain the company from committing breach of any provisions of the company's memorandum. 9. An order to declare the resolution altering the memorandum or articles of the company void if the resolution was passed by suppression of material facts or obtained by misstatement of the members. 10. An order to restrain the company and its directors from acting on such resolution. 11. An order to restrain the company from doing an act which is contrary to the provisions of the Companies Act or any other law for the time being in force. 12. An order to restrain the company from taking action contrary to any resolution passed by the members. 13. An order awarding damages or compensation from the company or its directors for any fraudulent, unlawful or wrongful act or omission on its or their part. 14. An order rewarding damages or compensation from the auditor for any improper or misleading statement of particulars made in his audit report for any fraudulent, unlawful, wrongful act or omission. 15. An order awarding damage or compensation from any expert or advice or consultant for any incorrect or misleading statement made to the company for any fraudulent, unlawful, or wrongful act or omission on his part. So these 15 cases were discussed here. So if we summarize it, we can say that by the order of the tribunal can give order to regulate the function of the companies and keep a check on the proper if the directors as managing directors, auditors, all of them are doing their duties in a proper way, keeping the accounts proper, if there is any misstatement. And it also ensures that ensures a remedy when a third party, someone outside the company, is giving a misstatement to the company. Then it also governs the if the meetings and the resolutions are taken as per the procedure, if there is any suppression of material facts, if such a resolution is not proper, the tribunal may restrain from executing that resolution. So in short, these are the activities, these are the things that the tribunal can order the company to do. Also other person. In the last, we also discussed about awarding damages or compensation from any expert or advisor or consultant for any incorrect or misleading statement made to the company for any fraudulent and unlawful or wrongful act. So the last point we also discussed where the court is awarding damages to the company for damages or compensation to the company for any wrongful act done by person, that is an expert or advisor or consultant. So these are the things that the tribunal can pass an order to. So the above stated orders are only illustrative and not exhaustive. So all kind of remedies, or you can seek for remedy for all kind of violations of provisions or violation of rights of all kind of remedies can be sought from tribunal. These are just some of the illustrative ones. The tribunal can pass any other order if it thinks fit. Now we have a case here, that is Shanti Prasad Jain versus Kalinga Tubes Limited. Shanti Prasad Jain versus Kalinga Tubes Limited, 1965. Here, a private company had 3 shareholders holding equal number of shares and with equal representation on the board. In order to utilize a loan facility offered by the Orissa government, the company was converted into a public company. I'm sorry, I'm having a cold. So we are discussing about Shanti Prasad Jain versus Kalinga Tubes. So this was a private company and had 3 shareholders. These 3 shareholders had equal number of shares and with equal representation on the board. In order to utilize a loan facility offered by the Orissa government, the company was converted into a public company. A substantial increase of capital was proposed by issuing 39,000 more shares. So there was a substantial increase of capital was proposed by issuing 39,000 more shares. By section 81, please note, by section 81 of Companies Act, these shares should be first offered to the existing shareholders, but the majorities allotted the shares to outsiders selected by the majority. The petitioner contended that the allottees were friends of the majority and allotment was made purposely with the malified intention to increase their voting strength and to squeeze out the petitioner. So what happened is that a private company with 3 shareholders having equal shares and equal representation on the board, they converted this company into a public company so that they can make use of a loan facility from the Orissa government. And they wanted to substantially increase the capital and they offered 39,000 shares to be issued. By section 81, the existing shareholders should get the allotment first, or should be first offered to existing shareholders, these allotment. But instead what they did was that they allotted these to some outsiders who were selected by the majority. So the petitioner was also one of the allottees and
he uh, this petitioner contended that the allottees were all friends of the majority, and the allotment was made purposely with the malified intention to increase the voting strength. So the friends will always support the friends. So the voting strength of the other person will be higher. And this was done to squeeze out the petition. That was the contention of the petitioner. Now let's see what the court said. The court held that the act of majority did not amount to oppression on minority. It was pointed out by the court that mere frivolous and wild allegations were not sufficient. A persistent and persisting course of conduct must be shown. So here the court held not in favor of the petitioner, the court held it in favor of the respondents, and the court held that the act of majority did not amount to oppression on minority, and the court pointed out that the mere frivolous and wild allegations were not sufficient. A persistent and persisting course of conduct must be shown. Now, in another case law, that is Rajamundry Electric Supply Corporation versus Nageshwara Rao. Rajamundry Electric Supply Corporation versus Nageshwara Rao, 1956. Here, a petition was presented by some minority shareholders against the company, alleging that the directors mismanaged the affairs of the company. The majority of the shareholders had not taken any decision to proceed against the directors. The court held that there was sufficient evidence of mismanagement and appointed two administrators to manage the company for 6 months. Now, in another case, Ramashankar Prasad versus Sindri Iron Foundry Private Limited. That is Ramashankar Prasad versus Sindri Iron Foundry Private Limited, 1966. In this case, the minority overthrown the majority by physical force. The court held that it amounts to oppression of the majority by a minority, and the decision of minority was set aside. So what happened here is not oppression of minority but oppression of majority. The minority overthrew the majority by physical force, and the court held that it amounts to oppression of the majority by a minority, and the decision of the minority was set aside. So that is with the rule and exceptions in the rule to force versus Harbottle. Then we also discussed what happened in force versus Harbottle. Once more, I will discuss force versus Harbottle. So what happened here was an action was brought by two shareholders in a company alleging that the directors were guilty of fraudulent acts which resulted in a loss to the company. That is only two shareholders against the majority. In the general meeting of the company, the majority of the shareholders resolved not to take any action against the directors. So the decision of the majority was not to take any action against the directors who are alleged to be guilty. Now the court dismissed the suit by the minority shareholders on the ground that the decision of the majority should prevail. So that is what was said in the force versus Harbottle, that the decision of the majority shall prevail. So this is the general rule. Now there are some exceptions to this, and that is the most important one, that is the prevention of oppression and mismanagement here. So the cases, circumstances where, or the exceptions of the force versus Harbottle rule, or the decision that the decision of the majority shall prevail over the minority, we discussed few situations. That is, one is act ultra-virus or illegal. Two, to prevent fraud or on minority. The third one is act against the articles. The fourth one is violating personal rights of individual members, and the fifth one, oppression and mismanagement. So these are the exceptions of force versus Harbottle, and oppression and mismanagement is discussed in chapter 16, section 241 to 246, and we also discussed some case laws where the court held that there is no in Shanti Prasad Jain versus Kalinga Tubes, the court held that there is no oppression on minority, and mere frivolous and wild allegations were not sufficient. A persistent and persisting course of conduct must be shown. And later in Rajamundry Electric Supply Corporation and Nageshwara Rao, the court held in favor of the plaintiff and held that there was sufficient evidence of mismanagement, and they appointed two administrators to manage the company for uh, 6 months. So the court appointed administrators to manage the company for 6 months. And later in Ramshankar Prasad versus Sindri Iron Foundry Private Limited, we saw a twist of scenario, that is, we saw that the majority was overthrown by the minority by physical force. And here the court said that this is oppression of the majority by a minority, and the decision of the minority was set aside. So that is with Force versus Harbottle and its exceptions, or the oppression and mismanagement. So the next topic we have is sick companies, revival and rehabilitation. So chapter 19, section 253 to 269 deals with revival and rehabilitation of sick companies. So declaration of a company as sick company. The jurisdiction to declare a company as a sick company is vested with the National Company Law Tribunal. In order to declare a company as a sick company, an application is to be filed to the secured creditors of the company. So, in order to declare a company as a sick company, an application is to be filed by the secured creditors of the company. If on demand by the secured creditors of a company representing 50% or more of its outstanding amount of debt, the company has failed to pay the debt within the period of 30 days of the service of the notice of demand, or to secure or to compound it to the reasonable satisfaction of the creditors, any secured creditor may file an application to the tribunal for a determination that the company be declared as a sick company. So what is it? A company, if on a demand by a secured creditors of a company representing 50% or more of its outstanding debt. Now, when 50% or more of its outstanding debt is being of the secured creditor is demanding it, now the company has failed to pay the debt within a period of 30 days. So how many days does the company have? 30 days. If the company failed to pay the debt within the period of 30 days of the service of the notice of demand, that is one, failure of paying of debt, or to secure or compound it to the reasonable satisfaction of the creditor. So either the company pay it within 30 days or secure or compound it to the reasonable satisfaction of the creditors. If they fail to do either of it, then any secured creditor may file an application to the tribunal for a determination that the company be declared as a sick company. So what should be the quantum of debt? That is 50% or more of its outstanding amount debt. So if on a demand by the secured creditors of a company representing 50% or more of its outstanding amount of debt. So that is a quantum of debt being demanded, and the company has 30 days to either pay or to secure or compound it to the reasonable satisfaction of the creditors, failing which the secured creditor may file an application to the tribunal for a determination that the company be declared as a sick company. Now the tribunal shall, within a period of 60 days of the receipt of the application. So after the service of notice of demand, the company has 30 days, and in failure of which if the secured creditor has moved to the tribunal within a period of 60 days of the receipt of the application determine whether the company is a sick company or not. It is to be done after giving the company a reasonable opportunity of being heard. If the tribunal is satisfied that a company has become a sick company, but the company is able to pay its debt within a reasonable time, the tribunal shall give such time to the company to make repayment of the debt. Now, revival and rehabilitation of sick company. So far we discussed how a company would be declared a sick company and what is the grace period, like if the tribunal would give a grace period, and if so, what is the condition for it. And now we are going to look into revival and rehabilitation of sick company. On determination of a company as a sick company, any secured creditor or the company may make an application to the tribunal for the determination of the measures that may be adopted for the revival or rehabilitation of the company. Such an application is to be filed within a period of 60 days from the date of determination of the company as a sick company. So, once the company is determined as a sick company, it should be filed within a period of 60 days for revival. Along with the application of a draft scheme of revival and rehabilitation is to be filed. If the sick company has filed an application and it has no draft scheme to offer, it shall file a declaration to that effect. So, the company should show a draft scheme of how it can revive and pay the demand or clear the demand. If the company doesn't have a draft to offer, then it shall file a declaration to that effect, that is acceptance of being a sick company. On receipt of an application for revival or rehabilitation, the tribunal shall appoint an interim administrator. So there is an interim administrator to convene a meeting of the creditors of the company and to consider whether it is possible to revive or rehabilitate the sick company. He has to submit his report to tribunal within 60 days. So, if the application for revival or rehabilitation is received, the tribunal will appoint an interim administrator. What does he do? He will convene a meeting of the creditors and consider whether it is possible to revive or rehabilitate the sick company. And his decision or his report has to be submitted to the tribunal within 60 days. So, once the company on demand, once the company defaults, the secured creditor has to file to the tribunal within 30 days, and from the tribunal they have to decide within 60 days, and the application for revival or rehabilitation has to be filed within 60 days, and once the interim administrator is appointed, he has to submit the report within 60 days. So that is the period they have. If the application of revival and rehabilitation is filed by sick company and it has no draft scheme of revival or rehabilitation to offer, the tribunal may direct the interim administrator to take over the management of the company. The tribunal may issue directions to protect and preserve the assets of the sick company and for its proper management. After hearing the parties and on consideration of the report of the interim administrator, the tribunal is satisfied. If the tribunal is satisfied that the creditors representing 3/4 in value of the amount of outstanding against the sick company present and voting have resolved that 1. It is not possible to revive and rehabilitate such company, the tribunal shall order the proceedings for the winding up be initiated. The second, by adopting certain measures, the sick company may be revived and rehabilitated. The tribunal shall appoint a company administrator for the company and cause such administrator to prepare a scheme for the revival and rehabilitation of the sick company. So after hearing the parties and on the consideration of the report, what the tribunal is satisfied that the creditors representing 3/4 in value of the amount outstanding against the sick company present and voting has resolved. They can resolve two things, that is either it can be revived or it cannot be. If it cannot be revived, it will be proceeding for winding up will be initiated. If the company can be revived and rehabilitated, then a company administrator will be appointed to cause such administrator to prepare a scheme for revival and rehabilitation of the sick company. But here the tribunal considers 3/4, the creditors representing 3/4 in value of the amount standing. So initially, to move the application to declare a company sick, it was discussed that if on demand by the secured creditors of a company representing 50% or more, so it was 50% or more, but here in decision of winding up or in appointment of company administrator, here the tribunal considers the creditors representing 3/4 in value of the amount outstanding against the sick company. Now, the company administrator shall prepare a scheme of revival and rehabilitation of the sick company. The scheme prepared by the company administrator shall be placed before the creditors in a meeting convened for their approval. If the scheme is approved, the company administrator shall submit the scheme before the tribunal for sanctioning the scheme. On receipt of the scheme, the tribunal shall, within 60 days, please not 60 days, pass an order sanctioning such scheme. A copy of the sanctioned scheme shall be filed with the registrar by the sick company within a period of 30 days. So, the copy of the sanctioned scheme shall be filed with the registrar by the sick company within a period of 30 days from the date of receipt of copy thereof. The tribunal shall authorize the company administrator to implement the sanctioned scheme. So, the tribunal shall authorize the company administrator to implement the sanctioned scheme. If the scheme is not approved by the creditors, the company administrator shall submit a report to the tribunal within 15 days. Not it's 15 days, and the tribunal shall order for the winding up of the scheme. So, if the scheme prepared by the administrator is not accepted by the creditors, the report is sent to the tribunal within 15 days, and in that case, the winding up process is started. So, that is with sick company revival and rehabilitation. So, the next topic is winding up of company. So, this is the most biggest topic in this subject with respect to AKN sir's note. So let's start with it. A company is an artificial person. It is a creature of law, and whenever it is decided to put an end to the life of the company, it can be done only through legal process. A company's life can be ended by the process of winding up or liquidation. Winding up or liquidation of a company represents the last stage of its life. It is the process of putting an end to the life of the company. It is a proceeding by which a company is dissolved. In the course of such dissolution, the assets of the company are realized, the debts of the companies are paid off out of the realized assets, and the surplus, if any, is then paid off to the members in proportion to their holdings in the company. According to Gower, winding up of a company is a process whereby its life is ended and its property administered for the benefits of its creditors and members. An administrator called liquidator is appointed, and he takes the control of the company, collects its assets, pays its debts, and finally distributes any surplus among the members in accordance with their rights. Now, on the dissolution, the existence of the company comes to an end, and its name is struck off by the registrar from the Register of Companies. Chapter 20, Section 270 to 365 of the Companies Act 2013. So, winding up is one of the most biggest topic. So, Chapter 20, Section 270 to 365. Section 270 to 365 of the Companies Act 2013 deals with the winding up of companies. So, we have two modes of winding up. So, by Section 270 of the Companies Act 2013, the winding up of a company can be either by the tribunal or voluntary. First, we will look into winding up by the tribunal. Section 270 to 303. Section 270 to 303 and sections 324 to 365 deals with winding up by the tribunal. Once again, section 270 to 303 and 324 to 365. 270 to 303 and 324 to 365 deals with winding up by the tribunal. The winding up of a company as per the order of the National Company Law Tribunal can be called the compulsory winding up by tribunal. So, winding up by the tribunal is also called compulsory winding up by the tribunal. It is discussed in section 270, sections 270 to 303 and sections 324 to 365. And overall winding up is discussed in chapter 20, that is sections 270 to 365. It has two modes of winding up, that is winding up by the tribunal and voluntary winding up. Winding up by the tribunal is also called as compulsory winding up by tribunal. This is discussed in section 270 to 303 and sections 324 to 365 of Companies Act 2013. Now, earlier the winding up of a company could be ordered by the high courts. Now the jurisdiction to order winding up is conferred to National Company Law Tribunal. The National Company Law Tribunal can order the winding up of a company under section 271. So the National Company Law Tribunal can order the winding up of a company under section 271 under the following circumstances. So now we are going to look into the circumstances where compulsory winding up or winding up by the National Company Law Tribunal is done. So the first one is inability to pay debts. So we just discussed about sick company, that will also come under this. So if a company is unable to pay its debts, the tribunal may order its winding up. A company shall be deemed to be unable to pay its debt in the following three cases. So what are the following? What are the three cases where a company is deemed to be unable to pay its debts? A. If a creditor to whom the company owes a sum exceeding 1 lakh has served on the company a demand notice for payment and the company has failed to pay the sum within 21 days after the receipt of the notice, or to provide adequate security or restructure or compound the debt to the reasonable satisfaction of the creditor. So here it is discussed as 1 lakh. Now, I have a doubt with the sum, but it is printed as 1 lakh here. Yeah, I do have a doubt if it's 1 lakh because that seems too small for a company, but here it's printed as 1 lakh. Now, the second option is if any, second circumstance is if any execution process issued on a decree or order of any court or tribunal in favor of a creditor is returned unsatisfied in whole or in part. So, if any execution process issued on a decree or order by any court or tribunal, so there is an execution process or decree that can be by decree or order, so that can be by a court or tribunal in favor of a creditor, and it has returned unsatisfied. It might be wholly or partly. In both cases, it can be considered as deemed to be unable to pay. And now the third circumstance, that is if it is proved to the satisfaction of the tribunal that the company is unable to pay its debts. For determining whether a company is unable to pay its debts, the tribunal shall take into account the contingent and prospective liabilities of the company. So these are three situations where a company is deemed to be unable to pay its debts. So this is the first circumstance where a National Company Law Tribunal will process for or order for winding up, that is compulsory winding of the up of the company. That is the first thing is inability to pay debt, and these are the three circumstances where the tribunal deemed a company unable to pay its debt. Now we have two case laws here. One is Sri Lakshmi Silks versus Ramanika Silks Private Limited. Sri Lakshmi Silks versus Ramanika Silks Private Limited, 1998. The respondent company owed to the petitioner a sum of Rs 20,05,150. The petitioner filed an application for compulsory winding up of the respondent company. The respondent raised certain defences. The court held that the defences set up was not in good faith and the winding up of the respondent company was ordered. So that is Sri Lakshmi Silks versus Ramanika Silks Private Limited. Okay, and next is Ram Bahadur Thakur versus Sahu Jain Limited. Ram Bahadur Thakur versus Sahu Jain Limited, 1981. In this case, the court held that a creditor who files a petition for winding up of a company on the ground of inability to pay debts must have a claim exceeding rupees 500, that is now 1 lakh. Then it was rupees 500. That is, this case is in 1981. So then it was exceeding 500 and now it's 1 lakh against the company and must serve upon the company a notice of demand for payment. The debt must be presently payable and the title of the petitioner demanding it should be complete. So this debt must be presently payable. If a company has guaranteed a debt and the principal debtor failed to pay, the company is bound to pay the money. If the company also fails to pay the money, the creditor can file a petition for winding up. So these are the two cases discussed in inability to pay. Now the second one we have is special resolution. Okay, if the company passes a special resolution in its general meeting to wind up the company by the tribunal can order winding up of the company's affairs. And the next one we have is acted against sovereignty and integrity of India. If a company has acted against the interest of the sovereignty and integrity of India or the security of the state or friendly relations with foreign states or public order, decency or morality, the tribunal can order winding up of the company. And the next we have sick company. We have already discussed about sick company. By section 265 of the Act, the tribunal can order the winding up of a sick company. Once such an order is passed, the sick company will be wound up as per the provisions applicable to the winding up of any other company. Now the next one is application by registrar. So the registrar or any other person authorized by the central government can apply to the tribunal to order winding up of a company on the following grounds. So we have 3 grounds mentioned here. The first one is the affairs of the company have been conducted in a fraudulent manner. Second one, the company was formed for fraudulent and unlawful purpose. Third is the persons concerned in the formation and management of its affairs have been guilty of fraud, misfeasance or misconduct in connection thereof. So the grounds where the application by registrar is applicable is either the company is functioning in an unlawful or fraudulent manner and the formation was formed for fraudulent or unlawful purpose, or the the persons concerned with the formation or management of its affairs have been guilty of fraud, misfeasance or misconduct. So these are the 3 circumstances where the registrar would make an application to the tribunal for the winding up of the company. If the tribunal is of the opinion that the allegations is true, it can order winding up of the company. And then next we have default in financial statements and annual returns. So the next one is default in filing financial statements and annual returns. If a company has made a default in filing with the registrar its financial statements or annual returns for immediately preceding 5 consecutive years, the tribunal can order winding up of the company. If a company has made a default in filing with the registrar its financial statements or annual returns for immediately preceding 5 consecutive years, the tribunal can order winding up of the company. The next one is just and equitable. The tribunal may order for the winding up of a company if it is of the opinion that it is for just and equitable. What is just and equitable depends on what is just and equitable? It depends upon the facts of each case. The tribunal may order winding up under this head in the following cases. 1. When the substratum of the company is lost. Under the following circumstances, the tribunal may hold that the substratum of the company has lost and winding up may be ordered. A. The object for which the company was incorporated has substantially failed. B. It is impossible to carry on the business of the company except at a loss. C. The existing assets of the company are insufficient to meet the existing liabilities. So under these circumstances, we can say that the substratum of the company is lost. That is, the object for which the company incorporated has been substantially failed. Then it is impossible to carry on business of the company except at loss. And the third one is the existing assets of the company are insufficient to meet the existing liabilities. So we are discussing what is just and equitable. It depends on facts of each case. The tribunal may order winding up under the heads in the following cases. In the first one, we discussed that, like, what are the circumstances where the tribunal may order winding up. So in the first one, we discussed when the substratum of the company is lost, and the second one, that is when the majority of the shareholders are using their powers unfairly or have adopted an oppressive policy towards the minority. 3. If there is a deadlock in the management of the company. 4. If the public interest is likely to be prejudiced. 5. If the company was formed to carry on illegal business or when the business of the company becomes illegal. 6. If the company is only a merry bubble or sham. 7. In the case of a public company, if the number of members is reduced below 7, and in the case of a private company, if it is reduced below 2, the company may be ordered to be wound up. The following cases illustrate when the courts ordered winding up of companies under the ground just and equitable. The first one is German Date Coffee Company. The main object of the company was to manufacture coffee on a German patent. The company could not acquire German patent. The company, however, acquired Swedish patent and started manufacturing coffee. 2 shareholders of the company filed a petition for winding up on the ground that the substratum of the company has lost. The court ordered winding up because the main object of the company was to manufacture coffee on German patent. The company could not acquire German patent and acquired Swedish patent. So the main object of the company was substantially failed. So the 2 shareholders of the company filed petition for winding up on the ground that the substratum of the company has lost. The court ordered winding up. Now, the next case we have is N.K. Prasad versus Andhra Bank. That is 1983 case. N.K. Prasad versus Andhra Bank. The company was formed for banking business. The business of the company was nationalized and the compensation was paid by the government. The directors called a meeting for shareholders and proposed changes in the memorandum to start non-banking business. The shareholders dissented. The court held that it is a fit case for ordering winding up on the ground of just and equitable. In Ramachandran versus Naras Rawpat Electric Corporation. Ramachandran versus Naras Rawpat Electric Corporation 1964. The main business of the company was to supply electricity in a particular area. The business was taken over by the state. The compensation money paid by the state was put in a fixed deposit, and the company did no business for 17 years. The court held that the substratum of the company has been lost and thus ordered winding up. The next case we have here is Yenidje Tobacco Company Limited. Yenidje, Yenidje Tobacco Company Limited, Re. 1960. Here W and R were the sole shareholders and directors of the company with equal rights of management and voting power. They became bitterly hostile and disagreed about the appointment of important servants of the company. All communication between them were made through secretary. The company made huge profit in spite of the disagreement. The court held that there was deadlock in the management and ordered the winding up. So even though there was huge profit, the court held that there was deadlock in the management and ordered the winding up. That is Yenidje Tobacco Company Limited, Re. Now in Re Middlesbrough Assembly Rooms Company. Re Middlesbrough Assembly Rooms Company 1880. A company suspended its business for more than 3 years due to depression in trade. A shareholder presented a petition for winding up the company. Majority of shareholders opposed it. Court held that the company intended to continue its operation when trade prospects improved and the petition was dismissed. The next case we have have is Rupa Bharati versus Registrar of Companies 1969. Rupa Bharati versus Registrar of Companies 1969. There was failure to resume business for 5 years and the prospectus also seemed gloomy. The court ordered winding up of the company. Now, Registrar of Companies versus Chauchen Brothers Industries Limited, Private Limited. So, Registrar of Companies versus Chauchen Brothers Industries Private Limited, 1913. A company could not commence business for 3 years after incorporation. The court ordered winding up of the company. The Malabar Iron and Steel Works Limited versus the Registrar of Companies, 1965. The Malabar Iron and Steel Works Limited versus the Registrar of Companies, 1965. Here the court held that the power of the court to wind up a company is discretionary. If a company does not commence business for a year, the court may order winding up if there is no intention of commencing its business. If the delay is sufficiently accounted for, the court will not order winding up. So, we are discussing about compulsory winding up right now. It is ordered by National Company Law Tribunal, and the circumstances where compulsory winding up will be carried out is discussed as inability to pay debts, then special resolution, acted against the sovereignty and integrity of India, sick company, application by registrar, default in filing financial statement and annual returns, just and equitable. Under just and equitable, we went through a lot of case laws to understand what is just and equitable. Next, we are going to see who can apply for winding up order. So, by section 272 of the Act, the following persons can apply to the tribunal for winding up of the company. Okay. So, the first one is the company, when there is a special resolution passed by the shareholders. Now, the second person is any creditor or creditors, including any contingent or prospective creditors. Now, a secured creditor, the holder of any debenture, whether or not a trustee is appointed in respect of such debenture, the trustee for the holders of debentures shall be deemed to be the creditors of the company. Thus, they can also apply for winding up of the company. Now, the third person is any contributory or contributories. Contributory means a person who is liable to contribute towards the assets of the company in the event of its being wound up. A person who is holding fully paid up share in a company shall also be considered as a contributory, though he has no liability to contribute towards the assets of the company. So, a person who is holding fully paid up shares in a company shall also be considered as a contributory, though he has no liability to contribute towards the assets of the company. A contributory shall be entitled to present a petition for the winding up of the company, even if he is holding fully paid shares, or the company may have no assets at all, or the company may have no surplus assets left for distributing among the shareholders after satisfaction of its liabilities. Now, the fourth person who can apply for winding up is the registrar. The registrar can apply to the tribunal for winding up on the following grounds. The company is unable to pay its debt. If a company has acted against the interest of the sovereignty and integrity of India, or the security of the state, or friendly relation with foreign state, or public order, decency or morality. Then the third scenario is where if the affairs of the company have been conducted in a fraudulent manner, or the company was formed for fraudulent and unlawful purposes, or the persons concerned in the formation or management of its affairs have been guilty of fraud, misfeasance, or misconduct in connection therewith. And the last scenario is if a company has made a default in filing with the registrar its financial statements or annual returns or immediately preceding 5 consecutive years. The registrar shall obtain the previous sanction of the central government for presenting a petition for winding up. The government has to give an opportunity to the company to make its representation before sanction is accorded. Now, the fifth one is any person authorized by the central government in that behalf. The sixth one is the central government or state government. If a company has acted against the interest of the sovereignty or integrity of India, or the security of the state, or the friendly relations with foreign state, or the public order, decency, or morality, the central government or state government may make an application to the tribunal for winding up of the company. Now, commencement of winding up. By section 357, winding up of a company is deemed to have commenced from the time of the presentation of the petition and not from the date of the order of winding up. So, the winding up of a company is deemed to have commenced from the time of the presentation of the petition and not from the date of the order of winding up. If before the presentation of the petition a special resolution has been passed by the company for winding up by the tribunal, the winding up shall be deemed to have commenced at the time of the passing of the resolution. Now, power of tribunal during and at the end of the hearing. By section 273, when a winding up petition is filed, the tribunal shall proceed to hear the winding up petition. After hearing the petition, the tribunal may dismiss it with or without cost, make any interim order as it thinks fit, appoint a provisional liquidator of the company till the making of a winding up order, make an order for the winding up of the company with or without cost, any other order as it thinks fit. So, after hearing the petition, the tribunal may take either of the steps as mentioned. Now, an order under this section shall be made within 90 days from the date of presentation of the petition. So, either of these orders shall be made within 90 days. That is, dismiss it with or without cost, make any interim order as it thinks fit, appoint a provisional liquidator of the company till making of a winding up order, make an order for winding up of the company with or without cost, and finally any other order as it thinks fit. If the petition for winding up is presented on the just and equitable ground, the tribunal may refuse to make an order of winding up if it is of the opinion that some other effective remedy is available to the petitioner. Appointment of provisional liquidator and company liquidator. After the presentation of a petition for winding up and before making the winding up order, the tribunal may appoint a provisional liquidator of the company. A provisional liquidator is to be appointed from a panel maintained by the central government consisting of chartered accountants, advocates, company secretaries, cost accountants, etc. Before appointing a provisional liquidator, the tribunal shall give notice to the company and afford to it an opportunity to make its representation. The object of appointment of a provisional liquidator is to protect and preserve the asset of the company during the pendency of winding up petition. The provisional liquidator has to take into its custody or control all the property, effects, and actionable claims of the company. He has to take such steps and measures to protect and preserve the properties of the company. The properties so taken into his custody shall be deemed to be in the custody of the tribunal from the date of the order of the winding up. So that is from the date of the order of the winding up. At the end of the hearing on winding up petition, if the tribunal orders winding up of the company, the tribunal will appoint a company liquidator. He has to conduct the liquidation proceeding. An official liquidator or liquidator from the panel prepared by the central government may be appointed as the company liquidator. The tribunal may appoint the provisional liquidator, if any, as the company liquidator for the conduct of the proceedings for the winding up of the company. The liquidation proceeding after the winding up order are to be undertaken by the company liquidator who is appointed by the tribunal. Now we are going to proceedings after winding up order. So the first one is notification in the official gazette. So these are proceedings after winding up order. Notification in official gazette. If the tribunal passes an order for the winding up of a company, the tribunal shall give intimation to the company liquidator and the registrar. The petitioner and the company should also file a certified copy of the order with the registrar within 30 days. The registrar shall notify in the official gazette that a winding up order has been passed by the tribunal. Now, deemed notice of discharge. The winding up order shall be deemed to be a notice of discharge to the officers, employees, and workmen of the company, except when the business of the company is continued. Effect of winding up order. The order for winding up of a company shall operate in favor of all the creditors and all the contributories of the company as if it had been made out of the joint petition of the creditors and contributories. Stay of suits on winding up order. By Section 279 of Companies Act 2013, when a winding up order is passed or a provisional liquidator is appointed, no suit or other legal proceeding shall be commenced, or if pending at the date of the winding up order, shall be processed with, by, or against the company except with the leave of the tribunal. So, when a winding up order is passed or a provisional liquidator is appointed, no suit or other legal proceeding shall be commenced, or if pending at the date of the winding up order, shall be proceeded with, by, or against the company except with the leave of the tribunal. That is said in Section 279. Any application to the tribunal seeking leave shall be disposed of by the tribunal within 60 days. The restriction shall not be applicable to any proceeding pending in appeal before Supreme Court or High Court. So next we are going to jurisdiction of tribunal to try suits. Okay. So by Section 280, the tribunal shall have jurisdiction to entertain or dispose of A. Any suits or proceedings by or against the company. B. Any claim made by or against the company. C. Any question of priorities or any other question relating to assets, business, actions, rights, entitlements, privileges, benefits, duties, responsibilities, obligations, or in any matter arising out of or in relation to winding up of company. Now, whether such suit or proceeding has been instituted or is instituted, or such claim has arisen or arises before or after the order of winding up of a company is made. So the tribunal have jurisdiction to entertain and dispose of these matters. Now, the company liquidator plays the role of a hangman. When the tribunal makes the winding up order, it appoints a company liquidator to wind up the affairs of the company. He is in fact responsible to liquidate or wind up the affairs of the company, the last stage of a company. In this process, he has to do various functions. He is also bound by various duties. They are discussed below. Duty to file first report, that is preliminary report. Excuse me. So, duty to file first report or preliminary report. By Section 281 of the Act, the company liquidator shall within 60 days from the date of order submit to the tribunal a report containing the following particulars. A. The nature and details of the assets of the company, including their location and value, the cash balance in hand and in the bank, and the negotiable securities, if any, held by the company. B. The amount of capital issued, subscribed, and paid up. C. The existing and contingent liabilities of the company, including names and addresses of the occupations of its creditors. D. The debts due to the company and the names, address, and occupation of the persons from whom they are due. E. Guarantees, if any, extended by the company. F. The list of contributories and dues, if any, payable by them and details to unpaid call. G. The details of the trademarks and the intellectual properties, if any, owned by the company. H. The details of the subsisting contracts, joint ventures, and collaborations. I. The details of holding and subsidiary companies. J. The details of legal cases filed by or against the company. So, this is the first report or preliminary report. Now, duty to take custody of company's properties. The company liquidator has to take into his custody or control all the property, effects, and actionable claims of the company. He has to take such steps and measures to protect and preserve the properties of the company. The properties so taken into custody by the company liquidator shall be deemed to be in the custody of the tribunal from the date of order of the winding up. The next one is duty and right to seek assistance of winding up committee. The tribunal, when ordering winding up of a company, appoint a person as company liquidator. The company liquidator so appointed shall make an application to the tribunal within 3 weeks from the date of winding up order for consultation of a winding up committee to assist and monitor the progress of the liquidation proceedings. So, this application shall be made by the company liquidator to the tribunal within 3 weeks. And for constitution of a winding up committee to assist and monitor the progress of liquidation proceeding. The winding up committee shall comprise the following persons: 1. Official liquidator attached to the tribunal. 2nd, nominee of secured creditors. And the 3rd one, a professional nominated by the tribunal. The company liquidator shall be convener or convener. Okay, the company liquidator shall be the convener of the meetings of the winding up committee, which shall assist and monitor the liquidation proceeding in the following areas of liquidation functions, namely, the first one, taking over assets. 2nd, examination of the statement of affairs. 3rd, recovery of property, cash, or any other assets of the company, including benefits derived therefrom. 4th one, revive of audit reports and accounts of the company. 5th one, sale of assets. 6th, finalization of list of creditors and contributories. 7. Compromise, abandonment, and settlement of claims. 8. Payment of dividends, if any. And 9. Any other functions as the tribunal may direct from time to time. The company liquidator shall place before the tribunal a monthly report along with the minutes of the meetings of the committee. The report is to be signed by the members present in the meeting for its consideration. This process to be continued till the final report of dissolution of the company is submitted before the tribunal. Now, the general powers and duties of company liquidator. Section 290 of the Act confers very wide powers on company liquidator in order to enable him to wind up the company's affairs. However, these powers are to be exercised subject to the directions of the tribunal. The company liquidator shall have the following powers: A. To carry on business of the company so far as may be necessary for the beneficial winding up of the company. B. To do all acts and to execute in the name and on behalf of the company all deeds, receipts, and other documents, and for that purpose to use company's seal. C. To sell the immovable and movable property and actionable claims of the company by public auction or private contracts with power to transfer such property to any person or to sell the same in parcels. D. to sell the whole of the undertaking as a going concern. E. To raise any money required on the security of the assets of the company. F. To institute or defend any suit, prosecution, or other legal proceeding, civil or criminal, in the name and on behalf of the company. G. To invite and settle claim of creditors, employees, or any other claimant and distribute sale proceeds in accordance with the priorities established under the Act. Now, H. To take all such actions, steps, or to sign, execute, and verify any paper, deed, document, application, petition, affidavit, bond, or instrument as may be necessary. Necessary for 1. Winding up of company, 2. Distribution of assets, and 3. For discharging his duties and obligation and functions as company liquidator. He can apply to the tribunal for necessary orders or directions for the winding up of the company. The exercise of powers by the company liquidator shall be subject to the overall control of the tribunal. Now, duty to apply for dissolution of the company. When the affairs of the company have been completely wound up, the company liquidator shall make an application to the tribunal for dissolution of such company. Then the tribunal can make an order that the company be dissolved from the date of order, and the company shall be dissolved accordingly. A copy of the order shall, within 30 days, be forwarded by the company liquidator to registrar. The registrar shall record the register relating to the company a minute of the dissolution of the company. If the company liquidator makes a default in forwarding a copy of the order to the registrar within the period of 30 days from the date of the order, he shall be punishable with fine which may extend to 5,000 rupees for every day during which the default continues. So that is with compulsory winding up and the winding up process and the company liquidator and his duties and powers, etc. Now we'll be looking into voluntary winding up. So section 304 to 365 deals with voluntary winding up of companies. Voluntary winding up means winding up of the company on the basis of a simple resolution or a special resolution passed by the shareholders in a general meeting. A company may voluntarily be wound up on the basis of a simple resolution passed in the general meeting of its members under the following circumstances. 1. If the period of duration fixed by the articles has expired. 2. Where the articles provides that on the happening of any event, the company is to be dissolved and the event is occurred. So, only under these two conditions, the company can be simple resolution passed in general meeting can be used to wind up a company. So, that is two situation is the period of duration fixed by the articles has expired, or the articles provide that on the happening of any event, the company is to be dissolved and the event has occurred. Now, a company can also be dissolved without assigning any reason. If the company in its general meeting passes a special resolution to wind up the company voluntarily. So, if it's a special resolution, it does not need to assign any reason for the winding up. Now, declaration of solvency. If it is proposed to wind up a company voluntarily, the director or directors, or in case the company has more than 2 directors, the majority of the directors shall at the meeting of the board make a declaration verified by an affidavit to the effect that 1. They have made full enquiry into the affairs of the company. 2. They have formed an opinion that the company has no debt or the debt of the company can be paid in full form the proceeds of assets sold in voluntary winding up. A voluntary winding up is possible only when the company is solvent and is able to pay its liabilities in full. So, a voluntary winding up is possible only when the company is solvent and is able to pay its liabilities in full. A declaration will be valid only if 1. It is made within 5 weeks immediately preceding the date of the passing of the resolution for winding up of the company, and it is delivered to the registrar for registration before that date. 2. It should contain a declaration that the company is not being wound up to defraud any person or persons. 3. It should be accompanied by a copy of the report of the auditors of the company on the profit and loss account, balance sheet, and statement of the assets and liabilities of the company on that date. 4. It is to be accompanied by a report of the valuation of the asset of the company prepared by a registered valuer. So the first condition was it is made within 5 weeks immediately preceding the date of the passing of resolution for winding up of the company. Okay, now if the company is wound up in pursuance of a resolution passed within a period of 5 weeks after making the declaration, if the company is wound up in pursuance of a resolution passed within a period of 5 weeks after making the declaration and its debts are not paid in full, it shall be presumed until contrary is shown that the director or directors did not have reasonable grounds for his or their opinion. The director or directors responsible for making such declaration shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine which shall not be less than 50,000 rupees, but which may extend to 3 lakh rupees, or with both. Now, meeting of creditors. The company shall, along with the calling of meeting of the company members at which the resolution for a voluntary winding up to be proposed, convene a meeting of its creditors either on the same day or on the next day. So, company shall, along with the calling of meeting of the company at which the resolution for voluntary winding up to be proposed, convene a meeting of its creditors either on the same day or on the next day. The notice of the meeting should be sent to the creditors by registered post. In the creditors meeting, the board of directors shall cause to present a full statement of the position of the affairs of the company, together with a list of creditors of the company, copy of the declaration of solvency, and estimated amount of the claims. One of the directors is to preside at the creditors meeting. If 2/3 in value of creditors of the company are of the opinion that it is in the interest of all the parties that the company be wound up voluntarily, the company shall be wound voluntarily. If 2/3 in value of creditors of the company are of the opinion that it is in the interest of all parties that the company be wound up voluntarily, then the company shall be wound up voluntarily. If 2/3 in the value of creditors of the company are of the opinion that the company may not be able to pay for its debts in full and pass a resolution that it shall be in the interest of all parties that the company is to be wound up by the tribunal, then the company shall within 14 days thereafter file an application to the tribunal for winding up. Now, next one is publication of resolution to wind up voluntarily. If a company has passed a resolution for voluntary winding up and a resolution of creditors agreeing for voluntary winding up, it shall within 14 days of the passing of the resolution give notice of the resolution by advertisement in official gazette and also in a newspaper which is in the circulation in the district where the registered office of the company is situated. The next is effect of voluntary winding up. A voluntary winding up shall be deemed to have commenced on the date of special resolution passed in the members' meeting. The company shall cease to carry on its business. However, the corporate state and corporate powers of the company shall continue until it is dissolved. The next is appointment of company liquidator. The company in its general meeting where a resolution of voluntary winding up is passed shall appoint a company liquidator from the panel prepared by the central government for the purpose of winding up its affairs and distributing the asset of the company and recommend the fee to be paid by the company liquidator. The creditors in their meeting have to approve the appointment. If they do not approve, they can appoint another person as company liquidator and fix the fee of the company liquidator. The company shall give notice to the registrar of the appointment of the company liquidator along with the name and particulars of the company liquidator. On the appointment of a company liquidator, all the powers of the board of directors, managing directors, and manager shall cease except for the purpose of giving notice of appointment to the registrar. Now, functions of company liquidator in voluntary winding up. In the case of voluntary winding up, the company liquidator shall settle the list of contributories, which shall be prima facie evidence of the liabilities of the persons named therein to the contributories. He can call general meeting of the members for the purpose of obtaining the sanction of the company for any purpose that he may consider necessary. He shall maintain regular and proper books of account, and the members and creditors and any officer authorized by the central government may inspect such books and account. He shall prepare quarterly statement of accounts and file such statement of account duly audited within 30 days from the close of each quarter with the registrar. He shall pay the debts of the company and shall adjust the rights of the contribution among themselves. As soon as the affairs of the company are fully wound up, the company liquidator shall prepare a report of winding up showing that the property and asset of the company have been disposed of and its debts fully discharged, and thereafter call a general meeting of the members and submit the report of their consideration. For their consideration. If the majority of the members, after considering the report, are satisfied that the company is to be dissolved, they may pass a resolution for its dissolution. Within 2 weeks, the company liquidator shall send the registrar a copy of the final winding up accounts, copies of resolutions passed in the meeting. He has to file an application along with his report before the tribunal for passing an order of dissolution of the company. If the tribunal is satisfied after considering the report of the company liquidator that the process of winding up has been just and fair, the tribunal shall pass an order dissolving the company within 60 days of the receipt of the application. The company liquidator shall file a copy of the order with the registrar within 30 days. The registrar shall forthwith publish a notice in the official gazette that the company is dissolved. That is with winding up. Winding up is discussed from two so we have two modes of winding up, that is compulsory winding up or voluntary winding up. Compulsory winding up is also called winding up by tribunal. Winding up is discussed from sections 270 to 365, that is chapter 20. 270 to 303 and 324 to 365 deals with winding up by the tribunal. Now voluntary winding up is discussed in 304 to 365. Here we looked into the powers and functions of National Company Law Tribunal, the interim administrator, the company liquidator, the provisional liquidator, the powers and duties of the company liquidator, and the role of the registrar. And in case of the compulsory winding up, we also looked into who all can apply for a winding up to the tribunal, which included and the grounds on which it can be applied for. And we also discussed few case laws in compulsory winding up regarding what is just and equitable. So we also read the exceptions of just and equitable. We discussed about the giving of reasonable opportunity for the company to be heard, and we also discussed about sick company. So that is with winding up of the company. Contributors. The next topic is contributors. The past and present shareholders who are liable to pay towards the capital of the company at the time of winding up of company are called contributors. Those shareholders who are holding fully paid up shares are also called contributors. The liquidator has to prepare list of contributors. It is to be prepared in two parts. List A contains the names of the present members and list B contains the names of the past members. Contributories in list A are liable to pay the unpaid balance in the respect of the shares holding by them. If a shareholder is holding fully paid shares and the liability is limited by shares, he shall not be liable to contribute at the time of winding up. If a shareholder is holding partly paid shares, he has to contribute the balance amount in the respect of those shares. The liability to make payment arises only when the tribunal makes an order to pay the balance amount. Please note the liability to make payments arises only when the tribunal makes an order to pay the balance amount. Past members are also liable as contributories. However, if he has ceased to be a member for 1 year or upwards before the commencement of the winding up, he is not liable as contributory. So, also, if the present member is capable to pay the balance, the past member is not liable to pay the unpaid balance. The past member becomes liable only on the default of the present member. That is with contributories. The next topic is dormant company or inactive company or defunct company. Section 455 of Companies Act 2013 deals with inactive companies and dormant companies. Inactive companies means a company which 1. has not been carrying on any business or operation, or 2. has not made any significant accounting transaction during the last 2 financial years, or 3. has not filed financial statement and annual returns during the last 2 financial years. So, what is significant accounting transaction? It means a transaction other than A. Payment of fees by a company to the registrar, B. Payment made by it to fulfill the requirements of the Act or any other law, C. Allotment of shares to fulfill the requirements of this Act, and D. Payments for maintenance of its office and records. So, except for these four, all other come under significant accounting transaction. If a company is formed and registered under the Act for a future project or to hold an asset or intellectual property and has not made any significant accounting transaction, such a company or an inactive company may make an application to the registrar for obtaining the status of a dormant company. The registrar, on consideration of the application, allow the status of a dormant company and issue a certificate to that effect. The registrar shall maintain a register of dormant companies. If a company fails to file financial statement or annual returns for 2 consecutive years, the registrar shall issue a notice to the company and enter the name of such company in the register maintained for dormant companies. A dormant company shall have minimum number of directors. If it has to pay the prescribed annual fee to the registrar to retain the dormant status. After filing an application and paying prescribed fee, it can become an active company. The name of the dormant company which fails to comply with the provisions of section 455 will be struck off from the register of dormant companies. Then we have defunct companies. This was discussed in Companies Act 1956. Not this was discussed in Companies Act 1956, Section 560. A defunct company means a company which is not carrying on any business or which is not in operation. The name of a defunct company could be struck off the register of the companies by registrar. The following formalities were to be satisfied by striking of the name of the company. 1. If the registrar had reasonable cause to believe that the company was not carrying on business or in operation, he had to send a notice to the company inquiring whether the company was still in operation or not. 2. If the registrar did not receive any answer to such notice within 1 month, the registrar had to send the company a letter by registered post stating that if no answer was received to the second letter within 1 month, a notice would be published in the official gazette with a view to striking of the name of the company from the register. Third, if the registrar did not receive any answer to the second notice, he was to publish in the official gazette a notice that at the expiration of 3 months from the date of the notice, the name of the company would be struck off the register and the company would be dissolved. A notice had also to be given to the company. At the expiry of 3 months from the date of notice, the registrar had to strike the company's name off the register and to publish a notice in the official gazette. On the publication in the official gazette of this notice, the company stood dissolved. The company or any other member of the company or creditor of the company could, within 20 years, apply to the National Company Law Tribunal to pass an order restoring the name of the company. The tribunal found that if the tribunal found that the company was actually carrying on business or it is otherwise just to do so, the tribunal could order to restore the name of the company to the registrar. That is with inactive or dormant or defunct company. The next topic is National Company Law Tribunal (NCLT) and the National Company Law Appellate Tribunal, that is NCLAT. So the National Company Law Tribunal. Section 408, that is Section 408 of the Companies Act 2013, empowers the central government to constitute the National Company Law Tribunal. The function of National Company Law Tribunal is to exercise the powers and discharge the functions as may be conferred on it under the Act. The NCLT, that is National Company Law Tribunal, is to consist of a president and such number of judicial and technical members. The president shall be a person who is or who has been a judge of a high court for 5 years. The president shall be appointed after consultation with the CJI, that is Chief Justice of India. A person shall not be qualified for appointment as a judicial member unless he A. is or has been a judge of high court, B. is or has been a district judge for at least 5 years, or C. has for at least 10 years been an advocate of a court. So, to be a judicial member, he is or has been a judge of high court or a district judge for at least 5 years or an advocate for a minimum of 10 years. So that is the minimum qualification to be a judicial member. So the NCLT tribunal will have president and such number of judicial technical members. The judicial member shall be a judge who is or has been a judge of high court or a district judge for at least 5 years or an advocate of any court for at least 10 years. Now, chartered accountants, cost accountants, company secretaries, etc. are eligible to be appointed as technical members. The judicial and technical members are to be appointed on the recommendation of a selection committee. The power of the National Law Tribunal may be exercised by the benches. Then the number of benches may be specified by the central government. The principal bench of the tribunal shall be at New Delhi, which shall be presided over by the president of the tribunal. The powers of the tribunal shall be exercisable by benches consisting of 2 members, out of whom one shall be a judicial member and the other shall be a technical member. The president shall, for the disposal of any case relating to the rehabilitation, restructuring or reviving of companies, constitute 1 or more special benches consisting of 3 or more members with majority of judicial members. If the members of a bench differ in opinion on any point or points, it shall be decided according to the majority, if there is a majority. If the members are equally divided, they shall state the point or points on which they differ, and the case shall be referred to the president for hearing on such point or points by 1 or more of the other members of the tribunal, and such point or points shall be decided according to the opinions of the majority of members who have heard the case, including those who first heard it. Any person aggrieved by an order of the tribunal may prefer an appeal to the appellate tribunal. No appeal shall lie to the appellate tribunal from an order made by the consent of the parties. Every appeal shall be filed with a within a period of 45 days from the date of which a copy of the order of the tribunal is made available to the person aggrieved. The appellate tribunal may entertain an appeal after the expiry of the set period of 45 days, but within a further period not exceeding 45 days. That is a total of 90 days. If it is satisfied that the appellant was prevented by sufficient cause for filing the appeal within the set period. On the receipt for an appeal, the appellate tribunal shall, after giving the parties a reasonable opportunity of being heard, pass such orders thereon as it thinks fit. It can confirm, modify, or set aside the order of the tribunal. The appellate tribunal shall send a copy of every order made by it to the tribunal and the parties to appeal. Now, the National Company Law Appellate Tribunal. Section 410 of the Companies Act 2013 provides for the establishment of National Company Law Appellate Tribunal. So, the National Company Law Tribunal was dealt by Section 408, and National Company Law Appellate Tribunal is dealt by Section 410. The main section of the National Company Law Appellate Tribunal is to hear the appeals from the orders of National Company Law Tribunal. The National Company Law Appellate Tribunal shall consist of a chairperson, judicial members, and technical members. The chairperson and judicial members are appointed by the central government after the consultation with the CJI, that is Chief Justice of India. The chairperson shall be a person who has been a judge of the Supreme Court or the Chief Justice of a High Court. A judicial member shall be a person who is or has been a judge of a High Court or a judicial member of the National Company Law Tribunal for 5 years. A technical member of National Company Law Appellate Tribunal shall be a person of ability, integrity, and standing, having special knowledge and professional experience of not less than 25 years in science, technology, economics, banking, industry, law, or matters relating to labor, industrial finance, or any other matter. The technical members of the appellate tribunal shall be appointed on the recommendation of the selection committee. An appeal against any decision or order of the National Company Law Appellate Tribunal shall lie to the Supreme Court of India on any question of law arising out of the order. The appeal is to be preferred within 60 days from the date of receipt of the order of the appellate tribunal. The Supreme Court may condone any delay in filing appeal if there is sufficient cause for the delay. However, the delay should not exceed 60 days. So, we have come to the last topic in this against us not on company law, that is removal of names of companies from register of companies. So, the power of registrar. By section 248 subclause 1 of the Companies Act 2013, the registrar has reasonable cause to believe that a company has failed to commence its business within 1 year of its incorporation, or b, the subscribers to the memorandum has not paid the subscription which they had undertaken to pay within a period of 180 days from the date of incorporation, and a declaration by a director is not filed within 180 days of its incorporation, or a company is not carrying on any business or operation for a period of 2 immediately preceding financial years and has not made any application within such period for obtaining the status of a dormant company. He shall, that is the registrar shall, send a notice to the company and all the directors of the company of his intention to remove the name of the company from the register of companies and requesting them to send their representations along with the relevant documents within a period of 30 days from the date of the notice. The notice shall be published in the official gazette. At the expiry of the time mentioned in the notice, the registrar may, if no explanation is given by the company against the proposed action, strike off the company's name from the register of companies, and publish notice thereof in the official gazette. On the publication of this notice in the gazette, the company shall stand dissolved. Now, any person aggrieved by an order of the registrar notifying a company as dissolved may file an appeal to the tribunal within a period of 3 years from the date of order. If the tribunal is of the opinion that the removal of the name of the company from the registrar is not justified, it may order restoration of the name of the company in the register of companies. So that is with the removal of name of companies from the register of companies. And that is the end of the AKN's note on company law.